6239. Is there a motion? Moved by Representative Turco. Is there a second? Yeah, I said that. Second. Okay. Seconded by Representative Luxembourg. Is there a discussion on this bill?
Mr. Chair, I'm sorry. I apologize. I know I'm speaking too much today, but I'm uncertain on the Attorney General's recommendations regarding social media. Actually, we have a lot of bills here today to talk about expanding the Attorney General's powers, so to speak. How is this planned on being implemented relative to this? And is this still another one of those works in progress kind of things?
Thank you. There are some constitutional aspects of this conversation that will continue post
Right.
leaving this committee. There's a case that's being adjudicated that directly touches some of this based upon a court case that was brought in Texas. The Attorney General's office feels confident that the structure of the bill before us will pass constitutional merit, and they're prepared to defend it with the modifications that have been made.
And how are we going to enforce this?
Through the AG's general powers. Right. Traditional CUPTA violations provide the basis for how the AG anticipates defending against any.
I will not disturb this going on to consent, but I am concerned about what we're doing here relative to a number of these different items, and would like to have more conversation about this. I did speak against some of the Attorney Generals. He's in so many committees this time frame. I'm not certain it was here. And so I am worried that we are doing some First Amendment kind of violations, some other things that is an overreach. I find myself considering that more and more. So.
Understood. To be clear, while there are a series of recommendations from the Attorney General on today's agenda, the only one that's being raised for potential consent is this HB 6857, LCO 6239, which does, I understand, impact what some would say were First Amendment rights to publish via social media applications, but does not touch on a number of the other issues that the Attorney General brought to our committee, which would be held in a different bill. So it's just this, simply this one is with respect to social media and minors, not the broader list of issues that the Attorney General brought to this committee. Are there any other comments on this issue? Seeing none, Representative Ritigliano.
Mr. Chairman, I'd like to make a motion to add this to the consent calendar.
Motion has been made to add 6857, LCO 6239 to the consent agenda. Is there a second? Seconded by Representative Martinez. Is there any objection to adding this to the consent calendar? Seeing none, item number 7, 6857, LCO 6239 has been added to the consent calendar. Moving on to item number 9 on today's agenda, HB 7020. Do I hear a motion? Moved by Representative Ritigliano, seconded by Senator Maroney. Is there any discussion? Seeing none?
Seeing none, Mr. Chairman, I'd like to add, offer HB 7020 to the consent calendar.
Is there a second to adding this to the consent calendar? Seconded by Senator Maroney. Is there any objection to adding HB 7020 to the consent calendar? Seeing none, HB 7020 is added to the consent calendar. Moving on to item number 10 on today's agenda, Senate Bill 611. JF to the floor.
So moved.
Moved by Representative Ritigliano. Is there a second?
Second.
Seconded by Senator Maroney. Is there discussion? Senator Austin.
Again, this list of licenses, occupational licenses, is this the list? Is this looking to be a little bit broader than what it is? Are we looking at addressing some of the others that are? One of these would be the certified public accountants. We're about 5 times the national average on that license. Is that what the prior bill does? Is that a licensure issue also?
Sorry.
Thank you for the question, Representative Rutigliano.
So the idea behind this bill, the governor has a bill out there actually eliminating most of the occupational licenses. This bill sort of narrows itself to the things that are the cognizance of the Department of Consumer Protection. So I think there are other industries or occupations that we're looking to lower the license for, but this particular bill just works within the DCP.
So we talked about the public accountants right before this, certified public accountants. Is certified public accountants considered to be within the confines of DCP or within the confines of the General Law Committee?
Thank you. Yes, they are actually regulated by Department of Consumer Protection, and this would be under the cognizance of the General Law Committee, but they're not included in.
Are
Do
they
you-
included in this one? I'm sorry.
Yes, they are included in this one.
So we're considering lowering their license fees to
Yes.
bring them more into the standard of the rest of the United States.
Yes.
Thank you. Appreciate that.
Is there any other discussion on item number 10, SB 611? Seeing none, Representative Rutigliano.
I'd like to offer SB 611 to the consent calendar.
Is there a second for item number 10, SB 611 being added to the consent calendar? Seconded by Senator Kissel. Is there objection to adding this to the consent calendar? Seeing no objection, item number 10, SB 611 is added to consent. We're going to hold item number 11 today. Moving on to item number 12, SB 1238. I would hear a motion to JF to the floor.
So moved.
Moved by Representative Rutigliano. Is there a second?
Second.
Seconded by Senator Maroney. Is there discussion? This is, again, minor legislative recommendations, minor technical revisions. Senator Austin.
Last year, we did minor technical revisions for that the DCP asked for. One of those minor technical correct things was done relative to the boxes for naloxone and other things, and created an atmosphere which required removal of some of the boxes relative to naloxone dispersal. Does this correct that problem that we had last year?
Thank you for the question, Madam Senator. No, this is not a DCP minor and technical. This is just our LCO's minor and technical, which is like, yeah, commas and periods, and absolutely no policy is inherent in this item. Those modifications that you're looking for will be in a subsequent bill with respect to DCP, not in LCO.
Thank you.
Are there any other questions with respect to item number 12? Seeing none, Representative Rutigliano.
Mr. Chairman, I'd like to offer SB 1238 to the consent calendar.
Is there a second to move this item to the consent calendar? Seconded by Senator Maroney. Objection to adding this item to the consent calendar. Seeing no objection, item number 12, SB 1238, JF to the floor, has been added to the consent agenda. Moving on to item number 14, SB 1294. I'd accept a motion to JF to the floor.
So moved.
Moved by Representative Tagliano, seconded by Senator Ciccarella. Is there any discussion on this item? Seeing none, Representative Rutigliano.
Mr. Chairman, I'd like to offer SB 1294 to the consent calendar.
Is there a second?
Second.
Seconded by Senator Maroney. Is there any objection to moving item number 14, SB 1294, to the floor? Seeing no objection to the, sorry, did JF add to the consent calendar? Is there any objection to adding this to the consent calendar? Seeing no objection, we move SB 1294 to consent. Madam Clerk, could we call the consent?
All right, a motion has been made to approve a consent calendar. It includes item number 2, HB number 5271, an act prohibiting gaming-related advertising, marketing, and promotional activities at public institutions of higher education. JF to the floor. Item number 3, HB number 5361, an act concerning the source of the fruit used by fine winery permittees to manufacture wine. JF to the floor. Item number 4, HB number 5425, an act concerning heritage railways and alcoholic liquor. JF to the floor. Item number 5, HB number 5571, an act establishing a maximum restocking fee for returned consumer goods. JFS to the floor, LCO number 6211. Item number 7, HB number 6857, an act concerning the Attorney General's recommendations regarding social media and minors, JFS to the floor, LCO number 6239. Item number 9, HB 7020, an act concerning certified public accountants, JF to the floor. Item number 10, SB 611, an act establishing a maximum charge for certain occupational licenses, certifications, permits, and registrations, JF to the floor. Item number 12, SB 1238, an act concerning the Legislative Commissioner's recommendations for minor and technical revisions to statutes concerning consumer protection, JF to the floor. And item number 14, SB number 1294, an act concerning the manner in which persons engaged in making home improvements make certain disclosures, JF to the floor. Senator Maroney,
Yes.
Representative Lamar,
Yes.
Senator from Farah, Representative Turco,
Yes.
Senator Ciccarella,
Yes.
Representative Retigliano,
Yes.
Representative Ackert,
Yes.
Representative Ali Brennan, Representative Aniskovic, Representative Candelaria, Senator Gadkar Wilcox,
Senator Geiger Wilcox, yes.
Representative Gibson, Representative Jensen,
Yes.
Senator Kissel, Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg,
Luxembourg votes yes.
Representative Martinez,
Representative Martinez votes yes.
Representative Osborne,
Representative Osborne votes yes.
Senator Austin,
Senator Austin votes in the affirmative.
Representative Paolillo,
Yes.
Representative Santos,
Representative Santos votes yes.
Representative Yacarino.
Yes.
All right, thank you, Mr. Chair.
Thank you, Madam Clerk. Right, going back to the beginning of our agenda, we have 7 minutes. We have some understanding that a number of these items still on our agenda don't require a great deal of discussion, but there will likely be some no votes. So we're going to start with item number 1 on today's agenda, which is HB 5112, joint favorable to the Environment Committee. Moved by Representative Retigliano. Is there a second? Seconded by Representative Turco. For purposes of discussion, we're going to turn this over to Representative Turco.
Thank you, Mr. Chairman. I think this committee heard a lot of testimony about the potential consumer issues with purchasing dogs from out-of-state breeding facilities in our pet stores here. So we're trying to protect the consumers, but since this issue really has cognizance in the Environment Committee, we're proposing to JF the bill out of general law today to show that this committee supports protecting our constituents and consumers from the sale of these out-of-state pets, which may be unregulated, and allow the Environment Committee, who has cognizance over these stores and the regulation of these stores, to decide what to do from the issue from here. Thank you, Mr. Chairman.
Thank you, Representative Turco. Is there any further discussion on the bill? Representative Acker.
Thank you, and thank you for the good explanation of the bill. Was there and I get it, we want to protect our consumers, but was there a economic impact study done on what this would cost the businesses in the state of Connecticut? And that's what I heard a lot about on the other side of that. Representative, do you have that, or through the chairs?
I'll handle that. No, there was not an economic impact study conducted in relationship to this bill. It is a concept that has been in the legislature for a number of years of how to best regulate the industry to ensure that we're not inadvertently supporting puppy mills across the country. We feel like we've got a very narrow purview in this committee with respect to the Department of Consumer Protection. The bulk of this conversation does need to happen in an environment generally. So in the very narrow application here, we thought it was appropriate for us to joint favorable this to the Environment Committee. Are there any other questions with respect to this bill? Seeing none, Madam Clerk, can you please call the roll?
All right, a motion has been made to JF to Environment, HB 5112, an act prohibiting pet stores from purchasing or procuring dogs, cats, and rabbits. Senator Maroney,
Yes.
Representative Lamar,
Yes.
Senator from Farah, Representative Turco,
Yes.
Senator Ciccarella,
No.
Representative Vertigliano,
Yes.
Representative Ackert, Representative Ali Brennan, Representative Yanukovych, Representative Candelaria, Senator Gadkar Wilcox,
Senator Gadkar Wilcox is yes.
Representative Gibson, Representative Jensen,
No.
Senator Kissel, Senator Lopes,
Senator Lopes votes no. I mean, yes.
Representative Luxembourg,
Luxembourg votes yes.
Representative Martinez,
Representative Martinez votes yes.
Representative Osborne,
Osborne votes yes.
Senator Austin,
One hot potato over to environment. Senator Austin votes in the affirmative.
Representative Paolillo,
Yes.
Representative Santos,
Yes.
Representative Yacarino.
No.
Okay, thank you, Mr. Chair.
Thank you. I thought I saw someone raise their hand online.
Oh.
I think, okay, moving on. I'm going to play. We're going to take up 15. So what item is this? All right, we're going to move on to item number 6, HB 6856, JFS to the floor of LCO 6238. Do I hear a motion?
So moved.
Moved by Senator Maroney. Is there a second? Seconded by Representative Vertigliano. Any discussion? Seeing none. Madam Clerk, can you please call the roll?
Okay, a motion has been made to JFS to the floor, HB 6856, an act concerning the Attorney General's recommendations regarding abnormal economic disruptions, precipitating events, and consumer product disclosures, LCO number 6238. Senator Maroney,
Yes.
Representative Lamar,
Yes.
Senator from Farah, Representative Turco,
Yes.
Senator Ciccarella,
No.
Representative Vertigliano,
No.
Representative Ackert, Representative Ali Brennan, Representative Yanukovych, Representative Candelaria, Senator Gadkar Wilcox,
Senator Gadkar Wilcox is yes.
Representative Gibson, Representative Jensen,
No.
Senator Kissel, Senator Lopes,
Senator Lopes votes yes.
Representative Luxembourg,
Luxembourg, yes.
Representative Martinez,
Representative Martinez votes yes.
Representative Osborne,
Osborne, yes.
Senator Austin,
Senator Austin votes in the affirmative.
Representative Paolillo,
Yes.
Representative Santos,
Yes.
Representative Yacarino.
No.
All right, thank you, Mr. Chair.
Thank you, Madam Clerk. Moving on to HB number 8, HB 6858. I hear a motion to JFS to the floor, LCO number 6244. Do I hear a motion?
So moved.
Moved by Senator Maroney. Is there a second? Seconded by Representative Turco.
Just
Discussion, Representative Vertigliano.
really quick, Mr. Chairman, there are some no votes on the last few remaining bills, mostly just a flag. It doesn't mean that we won't end up supporting the bill. That just we have recognized some issues within the bill that we think needs to be addressed, and we didn't want it to be unanimous out of committee.
Thank you, Representative Tigliano. That's an important conversation to have. The bills on today's agenda are largely items that we've caucused numerous times. We recognize that there are still some concerns with some of the language in the bills, but we've clarified that due to the nature of our working relationship, those issues will be worked out in the next 2.5 months before the close of session. Seeing no further discussion, Madam Clerk, can you call item number 8, HB 6858, LCO 6244, JFS to the floor?
Okay, a motion has been made to JFS to the floor, LCO number 6244, HB 6858, an act concerning the Attorney General's recommendations regarding tickets, veteran or military benefit services, the State Code of Ethics, Umbilical Cord Blood, and the Solicitation of Charitable Funds Act. Senator Maroney. Representative Lamar.
Yes.
Senator from Farah. Representative Turco.
Yes.
Senator Ciccarella.
No.
Representative Retigliano.
No.
Representative Ackert. Representative Ali Brennan. Representative Aniskovich. Representative Candelaria. Senator Gadkar Wilcox.
Senator Gadkar Wilcox is yes.
Representative Gibson. Representative Jensen.
No.
Senator Kissel. Senator Lopes.
Senator Lopes votes yes.
Representative Luxembourg.
Yes.
Representative Martinez.
Representative Martinez votes yes.
Representative Osborne.
Osborne votes yes.
Senator Austin.
Senator Austin votes in the negative.
Representative Paolillo.
Yes.
Representative Santos.
Representative Santos votes yes.
Representative Yacarino.
Yacarino, no.
Okay, thank you, Mr. Chair.
Thank you, Madam Clerk. We have one item left on today's agenda before our public hearing begins. Again, we're holding item number 11, SB 1236. I accept a motion to hear item number 13, SB 1248. Motion would be to JF to the floor. Do I hear that motion?
So moved.
Moved by Senator Maroney. Is there a second? Seconded by Representative Luxembourg. Is there discussion? I think the preceding discussion solved the issue. Seeing no need for discussion, Madam Clerk.
Okay, a motion has been made to JF to the floor, SB 1248, an act expanding consumer protections. Senator Maroney. Representative Lamar. Senator from Farah. Representative Turco.
Yes.
Senator Ciccarella.
No.
Representative Retigliano.
No.
Representative Ackert. Representative Ali Brennan. Representative Aniskovich. Representative Candelaria. Senator Gadkar Wilcox.
Senator Gadkar Wilcox is yes.
Representative Gibson. Representative Jensen.
No.
Senator Kissel. Senator Lopes.
Senator Lopes votes yes.
Representative Luxembourg.
Yes.
Representative Martinez.
Representative Martinez votes yes.
Representative Osborne.
Osborne, yes.
Senator Austin.
Senator Austin votes in the affirmative.
Representative Paolillo.
Yes.
Representative Santos.
Santos votes yes.
Representative Yacarino.
Yacarino's no.
Thank you, Mr. Chair.
Thank you, Madam Clerk. Well done, everybody. We will recess this committee meeting to the close of the public hearing, in which we will reconvene the committee meeting for purposes of ensuring all members have had a chance to vote. We'll reconvene that meeting. At the close of the public hearing, we'll reconvene the meeting for 1 hour to ensure that all of our members have had a chance to vote. With that, Madam Clerk, we stand in recess. Moving on, we now begin our public hearing on.
Mr. Chair, I have
Yes.
to reset the technology. It's going to take me a minute here.
We're going to need it. We're going to take about 4 minutes to reset our Zoom meetings and begin our public hearing in about 4 minutes time. Thank you all. We'll see you very shortly.
You have good chairman skill. To the old school. I love it. Very efficient.
How many items are on today?
It's a lot of gaming items.
I'll be back on after
Yeah.
the meeting.
Volume is still on. Volume is still on the webinar.
Good morning, everyone. Welcome to the second part of today's general law agenda. We're going to kick off our public hearing portion of today. We've got a number of bills on today's public hearing agenda, 8 of them to be exact. We've got about 40 people signed up to speak today. We want to make sure we accommodate time for everyone. We'll be starting off with the first hour, which will be 45 minutes, which will be dedicated towards public officials who are signed up and prepared to speak. First on the agenda today is Senator Looney and Senator Duff. They are stuck in another meeting at this moment. So if Representative Linehan is available, we'll lead off with her. After Representative Linehan, we'll also have Tony Scott, or Representative Scott, who's signed up to speak. All right, so we'll start with Representative Linehan, move on to Representative Scott.
Thank you very much, Representative Lamont.
Good to see you this morning.
It's great to see you. Great to see you, Senator Maroney, and esteemed members of the committee. I'm grateful for the opportunity to testify on House Bill 6052, an act concerning the Home Solicitation Sales Act and residential solar photovoltaic systems. I hope I can say that 10 times fast at some point. The legislation, dubbed the Do Not Knock Bill, is a much needed safety check for door-to-door sales in an age where it's become increasingly more dangerous for homeowners than the days of the friendly Electrolux salesman of the 1950s. Nationwide, consumers reported losing more than $12.5 billion to fraud in 2024, which was a 25% increase compared to the year prior. Door-to-door scams are a subcategory known as imposter scams, with people showing up at doorsteps claiming to be utility workers, home improvement companies, pavers, landscapers, charitable organizations, solar companies, and more. In 2023, Connecticut fielded 15,000 scam contractor complaints and has recovered $700,000 in stolen consumer funds. Most often targeting elderly residents, these fraud scams turn into dangerous break-ins whereby one scammer keeps a person talking at the front doorstep while an accomplice enters through the back and robs the homeowner of cash and jewelry. Here in Connecticut, police departments in Middletown, Hamden, New Haven, and Stamford all issued official warnings to residents, and Eversource and the Better Business Bureau put out statewide warnings of these door-to-door scams. Our own state government did as well, with Attorney General Tong crisscrossing the state, warning senior citizens of these scams, and my office even created a book for constituents entitled How Not to Get Scammed. This is why a do not knock list is needed. The bill will protect consumers by doing the following. It creates the do not knock database, which requires companies who use door-to-door sales to run their contact list against the do not knock registry. It requires the company to sign an attestation 7 days prior to entering a town, stating that they have, to the best of their ability, removed anyone from that list from their contact plan. They must specify safety information to be shared with the public, as in the uniforms they wear, badges, hours of operation, and company phone number for residents to call to determine if someone at their door is indeed legitimately with the company. That attestation must be sent to the municipality, and that municipality must post notice on their website or social media page which companies have notified the town that they will be knocking, the dates and hours, the aforementioned safety information, and a local phone number to report noncompliance. And it prohibits anyone with a violent criminal record from doing door-to-door sales. In addition, I'd like to see final language added which would allow local municipalities to levy fines against any company found not in compliance, as well as clear language that this applies to any cold call home solicitation and not just solar companies. I understand that there may be a comparison to the National Do Not Call Registry and its efficacy or non-efficacy, if it will. However, these two are substantially different. I'm happy to answer any questions about how and go into detail for members of the committee if you wish, but my written testimony does go into that detail. The Do Not Knock list will empower consumers and weed out fraudsters from legitimate salespeople while keeping our residents safe. Thank you again for this opportunity to testify, and I look forward to working with the committee to help secure passage of this bill. Thank you so much.
Thank you, Representative Linehan, and I do appreciate, for purposes of brevity, not going over some of the distinctions between the do not call list and the do not knock list, but I do think that how many people are thinking about a do not knock list necessarily portends a comparison between the two. So if you wouldn't mind, I think for the purposes of exploration, highlighting those distinctions would be beneficial to the committee.
Absolutely. Thank you so much. So the National Do Not Call list was put forward years ago, and anyone who is continuously receiving their spam calls will know it really doesn't work. But the reason it doesn't work is there's actually many of them. The first is their phone numbers. It's very difficult to find out where these phone numbers are coming from. They're often out of country. They are spoofed numbers. It's hard to catch them in the act. Secondly, the do not call list is actually one centralized place that is supposed to issue these fines for all 50 states. That just simply doesn't work. It's hard to keep up with that. This do not knock list, with the addition of adding the ability for municipalities to levy their own fines via ordinance, actually puts the onus on municipalities to determine if someone has not been in compliance with this law. And in fact, with the addition of Ring doorbells and cell phones and other ways that we record people at their door, there is proof that someone has actually violated this law and can in fact be issued a fine based on that. So the combination of putting the onus on municipalities, in addition to having it simply be easier to prove as someone is at your door rather than a spoofed phone call or someone out of country, simply just sets it apart from the do not call list.
Thank you. And I think that was an important clarification and helps people understand how this could yield a greater level of compliance than the traditional do not call list has unfortunately experienced. Are there any other questions for Representative Linehan? Senator Ciccarella.
Thank you. And thank you for testifying on the bill before us. Solid piece of legislation, makes sense. There's, I guess, a lot of good to this, right? I get people all the time either knocking at my door or constituents telling me, what can we do about this? Because, it's one thing they get a knock and then they leave, but some people stay there for a while. And no matter what you say, they're going to keep trying to sell you a product. I think we have some solar guys in here. I think some of your guys might be guilty of that. Where are they? A couple other good things that come from this as well. You'll see people walking down the street and a concerned resident may call. And if the officer or the dispatcher knows that they're registered, and they'll say, listen, we know they're there. It's not going to take the officers off the street to investigate something that's clearly innocent. And if they're not aware, maybe there is some concern. So I think that's really solid for a public safety perspective as well. And one more thing from a public safety perspective, you talked about individuals with violent records.
Mm-hmm.
They won't be able to cold call or go door to door. Is that correct?
Correct.
Okay, awesome. And how would they be able to verify the record? Is there anything in here reviewing it? I'm trying to understand, like the employer has to.
Oh, and as far as hiring someone with a record?
Well, yeah,
that would be on that would be on the employer, that they would need to do that background check to determine. I just want to be very clear when I state that we also have the law here in the state of Connecticut that if you are free from certain crimes after 10 years, that you can actually apply to have that struck from your record. So that clean slate law would apply here too. We are in no way looking to stop anyone who is trying to better their life after having a criminal record from getting a job. But I think it is really important that we ensure that someone with a violent background, armed robbery and such, isn't actually showing up at people's doorsteps. So that's an important part of it. But ultimately, this would be the employer would need to check and ensure that that's the case.
Got it. And if in fact, either one of two options, one, they don't register and the police officers show up because somebody called, is there any type of fine or penalty for the people that are not registering with the police prior to going into the neighborhoods?
So the way the legislation is written right now, it levies, I believe, a $20,000 fine through DCP. I am open to that discussion. I appreciate the drafter who put that in there. And I think that it speaks to how seriously we are taking this issue. I believe that it's more than just the annoyance of someone knocking on the door. It's the fact that people are being scammed out of their money, they're being robbed, and they're actually afraid in their own homes. But if this was something that the committee wished to change, the way I envisioned it was that there would be no direct implication through DCP. Instead, I was looking for language that would allow a municipality to pass an ordinance which would levy a fine, thereby allowing the municipality to kind of take ownership of posting that information, the safety information, having the residents feel comfortable enough to contact them, to check their social media pages and websites to see who is currently in the area going door to door, and then they can pass an ordinance to levy whatever fines that they see fit.
Excellent. I wanted to thank you for testifying, and I think it's a solid idea. I'd like to see it get worked on and get moved to over
Thank
the
you,
finish line.
Senator.
Thank you.
Representative Luxembourg, followed by Representative Turco.
Thank you, Mr. Chair. One thing that comes to mind with your legislation, which I wanted to ask if you've contemplated, is I've often gotten the complaint that because door-to-door salesmanship is unregulated, there is often a scenario where residents see somebody going door to door and they don't know what that person is doing. And the way I see it manifest most egregiously and problematically, it's happened in Manchester, in my district, and I think it happens frequently around the state. And I bet in our political campaigns, which is different protected door-to-door activity, many people on this committee have experienced it, which is that somebody calls in and says that there's a suspicious person going door to door. And what they're really doing is racially profiling somebody. They're seeing a person of color in a predominantly white neighborhood, and they're calling in assuming it's a problem. And I think in our current legal scheme, that scenario is scary for the person who's going door to door and creates unnecessary challenges. I'm wondering if if this bill became law, if that person of color going door to door could say, look, I'm registered with my company. My company's registered to be doing this work. Is that like a benefit of your bill, that it might cut down on some of the racial profiling that exists that makes it very, very scary for people who presumably are just trying to do their job?
Representative Luxembourg, I thank you so much for that question, and it is absolutely part of the reason why this bill is written the way it is. Any of us elected officials who have a local Facebook page, I'm sure is very aware of the posts that go out to say, have you seen this person? They were walking around the neighborhood. You know, who are they? And yes, sir, you are correct. Unfortunately, it does seem to often be surrounding racial profiling. I agree with you that is a problem, and I think that this bill will go a long way to support the safety, not only of residents, but also of those salespeople going door to door. Absolutely. And I think that's why it's important that the information is posted where everyone can see and check.
Thank you. Representative Turco.
Thank you, Mr. Chairman. Thank you, Representative Linehan. I really like the concept of this bill. I know constituents I represent in Newington and New Britain have been frustrated of recent years with the increases of door-to-door salespeople, and I've heard about quite a few scams, home improvement scams and things like that. I'm sorry I walked in the tail end of your testimony. I'm trying to look at your written testimony now. But can you clarify for me which organizations, businesses would be regulated and included in this, and who would be exempt?
Absolutely.
Thank you.
So any business who does door-to-door solicitations. So that could be anything from the solar companies, but also landscapers, pavers. My new favorite business, the Modern Milkman. I love them, but they would be required to do the same. It's really anyone. The people who would be excluded would be anyone who is sharing constitutionally protected free speech. It would be your local Girl Scouts, any community-based organization that is fundraising, your neighborhood school kids who are, your junior football kids who are coming to sell their candy bars, they would be excluded from this. However, if there is any nationally recognized charitable organization who will be going and collecting money at the door, they would be required to alert as well. So it's like Save the Whales, yes. Girl Scouts, no.
Thank you very much. I think that's an important clarification from my understanding. So politicians, ourselves going door to door talking to constituents, sounds like that's a protected constitutional right. No problems with that based on
That
this
is
bill.
protected speech, but not only that, we are not soliciting. So at this time, the way the bill is written, and so this is something that the committee should probably consider, right? It is about door-to-door solicitation. However, the committee may wish to consider language which would also require someone who is sharing information. So Senator Maroney, I know, has an interest in some of the data issues. And I think of upcoming concern kind of on the precipice is the fact that some of these scams are looking for people's information, census scams, maybe something, Medicare scams. And if we see them go door to door, I think that eventually they'll need to be folded in. I don't know if we're at that point now, but it may behoove the committee to consider some, or at least put some thought into, if we do it now or later, something about protecting data and not just being about solicitation. But I'll leave that to you.
Thank you very much, Representative. Thank you,
Thank you
Mr.
very
Chairman.
much.
Are there any other questions for Representative Linehan? Seeing none, thank you so much for your testimony today.
Thank you, Mr. Chairman.
When Senator Looney and Senator Duff arrive, we'll take them. But next up, we have Representative Scott, who's online.
Thank you, Mr. Chair. Appreciate it. Sorry I can't be there in person. But further conversations on these topics would be more than willing to happen in person if so needed. Thank you to Chairs Maroney and Lamar, Vice Chairs Funfair and Turco, Ranking Members Ciccarella and Ritugliano and the rest of the General Law Committee for allowing me to speak and provide my testimony in favor of parts of HB 1464, an act concerning sports wagering and multi-jurisdictional internet gaming. The sections I had previously proposed in this bill are in Section 3, lines 257 through 261, which touches on the immediate disclosure of wager odds error. So the wording in the bill currently is not my exact intent when I proposed the bill. So I'll talk through that intent. And again, if we need to have further conversations about that or questions, I'm more than willing to talk about it. This concept aims to have sports books communicate immediately with consumers if there was an error on the line of a bet and force them to notify consumer before the sporting event starts that they are canceling the bet. Errors and typos happen. Totally understand. An example in this scenario would be the sports book meant to put the odds of Tiger Woods to win the Masters at 10-1, but accidentally put it on the market at 100-1. So way higher odds, way bigger payout for the consumer. Those mistakes happen, but they should not be able to wait until the event is over when they know who won to decide if they want to notify the consumer of the error. If Tiger Woods lost, maybe the sportsbook would not say anything and just keep the money. But if Tiger won, they cancel the bet to not have to pay out that error. If told before the event, the bettor can choose to bet Tiger at the current correct odds or bet someone else. That is a great consumer protection piece that sportsbooks should be able to do with their technology. Secondly, Section 3, lines 273 through 275, it's the maximum wager notification. So again, not exact the intent of what I had proposed. This concept aims to communicate clearly consumers why and how they're being limited. So some gamblers who have a success rate higher than the average and maybe actually make money gambling sometimes get limited in certain sports or certain kind of wagers. So limited means they can't bet as much as they normally would or have any free reign to bet the limits that are allowed. So players get limited when they win a lot of certain sports. Sportsbooks won't let you bet more than maybe $20 on a game. What I'm asking for here is to force these betting providers to communicate clearly why the consumer is getting limited and exactly how much they are being limited to. In a perfect world, limiting would be outlawed and is clearly prejudicial and selective. It would be like going to a blackjack table when the limit is $100, but you sit down and you can only bet $10 because you won for the first hour that you're playing. It is not fair, and consumer is not protected. If they did something wrong, and if they did nothing wrong on the outside of just picking some games more right than the average bettor. So again, both those sections are a little bit worded separately from what I was expecting or what I was hoping for. Again, more than willing to have a conversation with you and even the gaming operators. I know there's some testimony coming up from both DraftKings, FanDuel, and Fanatics about these topics. More than willing to have those conversations to make it sure very clear and understand what they can do, but also keep in mind consumer protection behind the scenes at all points. So thank you for thinking about these changes to the gambling sports rules, and your consideration of this bill is greatly appreciated.
Thank you, Representative Scott, for your submissions. I know there are just two of a number of issues that you would raise for the committee's consideration. A number of them you've had a sense to talk to me a little bit more about and educate me as we move forward. I think that relationship is going to continue to evolve over the next few years as this committee takes on a number of gaming-related issues. So I appreciate for the time and patience and consideration that you've put into this issue. Representative Rutigliano.
Thank you, Mr. Chairman. Good afternoon, Representative. I found some of your other proposals super interesting. I was wondering if you could just talk about publicly about how you think the algorithm, the online betting platforms are using algorithms to either target or entice people to gamble more if they lose more.
Yeah, there's a lot of times you have, and listen, I'll be the first one to admit, I'm a user. I definitely gamble. I use the online platforms. If I go to the casinos, I would bet there. So I do get targeted with certain deals and wagers based on my betting history, and that does lead sometimes to hitting on the weaknesses of people. Not everyone treats it as entertainment like I do. I treat it no different than going to see a movie, or going to dinner. But some people aren't able to do that, and we need to make sure we're protecting those folks. So sometimes those algorithms will kick in if you are betting golf. As I used the example before, you all of a sudden start getting some deals on betting golf and maybe get some, instead of, maybe get an extra 3-to-1 odds. So if you wanted to bet somebody that's 20-to-1, maybe get a free 3-to-1. So now it's 23-to-1. You get those to try to entice you to buy or to bet more. Again, in most people, I would say that is totally fine, but there are those folks who maybe are more inclined to be betting too far for their needs. And maybe it's something that we need to look at to make sure we're honing in on that. As myself, as someone who's just uses for entertainment and totally within my means, I like those ideas because I'm getting a free extra wagers or some deals that sometimes are offered to me that I can take advantage of as a consumer. But I can understand how sometimes that doesn't work out for all the consumers.
Under current law, are the gambling platforms allowed to personalize odds to the user, or if they just say those enticement odds that you just referred to that you received, is that available to everyone? Are they required to have it available to everyone, or is that sort of customized to you?
So the deals that they do sometimes to try to entice you to bet more, those deals tend to be open or personalized to some based on your algorithm, but open to more than just yourself. But from my understanding, there are not specific odds that if somebody knows I bet Tiger Woods a lot in a tournament, that Tiger Woods is going to have special odds for me versus the rest of the market. From my understanding, that is not the case. They do not have that ability to do so, and it's a really complex situation to be able to do that. So I wouldn't get, let's say, less odds. So instead of 100-to-1, I'd only get 60-to-1 because they know I bet Tiger Woods a lot. So they don't want to give me the best odds. They want to give me the worst odds. That is not what's happening in the market. And I don't think they have the capability of even doing that to that level. But what they could do is, again, trying to entice me to bet Tiger Woods. They might give me an offer of saying, hey, if you bet Tiger Woods, you get an extra whatever. That could happen, but there's not necessarily a different odd for you betting the LA Lakers or whatever, because they see you bet the Lakers regularly.
So you're saying they offer you a promotion individually, but the odds are spread across. How do we prove that they're not doing that? And does the law specifically, does the law specifically speak to the fact that they're not allowed to do what you just stated?
I can't speak to that law, especially in Connecticut. Unfortunately, I don't know that specifically, and to answer that, unfortunately.
So, and when you fund your online gaming account, how exactly do you fund it? You personally? Do you mind me
So
asking?
I use a credit card. I mean,
Is that
luckily,
credit card
I've been
sold?
fine, so I haven't put it in for a while. But when I originally set it up, and then if I've ever wanted to put any additional dollars in, I would be able to use a credit card.
And that's an interest-bearing credit card if you don't pay it off at the end of the month?
That is correct. Yeah.
Yeah, continue.
I wanted to ask you about some of the marketing techniques. I know it's not this specific bill that you're testifying on, but it is part of our greater conversation on gambling. Some of the deals that are offered, when you see advertising, bet $5, get 150, is it plainly aware of what you actually have to do to get that $150 or whatever the offer might be?
No, I mean, that is definitely something that I think needs to be a little bit clearer. Obviously, it's a marketing technique, and that's literally what I do for my living. In my regular job is marketing, and I understand that. But yeah, a lot of times you have a very limited amount of time to use that $150. You get free bets. You have a very limited amount of time on that. And I don't know if that's 100% clear. And if somebody's, not used to betting a lot of money, to bet $150 over a course of maybe 3 days or 7 days, when they're betting $5 or $10, they might not realize that they don't have that in the amount of time, and then you lose that $150, or at least a portion of that $150 maybe you got in that scenario that you suggested. So no, I think it needs to be more clear up front for those consumers, to let them know what they're exactly getting into when they make that $5 bet and they put money into that account, to know exactly what they need to do to be able to take advantage of that $150.
Oh, I appreciate that because, I look at the ads, I see the ads, and I always thought, you bet $5, you got 150, but then I was requested that I go and look at the fine print, and that you only got the 150 if you bet 10,000 over the next 30 days, or if you have to spend it all within the next 5 days. So I did find it to be a little deceptive. I also found the amount so low, and I love your opinion on this, that really they're sort of marketing to people that can't afford to gamble. Most typically young people who are certainly struggling or a target of most of the fantasy sports and the online sports gambling, that the thought of only having to give up $5 or $10 to get 150 seems to be a super enticement. I don't know if you had an opinion on that.
Yeah, I think it is super enticing. I think we need to keep an eye on the college kids. They're the most susceptible to this. They're there with gambling, with sports, with college sports, so prevalent, especially in the state, that we need to keep an eye on those folks. And I think those are the ones that a lot of times, they don't necessarily have full-time jobs. They're college kids, and we need to make sure we're not putting them into a negative situation. And I think some of these deals could be overly targeting towards that age group and those people who don't have a ton of money. And we need to make sure we're clear on what we're doing from a legislature, back to the gaming operators, to make sure what they're allowed to do. And I know you guys have a lot of advertising pieces within some of the bills, in the one that I talked about, but also other bills. And I think those are things that are smart steps that we're taking a look at. Obviously working with the gaming operators to make sure we're doing it, because we're all should be this in partnership, but making sure we're not hitting those who are the most influential, but also the ones who are most susceptible to it. And if we can do anything we can to stop that, we should be pushing the gaming operators to do so.
So when you walk into a casino, all the games, all the tables, everything's laid out in front of you, right? They may have flashing lights or something to entice you to go in there. Do you think fundamentally, this is a fundamental question, I think we're going to have a long discussion about it today. I think a lot of people are going to talk about it, that they should be allowed to use the algorithms to get you to bet more, to entice you to try something new. Some people may see it just as a simple marketing trick. It's sort of like Amazon. If you search something, they're going to advertise something to you. But some people, like myself, to be blunt, think that you're sort of enticing people to engage in behavior that maybe not be the best for them. So I don't know what the law would look like or how we would do it, but would you, it seems like you've got a good handle on it, but would you stop the use of algorithm or targeted marketing for online gambling if you had the opportunity?
Me personally, it doesn't affect me personally, right? Like, again, I have it under control, and I use it as an entertainment purposes. So I don't know if in total, that needs to be done. I think for those who are susceptible and those who are maybe gambling beyond their means, and I don't know how we can determine that. Or maybe the algorithm, maybe the AI, whatever is working to figure that out. Maybe those folks, the pedal should be taken off of. I don't know if that's even possible. But the average person, if I walk into a casino and there's a game over there to the right, and somehow there's something that's driving me over there, I'm in the casino. I'm raising my hand to be there, you know. So to try to attract me to come to this other game, try this other game out, isn't a problem to me personally. But I could see how offline, at home, in their basement, trying to, you know, try to catch up from some losses they already have. And giving more, you know, more offers and more enticements to try to get you to bet more and try to get out of the hole that you're in. I can see how that can be a problem. And I think that could be a way that we could try to stop those algorithms from targeting those folks, if that's a possibility, because those are the folks that are most susceptible at that time. If they have the information on how much they've lost and they see they keep putting back money into their account, is there a way to limit that, how much money they can put in their account, and protect them in ways that they might not be able to protect themselves at that time? I think that's something that should be looked at.
Well, I appreciate the thoughtful answer. I'll just ask one more question because I just want your opinion, because reading the bills that you proposed, even I'm speaking for myself, but I know other members of the committee were sort of impressed with, you seem to have a knowledge of this or be in this world a little bit. Another bill that we're going to consider today, and actually we voted out of committee, but it's probably going to go through negotiations, is the advertising on college campuses, right? So I appreciate the fact that UConn needs, or whoever needs to sell ads in an arena to make money, and there's revenue there. But not unlike, in my opinion, cigarettes, I do think it should be a point where we get to sort of limit the ads that are marketed to college kids in a college setting. Do you have an opinion on that one?
You know, I go back, I might be dating myself a little bit, but I went to Penn State University, and there used to be all the time, all around campus and events, to get a credit card, right? That was like the big thing. They'd have some cool gift that they would get you to get a credit card. And basically what they're trying to do is get you to get that credit card and go spend money, and maybe money that you don't have. Well, that was really outlawed on campus. Like, that's really not something that can happen anymore. I think people realized that they were just getting credit cards, and people were buying on it thinking, oh, I don't have to pay for this right now, and I can pay for it down the road, and then they just build up this big credit card debt. I don't see much difference between that for these college kids in the gambling world. I think they throw these enticements out there, just like a cool gift that was when you set up a credit card. So I do think I'm in agreement with that. I think at the college level and the college campuses, especially, you know, state schools, I think we need to have a closer look of what kind of advertising, but also what that messaging is. Listen, it's okay to maybe advertise, but it's what the messaging is. What are you trying to accomplish as the advertiser, to see what you're trying to draw those consumers in, and see what is allowed and what's not allowed. I think that's a great conversation to continue to keep having. And again, those are folks that are most susceptible because they don't necessarily have full-time jobs and understand the money to be able to fund a larger betting, you know, situation. And sometimes we're treating them that way, and that's not the way that they're really operating. And we're going to put them into a hole that ultimately mommy and daddy are going to have to probably try to bail them out of. So I think it's something that we should be definitely looking at.
I appreciate it. I appreciate the thoughtful conversation. I look forward to continuing it. And thank you, Mr. Chairman.
Thank you. Senator Maroney.
Thank you very much, Representative Scott. Thank you for bringing these ideas to the committee. I just want to follow up on Representative Retigliano's line of questioning about the algorithms for advertising. In Connecticut, you know, we did create the right for people to opt out of targeted advertising. As of January 1 of this year, there is the global privacy control. So it's a service like Opt Me Out, where you can go and it'll opt you out of all targeted advertising. So you don't have to go and do that individually. Would you support then some way of making consumers aware of their ability to opt out of the targeted advertising from the gambling site? So maybe we work with the Problem Gambling Commission or others to list that on their website or get the information out, especially to parents and to others, about the ability to opt out of targeted advertising.
Absolutely. I think that's a great way of doing it. Listen, not everybody has that ability to be able to look in the mirror and realize they need to opt out or put a pause on their gaming. But if they are, we should be taking advantage of those folks and make sure, not taking advantage of them, but take advantage of the fact that they did realize that and they're able to understand that. And then we can do that. I proposed another bill this year about consumer opt-outs in sports wagering. So currently, right now, you could take pauses, you could opt out of your gambling account. I would love to be able to see even more opt-outs specifically within it. Like, hey, I've been betting golf and I've been getting killed and I need to stop betting golf. If I can just click a box and say no golf for me, I would love to be able to do that. Or no football, or no college football, whatever it might be. Give more options within that, because maybe they don't want to stop betting at all, but they just know they need to step away from this one specific sport or this one type of bet that they're doing. Maybe they're doing too many parlays, which are very high odds and hard to hit. They're doing too many of those and they want to walk away. So all these opt-outs are consumer protections that we should be looking at to protect those most vulnerable. And I am 100% aligned with you, Senator Maroney, on making sure we're doing exactly that. And it sounds like what you're talking about is something that I would be supportive of.
Great, thank you. I look forward to continuing to work with you. I know you submitted your written testimony, and I wrote in some notes that I need to call you on some issues. So thank you very much.
We're right across. Oh, yeah, we're close. We can talk. Definitely.
Seeing no further questions, thank you, Representative Scott. And just make clear, Tiger Woods definitely ruptured his Achilles this week, so no one should be betting
correct
on Tiger Woods to win anything anytime soon.
That's correct.
Seeing no further questions, thank you again,
Thank
Representative Scott. When Senator Looney and Senator Duff are available, we'll take them. That would conclude the number of folks who have signed up as public officials to testify in our first hour. We will now move on to the public. If no one's here because it's still within that first hour, we'll come back to them. But first on our public list is David Prestwood. David, the floor is yours.
Okay, let me adjust there. Can you hear me?
We can.
All right, thank you to chairs, ranking members, and members of the committee. My name is David Prestwood. I'm Government Affairs Manager at DraftKings. I'm here today to provide testimony on DraftKings' behalf. We are privileged to offer sportsbook and iGaming products in Connecticut in partnership with the Meshantucket Pequot Tribal Nation. I'd like to thank the committee for the opportunity to participate to discuss several pieces of legislation relating to sports wagering and internet gaming. And I've submitted written testimony, so I'll abbreviate that here and be happy to take any questions. Regarding Senate Bill 1464, DraftKings would like to state its support for the provision authorizing the governor to enter into agreements for peer-to-peer casino gaming, such as the multi-state internet gaming agreement that many other states are members of. Regarding the resolution of errors and odds, DraftKings requests respectfully that the committee vote to or not adopt the provision on errors or rewrite it to clarify the limitation on wagers should only apply to the specific market affected by the error and not all markets associated with the sporting event. And I have some suggested language in my written testimony. Additionally, DraftKings agrees and requests that operators be required to void wagers that have a known error and refund the wager back to the customer. Both of those things are the industry standard. Regarding the toll-free numbers provisions in 1464, DraftKings respectfully requests the committee not adopt this provision that requires operators to use a toll-free number for customer reporting and resolving account issues. DraftKings and other operators offer email and chat as the primary means of resolving user issues for a number of reasons. Customer issues, especially in technology, can be complex, and email and chat allow us for both efficient collection of information, but also routing to a team member that can provide the knowledgeable response necessary in the first interaction. Then that reduces customer wait time and frustration. We've also, frankly, found that our customers generally prefer digital communication in this area, and we don't want to direct them to the wrong resource. Regarding the provision on maximum sports wagers, it sounds like the representative's original intent for this provision was different than how it was drafted, but we would, as drafted, request that the committee not adopt the provision requiring DCP to establish maximum wagers for online sports wagering and for us to display those wagers on the platform. The state's current regulations provide customers the opportunity to access information on maximum wagers in an operator's house rules, which we do, and those can be accessed already by any customer at any time. So the maximum wager an operator may accept generally varies based on the sport and the type of competition and the type of odds. So requiring that as a blanket on the app, I think, would be a challenge. I'd like to talk a little bit about House Bill 5269. We would request that the committee not adopt this legislation. There are two primary provisions, the first regarding deposits. The bill would permit operators only to accept a debit or credit deposit where the deposit has been authorized by each named account owner. The reality is that the mechanics of funding transactions simply do not allow a way for an acquirer in a financial transaction to see or verify all account holders on a particular account. So DraftKings would respectfully request the language be removed and the committee discuss directly with payment operators and financial institutions. I believe you have someone testifying later today about this issue. And if enacted, Connecticut would be the only jurisdiction in the US with such a restriction, simply because it's not possible to comply with. Regarding the advertising provisions, this bill prohibits operators from offering or advertising any financial incentive to participate in gaming. Sports wagering operators, including DraftKings, already include responsible gaming messages and operate under content and outlet and target audience restrictions under the statute and DCP's regulations. We work hand in hand with DCP and regulators across the country and state agencies to ensure that our advertising is responsible and accurate. This kind of broad provision would hinder the ability of all of Connecticut's legal, licensed, and regulated sports wagering operators to compete with the illegal offshore operators that are not subject to this kind of requirement. Promotions and further advertising of promotions are critical tools to convert individuals who access the illegal market to legal licensed operators. DCP has warned Connecticut consumers about the risks of engaging in illegal offshore operations, and legislation related to wagering should further the goal of protecting consumers rather than hinder it. I know there are some concerns about specific kinds of advertising or where terms and conditions are. Those are all things that I'm happy to discuss. Finally, regarding House Bill 5272, DraftKings respectfully requests the committee not adopt this legislation for the same reason regarding the advertising provisions of 5269. That's a lot in a short time, but as I mentioned, I submitted written testimony, so I'm happy to take any questions.
Thank you. I do appreciate your testimony here today, and I do think your perspective is something we need to take into consideration as we continue to draft rules around what the state's role is in regulating this marketplace. We are, as you are aware, and I know you're cognizant of it and concerned as well, we're aware of a rapid increase in the rate of problem gaming, particularly amongst what appears to be younger constituents of Connecticut, particularly young men, generally are experiencing rapid rates of problematic gaming behavior. There's been a series of public health journals, American Medical Association, Wall Street Journal, New York Times, have all highlighted this rapid increase, not just in Connecticut, but across the country, of problematic gaming behavior with the prevalence of sports gaming that Connecticut authorized and is financially benefiting from. And so I think, recognizing the state's role in this marketplace and the fact that the state is gaining significant revenue streams from what one could argue is very problematic behavior amongst certain populations, I think that is the jurisdiction by which we are exercising concern, right? We're wondering, and you see it in these proposals, you see it in the leadership of this committee, the move from public safety over to general law, and understanding that perhaps there's additional constraints that we need to place on this marketplace when it comes to advertising, marketing, how accounts are funded, to protect against that rise. And I know you guys are concerned about it too, right? I know you're concerned about it, you're seeing it, and you're trying to craft some internal controls. So it's my hope that as we look over this for the next week in committee, but also the months in the legislative session, that you'll continue to work with us and, give us some advice and insight internally on how the marketplace is evolving and what your regulations and controls are. But we're hearing from constituents on a pretty continuous basis that their children are opening up credit cards that they're receiving on college campuses and depositing $5,000 into account. They're engaging in very risky, problematic sports gaming behavior. They lose the $5,000, or their husband, wife, spouse, partner, who's a named person on an account, suddenly finds a credit card bill with thousands of dollars of charges on it. They had no knowledge, and they are now held financially responsible for the behaviors of their spouse or named partners. And I think those are things that we want to look at to see if there's an appropriate regulatory tool that we can accompany. And so I think you covered what your concerns are, but I think we're going to ask you to help cover what the appropriate response is to those concerns. Representative Ritigliano? Representative Yacarino, sorry.
Thank you, Mr. Chair, and thank you for testifying, Dave. I've never gone on DraftKings, but full disclosure, when I was younger, a lot of my buddies, we would gamble, this is a long, long time ago. When the money ran out, you were done. So my suggestion would be, and I haven't gambled forever, why don't we use a debit card only? With a credit card, you could have a $20,000 limit or $50,000 limit or even $10,000. With a debit card, you only have the money that's in your bank account. Did you ever consider that? Just a strict debit card, maybe it's 25 or under? Hello?
David, did you hear Representative Yacarino?
I did. There are jurisdictions that allow credit card deposits. There are jurisdictions that allow debit card deposits. I think that's up to which individual jurisdiction and the decisions made there.
But I would think it would make more sense strictly with a debit card, because if you only have $1,000 in there, you could only spend $1,000. If you have a credit card limit of $10,000, you could max that out. So my suggestion really would looking at the age and strictly a debit card, because you run out of cash, you're done. But if you have a credit card, and it should strictly be that maybe one card and file, because it's a serious problem. And you can't police everything, but I think if you have only $1,000 to spend, that's it. When you have a $10,000 limit and you have a gambling problem, you're going to just spend the $10,000. So my suggestion would really look at just a debit card, because you can't go more than what you have in the bank. The banks, they're going to decline it. And I'd hope that we could consider that.
I'm happy to reach back out and clarify. I don't believe that we actually accept credit cards in Connecticut.
Thank you.
Thank you. It looks like that's the end of the questions.
I'm good.
Oh, so
I'm sorry. I was ready now.
Okay, sorry.
Sorry.
Representative
No,
Ritigliano.
it's okay. I wanted you to go first, Dave. It's all right. No, I did. Just a couple of quick questions. And maybe I'll start with a statement. The 1-800 number was proposed to us that you have a customer service line, because we have heard from the problem gambling people that a lot of your customers are using that 800 number to lodge complaints about whatever's happened on your website, not so much calling to discuss their gambling problem. I didn't know if with that information, if maybe you guys would be more open to setting up some sort of customer service line.
We hear this a lot from the hotlines. Even in the ads, it says gambling problem, call 1-800-GAMBLER. And some people, their gambling problem is not what is intended. It's, hey, how do I place a bet on X, or how do I recover my account? And so, we do offer robust services, and there are plenty of links on how to contact us and deal with those things. There's a chat available on every page that our customers consider. I worry a little bit about, posting multiple numbers, because the number that is the most important is 1-800-GAMBLER for anyone who seeks information about problem gambling. But I think that's an issue that we want to make sure that when people do have an issue with their account or a question, that they're getting those things answered. I think that email and chat, we have learned, is the most efficient way to do that.
So as it pertains to credit cards, you stated that if we put this restriction on it, or this mandate on it, that both people would have to sign off to use a credit card to fund their online account, we would be in the first in the nation to do that, the only state to do that. But isn't it true that some states who did pass legalized online gambling or sports gambling didn't allow for a credit card in the first place, and that they have to fund their account in a different way?
Yes, there are jurisdictions that don't allow credit card deposits. As I mentioned, I don't believe we accept credit card deposits in Connecticut as it is. The specific issue with the language in 5269 is that it would require for either a debit or credit card verification from all authorized account holders, or from all account holders, that deposit is allowed. We just don't have a way to see who all account holders is, because that's not the way payments are actually processed.
I mean, Representative Scott testified before you that he funded his sports gambling account with his revolving credit card. So, I mean, apparently we're doing it because it's happening. And my second question is, if you go to the casinos and you want to use your debit card or credit card for a cash advance, or you want to take out money, they limit you daily. I think it's $500. Is there any limit daily to the amount somebody could use their credit card for on an online platform?
I think that's up to individual jurisdictions. I'm not sure offhand if we have a daily deposit limit. I believe there might be a maximum limit, but we also provide individuals with the tools to set what their daily, monthly deposit limits are. So and I can't speak to that. As someone who works for DraftKings and am not able to use our app, I'm not sure that's something I've come up against.
I understand. I guess my question was like, you have somebody with, I don't know, is having a bad day or struggling, and they go to the casino and they use their debit card or credit card to take out money that day, cash advance. I think it's $500 limit, but you're saying that if they just grabbed their cell phone and started gambling, that I'm concerned, or I was questioning whether or not there's that same limit that day. It doesn't seem that there is, and I didn't know if you would be amenable to the same limits that would happen in person as online.
I'm happy to look into what the rules are there and what we do and get back to you.
When somebody contacts your customer service, you said that it's a way for us to collect information. Are you collecting the nature of the complaint, or are you collecting information on the gambler and then turn around and use that information to market to that customer?
No, if there's a customer complaint, when I say collecting information, I mean about what the complaint is, the specific issue that was had. If it's a technical issue, for example, so that it's routed to the right person. Rather than have someone say, what is your name, what is your account, so on and so forth on the phone.
And that, nope, you don't store any of that information. I guess you would know that they were a user anyway. And number two is, are you familiar with how the algorithms work on your site and how they collect information, how they store information, and then how they turn around and use that information to market to individuals?
I mean, I think that's a broad question. Like any other business, when my kids were young and I bought diapers, when I went to Amazon.com, it would show me diapers on the front page because it knew that that was something I had purchased in the past. If you're asking whether or not we determine if people have a gambling problem and then specifically use that information to market to them, we don't do that. Very much the opposite is we have
Not that
used.
they have a gambling problem, but what if they had losses that day? They're losing, they're gambling a lot. You see that you have a heavy user and that the algorithm could collect the information to further market to that person so they continue in the behavior. That's what I guess I'm most concerned with. Even if there is legal online gambling, I don't think there should be some sort of computer bot or whatever going after somebody who maybe have to get them to gamble more than they're already gambling. So that's what the basis of the question was, how they're gathering the information and then how in turn they're using the information to sort of maybe get this person to just do one more bet or one more bet.
I can say that we do not use algorithms to encourage patrons to chase their losses or participate in other irresponsible gambling behavior.
Thank you, Mr. Chairman. Thank you, sir. I appreciate your answers. Thank you.
Thank you.
Thank you. Are there any further questions? Okay, hearing none. Thank you for your testimony. Next, Chris Phelps.
Thank you, Senator Maroney and members of the committee. I'm Chris Phelps. I'm the State Director for Environment, Connecticut, and I'm here testifying today on Senate Bill 3 and specifically in support of Section 3 of Senate Bill 3 regarding a consumer right to repair for consumer electronics, home appliances, and things of that nature. We're testifying in support of this bill and we have supported it with our colleagues around the country in various other jurisdictions because right to repair for the stuff we buy helps consumers save money and also helps consumers reduce waste by making it easier to repair that stuff. Barriers to repairability of products such as home appliances like dishwashers or washing machines or home electronics like our cell phones increase our costs and contributes to the growing local and global waste crisis harming our economy and our environment. I note in our testimony some examples. Electronic waste, according to the United Nations Global E-Waste Monitor, is the fastest growing waste stream in the world. Each year, Americans produce roughly 47 pounds of e-waste per person per year, including every time we replace our cell phones after a year or two, rather than get it repaired. that e-waste contains toxic materials. It's estimated that 40% of the heavy metals in our landfills comes from discarded electronics. And e-waste is very hard to recycle. Only about 20% of e-waste is currently recycled. And although we might be able to do a better job of getting more of that waste into the recycling system, it's even more prudent, both environmentally and economically, to reuse the stuff we have, to repair it and extend its life. You know, I'll actually just summarize the rest of this and let you read my testimony. I'd like to talk, personally, I actually kind of learned this ethos from my parents and my grandparents. The idea that, you know, you don't buy a refrigerator every 5 years. If you buy a refrigerator, it goes on the fritz, you get it replaced. When I started owning cell phones, I was scandalized to discover how difficult it is to repair them, or, you know, it's getting better though. And I actually, for many years have personally refurbished and repaired vintage stereo equipment. It's a hobby of mine. And I do that because I hate to see good products go to waste and just go into the dump. In fact, a number of years ago, I was talking to an acquaintance about that. And he turned out, he worked with senior citizens, and he had a client who was in his 80s and always was talking about his favorite old stereo equipment from the 1970s. And long story short, I managed to find examples of the stereo system he was talking about. We managed to repair it and give it to this gentleman as a gift. And it was one of the most, the look on his face was incredible. And he started talking about this idea. He started talking about how he wanted that stereo because back in the day, he didn't have to buy a new stereo every 3 years because something broke. And he was talking about right to repair, the ability to repair stuff. I know I heard the bell go off, so I'd be happy to answer any questions you have about this. I have reviewed some of the testimony from various raising concerns about this language. And I would just note that I hope that various stakeholders, including us, would happily work with the committee to find alignment between this bill and some of the legislation that's already been adopted in other states, because this is a good bill, that or good language that ought to pass, as it were.
Great. Thank you very much. Are there any questions? Representative Yacarino has a question, then I'll just
I
stay.
apologize, Mr. Chair, just.
You don't have to apologize. We're here to ask questions.
I know, but Dave R. So I'm going through the bill, but I for appliances, for instance, like I took my oldest son and I went to he's getting new appliances. When the appliance company gets those, this would apply to that, I believe, the old appliances, it's up to the company what to do with them. Like there's a procedure, am I correct? How to dispose of them?
For the disposal side?
Yeah.
Well, I mean, this language is yes. I mean, this language is oriented towards ensuring that manufacturers are making the information available to make it easier for consumers and independent repair shops to repair an appliance rather than just throw it away.
Yeah, the procedure to fix it before discarding it.
Yeah, exactly.
That was the clarification. I
mean, that's the intent here is and from an environmental perspective, reusing or repairing an appliance or any product inherently, extending its life reduces both the waste produced, but also reduces the waste involved in producing a new product.
100%.
From scratch using virgin materials, for example. Yeah.
No, I try to fix what I can, but nowadays, unfortunately, a lot of stuff's disposable, and that's the sad part.
Yeah, yeah, and one of the problems we've encountered, we as consumers have encountered in recent years, and as time has passed, is that disposability is sometimes a function of lack of information, lack of access to the tools and just the manuals to enable someone to actually repair something that is repairable. And that's part of what this legislation gets at.
Yeah. Thank you, Mr. Chair.
Great. Thank you. And you're talking about the record players, and vinyl's making a comeback for what I hear. But thanks for bringing up your grandparents. It reminds me of my grandfather he'd repair everything, right? We'd repair the hose and all the different things. And bringing up the e-waste, a few years ago, this committee passed a bill to allow for the reverse vending machines for recycling the cell phones. And we were going to make the trip, and we never did. So thanks for reminding Representative Partigliano and I. We have to go to Walmart in Milford to recycle our cell phones. So thank you very much for your
No, thank you,
testimony.
Senator. It really is the case. Our grandparents' generation would have looked down the nose at the idea that you buy a washing machine and then throw it out 5 years later and buy a new one, for example. So, all right.
Great.
Thank you.
Thank you. Next, DM Livingston.
Hello. Hi. I've never been here before. It's a beautiful building. You guys are lucky that you work here. I'm submitting this testimony. Well, my name is DM Livingston, owner of Livingston Media Company. I do the Waterbury Times based in Waterbury, Connecticut. I'm submitting this testimony in strong opposition to the proposed legislation, House Bill 5560, which seeks to regulate and restrict the ability of content creators, influencers, and individuals who supplement their income through reviews and promotions of businesses. Influencers have become an indispensable part of the modern marketing ecosystem, especially for small businesses. According to a 2020 Influencer Marketing Hub report, 63% of marketers said that they plan to increase their influencer marketing budgets. So this is not just a little simple trend. It's a transformative shift in how businesses, particularly small businesses, connect with their target audiences. Research from Nielsen shows that 92%, pause for dramatic effect, 92% of consumers trust recommendations from individuals even if they don't know them personally over traditional advertising. This type of marketing is particularly valuable in local communities where word of mouth is essential for business growth, especially places like Waterbury, Connecticut. And a 92% trust rating as elected leaders, I'm sure you would all be pleased if you all had 92% approval ratings. There is no statistical data to support that passing this bill does more good than harm when 92% trust the current ecosystem, unless, of course, those 8% all live in Connecticut. Content creators and influencers are not just online personalities who like to talk a lot. Many are individuals who, especially in economically disadvantaged areas, aka poor people, have been able to turn their online presence into a legitimate source of income. With all the isms in the world, nepotism, sexism, racism, felonyism, technology has paved the way with no gatekeepers for individuals to earn a living, simply just earn a living. And this bill seeks to gatekeep that. While it's well-intentioned, and I'm 92% sure it's well-intentioned, this bill would have unintended consequences that can harm small business and undermine economic opportunity for the state as a whole. You're going to disempower small businesses. Many small businesses rely on influencer partnership to get the word out. If influencers are unable to operate freely, these businesses will face limited options for low-cost marketing. In many cases, this could force them to rely on expensive traditional advertising. No new small businesses will come to Connecticut, and influencers will take their influence to friendlier states. There will be a mass exodus of content creators, influencers, marketers, small businesses who can't afford to market in Connecticut. And I promise you, this is my life 24 hours a day. I'm not being dramatic. We are not going back to print. Nobody watches television. Who's going to tell the world that Connecticut is great? We're the pizza capital of the United States because of social media marketing. So you're welcome for that. So in conclusion, to just wrap this up, this is a misguided attempt to regulate an industry that provides immense benefits to both small businesses and individuals. Rather than imposing restrictive regulations, I urge you to allow the laws in place to work. Libel and slander, that is applicable to a social media post. So we have laws to protect businesses from bad reviews. Influencer marketing is not a passing trend. It's either influencers or algorithms. Got to pick. Thank you for your time and hearing me out.
Thank you. Representative Retigliano.
Good afternoon, sir. Good morning. How are you today?
I'm doing great.
Is the Waterbury Times a online paper?
Yes. So the Waterbury Times is a social media base. We utilize Facebook, TikTok, Instagram. We have a website. We use Newsbreak. And we gather the local news because the Republican American, may it rest in peace, now that it's bought by Hearst Communications, they didn't do the best job of covering Waterbury. So it started off as we're just going to cover Waterbury. And a big part of that is our central business district. I'm like a walking algorithm. I can tell you right now, every restaurant to go eat at, why the pizza's good, this, that, and the third. And it just seems like this bill wants to put that in the hands of, I don't know where they want to put
So
it at.
you're not like the news junkie or something like that. That's sort of a news website. You sort of just do it through social media where you tell a story about Waterbury, or that's how you.
No, I'm boots on the ground. I mean, if you guys, everyone, please follow the Waterbury Times. Oh, I'm gonna take you there first. Whatever's going on, I'm there. But in the midst of that, because this, like again, like I said, and I can only speak to myself. The Waterbury Times, it's kind of a hybrid situation. It's not you're necessarily what you first imagine when you think, oh, a social media site. We're making real changes in the city of Waterbury. We got a solid 15,000 total followers, and they're all local. See, that's the key differential that you have to think about. A lot of people's social media sites, when you see 2 million followers, that's worldwide people that press the button follow one time. I'm talking about locally grown people that have, you know, a respectable amount of followers that they actually know. And if I say, hey, go to this restaurant, they're actually going to go to that restaurant.
So I read the bill a few times. Is there anybody else? If you don't have to answer, just raise your hand. Going to testify in this bill? Because I came away with a bunch of questions about the bill in general. At first, I thought it was going after, you know, like online reviews. Somebody goes up there and it's your competitor, or they pay somebody to go up there and say something negative about you. But then I read it and it seemed like it was more towards people like yourself, what you're up to, where you probably get paid to talk about a particular business, but in a way that's different than just sort of writing a review on Yelp or something like that.
Right, exactly.
Did I read it correctly?
That's how I took it. I didn't probably read it as much as you read it, but as I was looking at it, it just seems like it wants to, I don't know, it didn't give an alternative. So what I'm taking from it, it's pretty much, it seems like leave the professional marketing and advertising to the professionals, but it's kind of like, if a person from New York moved to Waterbury, Connecticut, I don't care, CBS, NBC, there's no better person than the Waterbury Times to tell you where to go. I live there, I'm on the ground.
So you go around the businesses and offer your services for a fee.
Actually, what I will say is misconception, and I think anyone else would be able to attest to this, our phones ring. We don't have a sales team, a marketing team.
Right.
We're just doing our thing. We get a bunch of followers. A smart businessman sees the followers, sees the value. My phone rings or I get a message. And
Right.
it seems like this bill's going to make them not be able to do that.
So devil's advocate, do you think that somewhere on your site, when you're sitting there talking about, you know, how great Dominic and Pia's is downtown?
Nice.
Yeah. That you should say, hey, this is a paid endorsement, or is that what the bill's looking for? Or is it looking for you to have you completely stop doing what you're doing?
I'm reading it as it's trying to basically outlaw it. And again, there are already, maybe you guys can go back and look more in depth into this world of social media marketing, because through the individual platforms, there are certain things you cannot engage in. You have to put a title if you use AI. So there are, similar to, you know, the conversation I heard before, there seems like there are stops in place to stop whatever this bill is trying to stop already. You just don't want to throw the baby out with the bathwater all the time.
Would you be opposed to, like, if you're getting paid to promote a particular business in Waterbury, would you be opposed to some sort of, just, I have no idea.
Right.
I was hoping the bill said something different than what it says. So I'm kind of with you a little bit,
Yeah.
because I thought they were going to talk about like the predatory practices of online, where they congregate reviews, like your
Right.
Yelp,
Right. I'm trying to take down your business, so I'm
Right.
going to put a bunch of bad reviews to drop down your star rating.
Because it did say you have to disclose if you're an employee, but if you're hired to do it, are you
Right.
technically an employee? So
Right.
it started getting a little more in the weeds than I thought the bill was going to get into.
Exactly.
But would you be opposed to, like, when you're doing a review or you're walking around, to just something on the bottom of it that says this is a paid endorsement or something like that?
No, I wouldn't, because the way I can't speak for everyone, because I try to, even though it is social media, I try to adhere to traditional methods, and, you know, TV, this is paid programming. So that just, to me, it's normal, a little bit older than most people that are running the social media, but I remember seeing this is a paid programming. So that seems realistic to me. That seems a lot easier than constructing it that we can't even conduct business at all with each other.
I understand. I really appreciate your answers. I probably can go on, but I don't think I'm in business, so I have a business, and I'm kind of in this world a little bit. Not what you do. I mean,
Right. No, I
I hire
understand.
people.
You're
to
on
do
the
what you
other
do.
side.
Yeah, right. I don't necessarily personally have an issue with what you're up to, but there are some other people out there, namely your big review platforms that are super predatory and really engaging with conduct that, in my opinion, is illegal. But I
Right.
don't think this bill did that. And that's why I asked you those questions.
Okay.
Good luck to you. Good luck to Waterbury.
Yes, thank
As
you.
A native son.
Okay,
I'm
nice.
a Bunker Hill kid, just so everybody understands.
Okay, Waterbury's in the house. Don't get me excited in here.
All right. Nice to meet you.
All right, nice to meet you.
Wait, I might not be the last
Wait,
one. Hold on. Thank you, Mr.
Hold on
Chairman.
one second. Are there further questions? Yes, Representative Candelaria.
Thank you, Mr. Chairman. And I also, when I read the bill, I share some concerns as well because it's not very clear. Me, also, I own a business and I see how this would hinder me from growing as well, right? This is an opportunity, and I think all business owners see this as an opportunity when you engage with a celebrity, right? To get a
Right.
testimonial. My question to you is, when you provide a testimonial in support of a product or a consumer good, do you review the product beforehand? Do you utilize the product? Can you talk a little bit about that part?
So pretty much the way that I specifically do it is because I like to keep everything super genuine. So when you follow the Waterbury Times, I want it to be like, no, yeah, that's a Waterbury guy. So I don't have to try, for example, Dominic Apia. It's a known fact. If I'm telling you about, I've lived there my whole life, I've eaten. So I don't, like, my method isn't to, his point, going in, I'm gonna try your soup of the day, and then I'm gonna go tell everyone how great this soup. Like, that's not the business model. I just feel like the bill may indirectly affect a stream of revenue that sites like mine's depend on. So in the midst of writing a story about Chief Spagnola or whatever the mayor is doing, the new Afro-Caribbean place opens up. You know, they might reach out, hey, DM, can you run it? So it's those opportunities that I don't want me and people that aren't as vocal as me and won't come all the way down here to become hesitant now. Like, I don't know, can I do that? Should I do that? You know, it's kind of, it's new industry the way we're kind of, but I feel like if we just, it's a baby now, but just let it grow, it'll work its kinks out. I don't think anyone is being harmed that detrimentally because of a bad review.
Thank you for that response. And that clears up a lot in my view as well, because I had literally some concerns. I still have concerns with this language because I see it's a hindrance for
Yes.
small businesses in the state of Connecticut.
100%.
So thank you. Thank you for your time.
Okay.
Okay, Representative Yacarino.
Thank you, Mr. Chair, because there's so many good questions. I would argue, I do agree with you because you live there. So you have to live in that community. So if you're being predatory toward a certain business, you have to have credibility. So I think, to me, you have more credibility than Yelp or something like that because they don't have the boots on the ground. They're not there. They're not living with their neighbors. And if you do a bad job, like in any business, you're not gonna get any reviews. They're gonna dump you.
Right.
I believe
Absolutely.
that's correct. So I would think we have to look out for small businesses that are in the community, that are working in the community. You know, I have a small business in North Haven. If there's somebody doing reviews on us, if they're living there, they know what's really happening. If they're not there, anybody could say anything.
Exactly, 100%.
That's my concern. Thank you.
Great.
Thank you, Mr. Chair.
Thank you, Representative Yacarino. Thank you very much, Mr.
Okay, now I'm good.
Now you're good.
Okay.
Thank you. All right, next, Michael Ventre from FanDuel.
Good morning. How are we doing? Thank you very much, Chairman and co-chairs and ranking members. My name is Michael Ventry. Here on behalf of FanDuel, Senior Manager, and I cover Connecticut. FanDuel has been proudly offering online gaming here in Connecticut for nearly 4 years, along with our partners at Mohegan Sun. And we are here to voice concerns about bills 5269, 5272, and SB 1464. A lot of our concerns mirror those of our friends at DraftKings, so I'll try to keep them brief, and I'm sure you have questions. First on 5269, requiring all account holders to approve a debit deposit, making wagers on our platform. If adopted, Connecticut would be the only state in the country with this requirement for good reason. The compliance is impossible. To our knowledge, there's currently no method within established card network systems and banking systems to confirm the approval of all account holders making a deposit. What a customer is comfortable depositing is the responsibility of the customer, just like any other transaction. Moving on to banning promos as outlined in 5269 and 5272, it poses a threat to how the entire online gaming industry works. Promotional credits like the ones offered at FanDuel are part of our gaming experience, and our customers expect to enjoy them. If regulated operators are not able to provide such promotions, some customers will seek out the illegal offshore operators who do travel to other jurisdictions that would offer promos. Part of the benefit of being on the online regulated gaming marketplace is that it presents not only a safe gaming environment, but also one that is enjoyed by the customer. And taking promos away would inherently damage this experience. And I can say that, the illegal market is impacted by the legal market. To date, Bovada, which is one of the largest illegal operators, has seen a 50% decline in searches in the state of Connecticut since online gaming was legalized here nearly 4 years ago. Moving on to 1464, which gives the governor the authority to join organizations such as the Multi-State Internet Gaming Compact. FanDuel is supportive of this provision, and we thank the committee for moving on it. We just have two asks, and we're happy to have more detail on it in my written comments. The first is we ask that you put into the possibility of having Connecticut join along with other territories in places such as Canada, which is looking to join the compact itself. And there's a couple of definitions that was flagged that we would like included in the bill, but like I said, those are in my more lengthy statements. Concerning improper wagers, the way the bill is written, the verbiage is broad. There's no definition of what an error is, which can lead to problems. As sports wagering is defined to cover the appropriate segment of live sporting betting, including a portion or portions of a live sporting event and events. Since that language is not used in the error inclusion, it could be used to mean if we discover an error on one particular market, that we would have to stop accepting wagers in all markets. And as I understand from the representative before, maybe we can work on tweaking that provision. And just very briefly, we have similar comments related to toll-free numbers. Currently, 93% of our customers use our chat directly online, and the other 7% use email. Creating a toll-free number, it's both inefficient and difficult to manage. Agents right now are able to cover 3 or 4 chats concurrently. Phone system is only one at a time. We have a premier dedication to customer experience, and a fun and safe customer experience is our #1 priority. And we want to keep that going. And finally, on maximum bets, it gives the Department of Consumer Protection unlimited range to limit a wager size. We ask the committee either strike the provision or amend it to a reasonable range similar to other states. But as I understand it, the language may not be exactly what the original sponsor intended.
Great. Thank you very much, Representative Vitigliano.
Thank you. Thank you, sir, for coming in today. Just a follow-up question. So just on the credit card thing. So they were texting while we're all talking that even though it's permissible to use a credit card in Connecticut, that DraftKings and FanDuel doesn't use credit cards in Connecticut. Why would you oppose the bill that is banning or regulating something that you're not currently doing?
As I understood the way the bill reads, you would need, say you and your wife had a bank account, you would need both, you and your wife to both approve of the deposit before it would go through. That's the way that we read
Through a
the bill.
debit card or a credit card?
The way the bill reads is both. What we're saying is that process doesn't work that way. We have no way of verifying.
So you accept debit cards, just not credit cards?
In the state of Connecticut, yes.
So if a debit card has a Visa logo on it, isn't it essentially a credit card if you're past how much money you have in your bank? It becomes a revolving credit card. A revolving charge card, because it has a Visa logo, which means it can be used as a credit card.
I can't speak to the specifics of how that works. A debit card that was brought before, it has a set limit on your bank account, as we all know. Credit card has whatever the limit is on the cards are.
Okay, thank you. I just wanted, I was just curious. I mean, I understand and I accept everything that you've said. I think we're just trying to set some reasonable limits to what's going on out there. And really, it's not so much that we're thinking or considering the marketing. It's what we deem as predatory, deceptive marketing. To sit there and tell somebody they get $200 if they bet $5, and then the fine tiny little print says that you got to bet an aggregate of 10,000 over 7 days is deceptive in my opinion and some other people's opinions. That's why we brought it up. So if your industry could clean that up a little bit, then I think maybe some of us would back off on it. And really, in our opinion, and this is becoming a lecture more than a question, is it has to do more with the young people, the broker people are more susceptible to that sort of advertising. So it just seems like everything we've done, from gambling to cannabis, you name it, if you're under 24 and a male, we're coming after you and we're trying to beat you down a little bit. It's not Tony Scott, Representative Scott, who, you know, is a grown man, makes his own decisions. It really, a young person who maybe doesn't have the decision-making abilities or the financial means is the one that's susceptible to a 5 for 200 bet when they don't realize in order to get it. And then they try to get it. So they do the aggregate of 10,000 or whatever it might be. I'm making these numbers up, but I've seen the ads. So I don't know if that is a response. I just felt compelled to say it, but that's why I'm up here, I guess.
Yeah.
And I appreciate it.
I could say, if you don't mind, I appreciate the concern, Representative, and we're happy to have our responsible gaming teams come out here and speak in great detail on this. They're the experts here. And I can tell you, at FanDuel, even when given the option, we don't allow anyone on our platform under the age of 21. Kentucky is a good example. It allows explicitly in the law for anyone under 18 to 21 to be on there as a company. We do not allow that.
But Connecticut is 21 and older, or 18
I believe
and older?
I believe it's 21 and older. Yes,
Right.
sir.
21, right?
But
Well, there's
I
a DMOS symposium yesterday that said 18, but whatever. All right, go ahead. I'm sorry.
No, I just want to say, and you brought up college campuses before. We also agree that there should be no advertising on college campuses,
Well, I appreciate
as we
that.
testified in the past
Thank you.
for on campus advertising and all that.
And just as a side note, the 800 number really was just to take the pressure off the gambling hotline, because people are using it as a customer service line. It wasn't, we're trying not burden you with another communication method. It's just, we had heard complaints that the majority of their phone calls are somebody complaining about their gambling account, not the fact that they're seeking help for their gambling problem.
Completely understand. We're happy to work with whoever wishes to.
Thank
We want to be good partners with the state.
Appreciate it. Thank you, Mr. Chairman.
Thank you, sir.
Yeah, thank you very much. I was just going to reiterate that was a concern that was brought to us. And I think that, you know, you're committed to the user experience. There are some users who would rather call than go to a chat bot. And there are ways technologically, right, using voice recognition and others, you can easily do that. So I have a question. Did you drive up here from Brooklyn?
So my family's from Brooklyn. I live in the Hudson Valley.
Oh,
but,
okay.
Every single time the pizza capital thing is brought up,
I was gonna
have a real issue with that.
I was going to recommend you stop in New Haven on your way back to Brooklyn.
So far,
so we can put this to bed once and for all.
So far, I've had Frank Pepe, and it's excellent. I got to go to Sally's next, is my understanding.
Okay.
So I'll make my way there.
All right, great. Thank you very
Thank you
much, Mr. Ventry. Are there further questions? All right, thanks for testifying
Thank you
today.
very much. Thank you.
Okay, next, I believe David, number 9 is not testifying. Okay, so John Erlinghauser from AARP.
We're still good morning. Good morning, Senator Maroney, Representative Rotigliano, members of the committee. My name is John Erlinghauser, and I'm the Senior Director of Advocacy for AARP in Connecticut. And AARP is a nonpartisan social mission organization with an age 50 membership of nearly 38 million members nationwide and 550,000 here in Connecticut. We support livable communities for all ages, aging in place initiatives, financial opportunity and resilience for everyone who, as they work and age and retire, and we come before the General Assembly on a multitude of bills that impact these areas. And today I'm here to speak on 2 bills. And I'll speak first in strong support of Senate Bill 3. And I'll just touch on the sections that we support. There are some sections we don't comment on, and we're neutral on those sections, and not because they're not necessarily good provisions, but there are areas where we don't have policy. And so where we don't have policy, we don't comment. But we are in support of sections 1, 3, 4, and 6. We strongly support section 1 on the fee disclosures. Requires businesses to disclose all mandatory fees before purchases, except for taxes and certain fees if they're clearly disclosed. Violations are considered unfair trade practices, and we think just that's a very critical piece and one of the main reasons we do support Senate Bill 3. And then I will just touch again on section 6. On that, we support authorizing the Attorney General to declare abnormal economic disruptions caused by man-made or natural disaster or emergency, as well enforce measures against price gouging during those events. I wanted to comment on that section just because if in fact it doesn't meet that criterion, we do believe the market should decide things, but under these circumstances, we would support that provision. So if a change is made in that regard, we would have some concerns about that. The other bill I want to touch on is House Bill 6052, and we appreciate the committee raising that bill, and that's the Act Concerning Home Solicitation, Sales Act, and Residential Solar Photovoltaic Systems. We have testified on bills that have tried to deal with this issue for many years in the Energy and Technology Committee, and there's always been issues about, where this issue lies, whether it's with DCP or Pura and other things, and so it's always been this dynamic. And a lot of that has resulted in nothing really meaningful happening in this regard. And I just wanted to say this is an issue we hear from members about more than any other issue, quite honestly, and it's not just fraud. It's also, of people misrepresenting who they are when they come to the door. Maybe, people just pretending to be a door-to-door solicitation, and that's an issue. And I know that happens, but we also have concerns about the misrepresentations that third-party agents of solar companies make when they go door to door. And, I live in a very walkable neighborhood. I get 2 to 3 of these solicitations a day, and I get things represented to me by these third-party agents that I know for a fact are simply not true. So there's a good start in this bill. We are going to submit written testimony you will have by tomorrow that addresses some concerns we have with language and things that the bill doesn't address that we think it should. So I do appreciate.
Yeah. Yeah. He's not wrong about modern. I have to be honest with you. Yeah. Yeah. Rose Lane is very good. Yeah.
Great. Representative Tagliano.
Thank you. Just a couple of questions, couple of issues. First issue being that 50 and older is not senior citizen. I don't know where you people get that from.
I hit
That's
the speed
crazy.
limit this May.
And
So I'll be
we may
55.
be able to fight about that whole nonpartisan tag that you guys bandy about a little bit. But I read that in Trumbull, I live in Trumbull.
Yep.
So if you're going to do door to door, they sort of solved it. Or one of the ways they handled it was they have to go, the local municipality passed an ordinance. We have to go check in with the police and let them know, hey, they don't stop you. They're just like, okay, this is who we are. This is where we're going. So if there's any calls, they could say, hey, no, it's just some solar guy. Are you looking to ban the practice in your eyes of door-to-door sales? Or are you looking for some sort of mechanism where they register? But even if they just register with the police, it doesn't sort of give them the stamp of approval that this is a good company, not up to bad things. It just lets people know that they're walking the neighborhood.
I think that's an excellent point, and we have no concerns with. I mean, there's a constitutional right to go door to door and sell. But what we do believe is there's some very good provisions in the bill that would direct that, be directed towards that, and then additionally, we think there has to be some sort of Bill of Rights protections type things that are in law for example, third-party electric suppliers. We're not looking, I have no use for third-party electric suppliers and their door-to-door sales taxes because I don't believe there's a lot of value in that market, but that's another discussion. There is, solar's a product. I'm more interested in saving solar companies from themselves with third-party agents that they hire that go out and say and make representations that are not accurate. I've had people come to my door and say, you're going to get free electricity for the next however many years. And I just know that not to be the case. So they're good products that we need to put some guardrails on so that, the representations that are being made are accurate. In addition to alleviating the concerns of older people about who's coming around the neighborhood and why. So there are two issues.
So that makes sense. There's two. I get that. Is there currently now, and I have to admit that I scanned that bill because I had other things, but is there any extra protection for signing on with somebody that's door to door? You know that sometimes when you buy things in Connecticut, they give you 3 days to opt out or cancel. If you're in a high pressure situation, we have rules. Is there any rule at all? Some solar person comes around and they get you to sign something or do something, an older person, whatever. Is there sort of a cooling off period where they can get out? And do you think, I know that might be true, by the way. We were discussing it, Senator, for contractors. Remember when they come door to door about sort of an opt out, a 3-day opt out or something like that?
I know there are some provisions in states, and I'm not a lawyer, and I'm just basing this on various testimonies I've given over the years, but there are some areas where contracts have the like a 3-day right to cancel. And I know we made sure we codified that in the Bill of Rights around third-party electric supplier solicitations, where there is a 3-day period in with which you can cancel the contract. You know, getting written contracts and list of terms and conditions within the contract when you enter into one of these agreements with a supplier. So, you know, those are a lot of the things that we think should be.
So you're saying that that currently isn't?
I'm not
the rule?
100% certain if it is in existence.
Would
with
that satisfy some of the concerns of AARP? If we
Some
were
of them,
to come up
yeah,
with some sort of
absolutely.
scheme where A, there's transparency, and B, there's an opt-out after a certain time? You have to provide the notice? And it's 3 days. And it's 3 days. So that's for
Yeah.
everybody. That's in this bill here?
And
Oh,
what
so
I'll
that's
say
the good
is
part.
there is, again, we have many things in this bill that we like. And I have somebody with a lot more knowledge than me actually reviewing it, and the initial review of the bill, there were some concerns about how some of the language was written, that we will make recommendations for tightening it up. And then a few areas where we think there could be a few other things that would strengthen the bill. On the whole, it's a good bill.
Okay.
You know, we think there's some areas which it should go farther, but by no means are we looking to ban the sale of solar products door to door. But I think when you put all of the things together, you know, it addresses both concerns. You know, Representative Linehan brought up some very good things, important measures about, you know, the fact that somebody could be coming to just get your information. Right. There are those predators out there that are doing that are not employees of the solar company or their third-party agents. That's one bucket of problems. Then there's and so, you know, notifying the police and all of that and the do not knock, you know, that'll all help to some degree. But there are also issues around the representations that third-party agents that are indirectly working for solar companies make when they go to door, and that are just simply not accurate. And then there are vulnerable people that get into contracts that they might not otherwise get into if they had accurate information. So I think that has to be addressed as well.
I appreciate it. Thanks for coming out today. Thank you, Mr. Chair.
Any question? No? Okay, great. Thank you very much.
Thank you, guys.
All right, next, Megan Smith.
Hi, good morning, Chairs Maroney, Lamar, Ranking Member Rutigliano, and the members of the General Law Committee. My name is Megan Smith. I'm a Right to Repair Associate with U.S. Public Interest Research Group, here today representing PIRG. PIRG is a nonprofit consumer advocacy group with hundreds of members in the state, and I'm here today to testify in support of Senate Bill 3, specifically for the right to repair for consumer electronics, which is Section 3 of the bill. When an electronic or appliance breaks, you should be able to fix it. If you own it, you should be able to choose where you'd like to get it fixed or fix it yourself. This premise has been threatened in recent years as manufacturers have employed restrictions on the parts, tools, information, and software access needed to repair the things we own. The right to repair would require manufacturers to share the repair materials that they have. When manufacturers only provide repair materials to authorized servicers or don't provide them at all, they can name their price to fix devices or refuse to, inflating the cost of repair and pushing us to replace our devices instead. U.S. PIRG Education Fund's 2023 report found that on average, we spend $1,767 per household on new devices every single year. If we repaired our products and extended their lifespans by 50%, including the cost of those repairs, it would save $382 per family, or around $545 million across all Connecticut households every year. Repair would also make secondhand technology more affordable, accessible, and it would help bridge the digital divide. Repair restrictions also hurt independent repair businesses who struggle to serve their customers when they can't access basic repair materials on fair terms. After talking to hundreds of repair shops across multiple states in the country, including in Connecticut, I've heard firsthand how difficult it is for these small repair businesses to get what they need, fix devices, and help their customers and community. The bottom line is, when manufacturers monopolize the repair process, repair costs go up, choices go down, small businesses are hurt, and we replace things much faster. This causes cascading effects for the environment and for everyday families and businesses. Right to Repair has already successfully passed in 5 other states, and we urge you to pass it in Connecticut as well. Thank you.
Great. Thank you very much for your testimony. Are there any questions? I guess I'll just ask, of the 5 other states, which state do you think has the best model?
So far, the strongest bills have been passed in Oregon and Colorado. But all of these bills have been super beneficial in protecting the right to repair electronics.
Great. Thank you very much. Seeing no further questions, thank you for coming to testify before us today. Okay, next, Paul Tarbox.
Gonna phone a friend.
My name is Paul Tarbox. I'm the Director of Public Policy and Communications for the Connecticut Council on Problem Gambling. I'm joined by Val Tibbetts, who is our helpline manager, who can speak to all things helpline. We're here on behalf of Diana Good, who's our executive director. Unfortunately, she couldn't be here today. We wanted to provide testimony in support of 1464, specifically the toll-free number provision, as well as 5269 and 5271. We understand some of the challenges that have been kind of brought up, but we support the intent behind the restrictions for joint credit cards, as well as prohibitions on financial incentives to continue gambling. At this point, I'm going to kind of kick it over to my colleague to really kind of explain some of the challenges we're dealing with kind of on the helpline. Just pull your mic and press that button. Yep.
Is that the button? Hi, I'm Valerie Tebbets. As Paul said, I'm the helpline manager for the Connecticut Council on Problem Gambling. I answer Connecticut's 24/7 problem gambling helpline. I've done it for about 4 years. I used to, before the advent of online gambling, do it almost 24/7, 7 days a week. Once 3 years ago when that happened, we really had to start to look at our business practices, because the amount of people who actually do call about their online accounts for my size is a lot more than it might feel to DraftKings and FanDuel if you think about their size. We have 3 or 4 people who answer this helpline, and it's easier for me to respond to what they have said, which is, as critically important as it is for us to have that 1-800-GAMBLER or Connecticut's dedicated helpline, which we run ourselves, it is also really critically important for their customers not to be calling our helpline. The amount of confusion that happens on their websites and on their marketing materials is a lot more than I feel like has been represented here today. People for whom English is not their first language are in fact one of the dominant groups that we get phone calls from. When you redirect someone to chat or email, and they don't speak English very well, or they don't read English at all, it's very challenging. The other issue that's true is it is often, I would say, more underserved, less educated communities who are calling us. They're not reading, they're not paying attention. And I think that I have no interest in whether or not they answer a line, or whether the line, like such as the one they currently have, just redirects people to where they need to go. I just don't want it to be my job. Our priority is to respond to people with problems. And it is really difficult to have that be your priority and feel like your customer service for the industry. We have a historical relationship with the casinos and the lottery and simulcast in this state. They have numbers where we can redirect customers to. That's all we're asking. What happens at the end of that number is their business practice. It's not my job, but I do think that Connecticut and New Jersey got caught in the industry standard because we've had relationships with the industry for all these years, and our business practices have been affected by the advent of online.
Okay, thank you very much, Representative Vitigliano.
Thank you, Mr. Chairman. That was a very reasonable, I feel personally, that was a very reasonable request, what you just made. You're saying that if the gambling sites had an 800 number, it doesn't even have to be a human. It could just be, hey, if you go to www whatever for your customer service complaints. I think that's fair. I have a lot of questions, and you and I, we've talked, we had that little forum where I think I got a lot of them out, so I don't want to waste too much time today. But your funding for your group comes from the casinos themselves, correct?
Correct.
Can they stop funding your group and give it to a different group
So
tomorrow?
According to the original intent of the bill, each institution is required to give $500,000 towards problem gambling, either to an agency or a nonprofit.
Okay.
Both casinos have chosen to give a portion of that requirement to us.
But they could they choose somebody else if they felt like it?
In theory, yes.
So I don't want to step on Paul, but we're funded by DEMAS to run this helpline.
Okay.
So however the money's coming through the state, we have a contract with DEMAS to answer this helpline. They could at any time give that contract to somebody else.
Demas could do that.
Yeah.
That's what you're saying. So you're
DEMAS
saying that
could
a level of
probably
protection.
do it too, yeah.
So I'm just going to ask, only because I feel I've asked enough questions of the providers today. Was there anything that A, I missed, and B, can you refute anything that they were talking about? Do you have a different perspective on any of the answers that they gave today?
On any of the bills?
Yes, on any of the questions of the back and forth that's been going on.
No, I think we can kind of follow up with you if there's anything specific that we've kind of heard with it. But at this point, I think we'll just kind of leave it.
Can you answer the question of whether or not there is a limit for credit cards on daily gambling online as opposed to the casino where you can get a cash advance? So at a casino, there's a cash advance. I think of what's on your credit card standard $500 or an ATM card's $500. Online, is that same limit apply to your knowledge?
Again, we're not actually a credit card kind of purveyor, so we can't really tell. That's usually an agreement between a person and their credit card company. Val, you've had
I don't actually know the answer to the
Okay.
legal limits. I do in the casinos because I was a casino gambler.
Okay.
So I'm very familiar with how it works in the casinos, but I do know that from the helpline, the amounts of money that I hear people have lost. Now, that doesn't make it accurate, but they're reporting like in a weekend. I'm not talking about, over
Understood.
the lifetime. They kind of make me wonder, where did all that money come from? Like, how could you have lost $10,000 in a weekend? I don't know that that's accurate. I just want to say that I think that anyone with a gambling problem will find a way around limits. So it's hard for me to know what they are.
How do you handle somebody who English isn't their primary language? How do you handle? Do you have the capabilities of helping those folks if they call the 800 number?
If they call for a gambling problem, yes, we are a part of the 1-800-GAMBLER is the national helpline, and we also have our dedicated Connecticut helpline, but we're a call center for national. So we have access to 24/7 language line services funded by the National Council. We get that. So if someone only speaks Spanish, or only speaks like 143 different languages, I have a number I can call with them on the line and get an interpreter. I do not do that for customer service calls.
I understand.
Yeah.
I'm going to turn it over to somebody else, Mr. Chairman. Thank you very much.
Senator Ciccarello.
Thank you. I just have a couple of questions. You made a point about people spending a lot of money in a short amount of time, and they're calling you, talking about it. Do you see a situation where individuals that realize they have a problem, trying to correct that, maybe counseling, other processes, trying to stay away from it, and whether it's a casino, whether it's online gaming, they're marketing them maybe more or less, and if there's a way for them to get off of these lists, I just heard some stuff recently about it, and I was curious. You might be the people to explain that.
So I'm actually not, because I want to respect what I heard the industry say today, because I don't know for online gaming what is true anymore. As I said, I was a casino gambler. I'm very familiar with casino gambling. If they say that you can opt out of it on their Responsible Play website, I choose to believe them. They tend to. It's a lot harder to get out of marketing, though, than it may seem. There's always a delay. If you think about taking your name off any mailing list, there's going to be a delay. And My experience in the problem gambling world is enticements are a gigantic issue for people with problems. It's, you don't have any money left, but you know, you got $50 in some kind of free play or free bet and you're chasing. And chasing is one of the really indicators of a problem.
Sure.
It's a big enticement and it's really hard to get people to, for example, exclude themselves or sign out because they don't want to lose their free play. That is traditionally true.
Sure. And I could see, especially with the online gaming platforms, that's must be a real challenge to try to minimize the temptation, right? But some individuals who, and maybe you can speak to this part a little bit better, that may go to the casinos to gamble, you know, you have to go there, right? So if you stay away from there, the temptation may be less. But have you seen circumstances where individuals may have went to the casinos and said, hey, listen, I got an issue. Don't let me in here. And they're still getting maybe emails from the casinos, and I'm not attacking casinos, I'm just trying to understand this a little bit more. Or they're getting, you know, if they had what is that called? You get somebody that helps you, a liaison when you're gambling.
They're
No.
hosts. They're
Hosts,
casino
there we go,
hosts, yeah.
okay. They should have counselors there, right? Get a host or a counselor. But if they have a host and they're reaching out, calling them, do you see that, or is it?
Not with host services. Usually if somebody has attempted to exclude or stay away. I mean, I know hosts do reach out. I really want to say, I mean, in terms of the casinos, the people who work for the casinos, I believe, the individuals who do host or player stuff or marketing, they don't want people with problems. I believe that sincerely. And I think that's probably true of the online vendors too. So, you know, I'm a very staunch supporter of let's support an individual's responsibility to get treatment and get into recovery. We cannot put that responsibility on the industry, even though you guys are charged with putting laws in place to support your citizens. We still have to, at some point, have the responsibility be on the individual. So, and I do think marketing is a tough one. I can just say, you know, like I'm going to repeat, no marketing disappears overnight.
Sure. And that's kind of the point I was trying to make. Just such a big agency or company that, you know, they go in and say, I don't want to be here anymore, that if there is a delay, or maybe they're not communicating, and if it's a host or if it's getting offers for a free toaster, free play or something, that if that's happening, and just how we could expedite that quick shut off of the temptation. But I really appreciate you answering the question.
Yeah, and I appreciate, you know, your intent to do that. I do think that, you know, that's one of the big benefits and the resources that are intended for the helpline to do is to support that person and not have that happen so that we are available to them. And that's part of the intent of, please don't make us take any more time being customer service. We want to do that.
Got it.
Makes sense.
Yep, absolutely. Thank you so much.
Great. Thank you very much, Senator Ciccarelli. Representative Yacarino.
Thank you, Mr. Chair. And Paul, good to see you. And just a question, I mentioned it earlier. So you meant there's like, if you're a Chase gambler, if you have a credit card and you could have access to other credit cards and you have credit, you could actually build that card up to whatever your limit is. But I had mentioned earlier, if you have a debit card and you only have $1,000 in your account, you can't spend more than you have in the debit card. So I would, in a perfect world, it'd be 24, 25, or between 21 and 25, you'd have to have a debit card, not a credit card. And I know that, you know, that's for further discussion, but I would think that would solve a lot of the problems. You might not agree because you had said, if you're a chaser, you're going to find that money somewhere. But if you run out of money, you can't gamble any longer.
No, I actually do agree with you.
Oh, good.
If you're asking my personal opinion, of course,
I
agree
think
with
that's
you.
the way we should go. And I supported this legislation a number of years ago. And unfortunately, you know, there are problems, and not blaming anybody. The fact is there are problems because I mentioned earlier, you know, when I was a young guy, me and my buddies we wanted to bet. We didn't know anything about it. We started betting. And when you ran out of money, you ran out of money. But if you had access to more money, you would keep betting. You would call Chase. And that's a dangerous scenario.
It's also a technique used in recovery for people who want to mitigate their gambling, which is don't have access to more money than you have.
Right.
Just, you know, because not everybody stops entirely. But, you know, while I agree with you, that was a personal comment, not something, I don't know that I would advocate for it because I don't know how possible it is in this world. You know, I'm a pragmatic person, right? So,
I get it, but if the statute, well, if we put in language, you could only use a debit card, it makes it, I think, a little safer. And it makes you stop and say, you know what? I work really hard for my money. Maybe you don't think that way when you're younger, but when you run out of money, you run out of money.
yeah, I totally agree.
I would hope.
I agree.
I would hope we get to that point. I'm not knocking DraftKings. I've never gone on any of those sites, but the fact is, it's just so enticing for a young person, especially a young man. That's all I wanted to say.
Great. Thank you very much,
Thank you all for
Representative
being here. Thank you,
Iacoino.
Mr. Chair.
Just wanted to build on a few things that Representative Vitigliano had said earlier. One that and I don't know if you need to comment or not, but you raised a very good point that just because we're requiring them to have a number doesn't mean we're requiring them to have a live person answering it. I mean, there is the use of technology where they can take their existing chatbots and through voice recognition, just transcribe everything and run people through the process. So I think that's was a good point raised by Representative Vitigliano. And then to go back earlier, I know you saw when I was questioning on this, Representative Vitigliano had raised the use of algorithms and advertising. I guess, what would your thoughts be on one, helping us to publicize the right to opt out of targeted advertising for the different gambling sites? But two, I wonder, oftentimes, it's required that to give people the right to opt out of advertising. It's usually a very small at the bottom of the page. Would you think that we should make a requirement that that right is published closer to maybe right near where they put the problem gambling number, and requiring a larger font so it's more obvious for people coming there that they have that right to opt out of that targeted advertising?
I don't think it would be an unreasonable kind of ask to make sure that it's more recognizable or in several locations. But in terms of your request, the Connecticut Council would be more than happy to help kind of promote that, as well as use our kind of website and social media pages about the opt-out.
Great.
Yeah, I also think that if that existed, it would, like, the thing about the problem gambling helpline is we kind of have to have all this information about all these sites, and it would be great for us to have that available to people who are looking for that, because it does happen. And it's like, I've even had it happen more than once that somebody was deceased and their family member wanted the marketing to stop. It's marketing in this world. It's not unique to the gaming industry, but that would be great to have that available.
Great. Okay. Thank you.
Chairman, if you don't mind, just to follow up on his good question was, if somebody does opt out, can't they just go back and opt in, or is it a hard opt out? What's the process? If somebody's having a problem and they recognize they have a problem and then they go and they opt out, can't they just simply click the box again and opt back in?
So you have to define what you mean by opt out in order for us
Well,
to answer that.
The advertising versus the exclusion list, I think, because when you put yourself on the gambling exclusion list, it's a set amount of time, correct? That you have to stay on that before you can get off of it.
Yeah.
And I believe you're referring to the opt-out for the targeted
I
advertising.
guess I'm referring to either one. So I wasn't aware what you just said. So if somebody opts out of, I don't want to be able to gamble, there's a time limit to that before they could even think about opting back in?
So there's a lot of different ways you can opt out. That's why I said you have to define it. So the voluntary self-exclusion that's managed by the Department of Consumer Protection in the state of Connecticut, that is mandatory. It's a year at a minimum. You choose it, but you don't get to reverse that. The casinos also have irreversible processes available. Online is DCP, but online they've referred today to responsible play guidelines. So you can go in and you can cool off for 30 days. Say
You select the 30-day
you
cool off?
select the 30 days, you
So-
select to cool off because you feel like, for one reason or another,
Yeah,
it's taken
but then
time out.
you're automatically allowed back on. It just sort of disappears after 30 days. And to the good senator's point, if somebody opts out of the advertising, or a promotion, whatever help he was looking for from you guys, if you would help participate, can't you just simply go back in there and click the box off so you start receiving ads again? I mean, there's no real, when you self-exclude, you're dealing with somebody who maybe have some self-control issues or other issues, but now you're asking them not to go back in there and let them allow themselves back in, I guess was my question and my point at the same time.
It's almost better for the industry because I don't exactly understand the timing between maybe their security, which does exclusion, and marketing. You know.
Yeah, I believe that they, through the data privacy laws, they would have the right to opt back. So if they opted out, it's not a permanent, they would be able to opt back in. So, yeah. Yeah. So, okay, are there any further questions? Okay, hearing none. Thank you very much for coming to testify today. Next, Valessa Suter Klein. You could just press the button in front of you. Yep, red light's on. Please proceed.
All right. Good afternoon, I believe. Chairs Maroney and Lamar, Ranking Member Rutigliano and Chigarella, and members of the committee. Thank you for the opportunity to testify today. My name is Valessa Suter Klein. I am the Northeast Regional Director for the Solar Energy Industries Association, which I will refer to as SEIA henceforth. SEIA is the National Trade Association for the U.S. solar and storage industry. We work with our 1,200 plus members to grow American jobs, empower customers to take control over their energy future, and also to promote responsible growth in our industry. Our members include not just developers, but manufacturers, contractors, and other businesses who support residential solar and storage installations in Connecticut. So we have a wide member base. As you likely know, solar remains one of the most popular energy sources for families and businesses in America. Our polling shows that solar consistently does well. People like solar. And we anticipate that it will continue to grow because we are saving people money. So with that in mind, SEIA has been working very hard to increase sort of standardization and customer protections to ensure that our industry can grow successfully. So to that end, SEIA has published consumer education guides, developed model contract disclosures, built industry compliance tools, and we are in the process of finalizing ANSI standards, ANSI national standards for salesperson training, savings claims, and installation practices. We are also part of the Consumer Protection Task Force that came out of the last legislative consumer protection discussion. That task force was not convened, but we were very excited to work on this issue with Connecticut, and so we can remain in that position. Today, I want to talk about HB 6052, which will surprise no one. SEIA strongly supports the intent of this bill. However, we do have some areas of concern, and we feel that amendments would strengthen the efficacy of the bill and while ensuring good customer service and continued solar deployment. The one thing I want to mention just in response to previous testimony is that there in the bill, but also under existing Connecticut contract law, there is a 3-day cooling off period. Solar contractors are contractors. We have to comply with contract law in Connecticut. So there's already a number of regulations in place that cover that, but we also support the additional protections in this bill. I'm not going to use my time to go through every slight amendment that we would like to see. I'll submit written testimony, but I did want to mention just a couple of clarifications. That's what I was expecting. There are some areas where we think more clarity could ensure that, like, for example, we think DCP should develop a standardized solar brochure rather than having each company develop a brochure. And so there's a number of examples that my members will touch on later that would streamline and make sure that the bill accomplishes what it sets out to do. So I'll stop there.
Just one, if you don't mind.
Great. Thank you very much, Representative Rutigliano.
Just a quick question. What is the primary sales method that your members, because you're an organization, right?
Correct.
Is it door to door where they get most of their customers, or is it standing in Home Depot? Is it people calling up on their own?
Our members include sort of everything from utility scale to residential. I don't have the statistics on that. I do know that some door-to-door sales are very helpful to the industry because it's helpful to see individual, you need to see energy bills, and people don't generally know where they are. It's much easier to do that door to door.
Are there any particular training requirements that a door-to-door salesman has to go through, especially if they're evaluating how much solar you need to put on a roof?
So that is, SIA has been working on standardization practices for that. The ANSI standards would cover that, which are in their national standards that are close to finalization. I can check the.
But not currently.
I don't know the answer to that in Connecticut. There may be.
Thank you. Thank you,
Yep.
Mr. Chairman.
Are there any other questions? I guess, I know you haven't submitted the written yet.
Yeah.
You're going to submit that. I guess, would you just prioritize for me? Like, what do you think are the most important changes we need
Absolutely.
to make? And so just, the solar protections, we looked at what they have in Illinois, Massachusetts, and Connecticut and tried to add in what was missing, right? What Illinois and Massachusetts had already done. So just to
And
let you know that.
we appreciate that. And there is starting to be some consistency around this, which is incredibly helpful to the industry many companies work across states. So a couple of things. There's one section that requires, it's just a little bit unclear whether the requirement is to disclose or register the list of names of every employee of every business selling solar services, or whether it's just to list the businesses themselves. We think the intent is businesses, but we wanted to clarify that. I mentioned the brochure requirement. We just would like to see a brochure developed with stakeholders and standardized. And then there's a note it came up earlier, actually. There's a 10-day municipal notification requirement. And our concern there is simply that it duplicates efforts that are already in place in some municipalities and would just add confusion. And there are a few other things that others will touch on that I'm not thinking of at the moment.
Okay, great. And back to the standardized brochure. I mean, I know you suggested DCP. It seems to me it may make more sense in Connecticut for the Office of Consumer Counsel or
Sure,
PIRG to work with
yeah.
DCP, or is there any objection to that?
I don't believe so. I think, we and stakeholders is the language we used because anyone who's would like to be involved. Yeah.
Great. Okay. Thank you very much. Are there any further questions? Okay. Hearing none. Thank you for taking the time to testify. Okay. Next, Nick Teeling.
Senator Maroney, Representative Lamar, Senator Ciccarella, Representative Retigliano, and esteemed members of the General Law Committee. My name is Nick Teeling, Advocacy Director with Connecticut Voices for Children, a research and advocacy organization working to ensure that one day Connecticut is a thriving and equitable state where all children can achieve their full potential. CT Voices supports raised Senate Bill 1463, an act concerning disclosures, payments, and revenue transfers by the Connecticut Lottery Corporation, which deposits revenues from iLottery, as well as lottery revenue from the online sports gambling into the Early Childhood Care and Education Trust. In short, we support Senate Bill 1463 because early childhood, if deeply invested in, has incredible societal and economic returns. However, early childhood in Connecticut needs a whole lot more resources in order to meet the ROI potential. While there are other components of the bill, our testimony speaks to the early care sections. Specifically, we appreciate that the committee is continuing the legislature's good work from last year by resourcing the Early Childhood Care and Education Trust with a consistent revenue source. We know that ECE is good for children and their lifelong success, parents and businesses, including ECE businesses, who rely on care and able to work, and help stimulate our economy overall. Early childhood opportunities provide the foundation from which kids learn and grow. Children that receive high-quality ECE are more likely to perform better in school, retain gainful employment, and are less likely to be incarcerated. The foundational building blocks of ECE are even more pronounced for children in low-income families, dual language learners, and children with special needs. Unfortunately, high staff turnover, staff shortages, and a declining number of childcare slots are all the results of low wages and tenuous revenue margins. In our most recent State of Early Childhood report, CT Voices modeling found that childcare centers who rely on Care for Kids supports often don't break even, and owner-providers of family childcare homes are often making less than minimum wage. This is because providers are put in a tough choice of increasing tuition on families who can't afford it and foregoing needed income. Connecticut falls in the top 5 states with the most expensive childcare, and it's pushing parents into poverty. In fact, in CT Voices research, we showed that work-related costs such as transportation and childcare were the 3rd largest contributor to poverty in 2022. Better wages and benefits are crucial to attracting and retaining EC professionals, and given the current economic climate and with lingering inflation and tariff uncertainty, policies that advance increase affordability all around for Connecticut families, many of whom are EC professionals, are going to be critical. For these reasons and more, we support Senate Bill 1463, urges passage, and thank you for your time, and would happy to take any questions.
Great. Thank you very much. Does anyone have questions? Okay. If not, I'll ask you some. So I would say one of the things, and feel free to say you'll get back to me on this because I did, but you know, one of the issues, right, with the early childhood, we need hundreds of millions versus this bill could potentially generate the tens of millions. I would say we need to figure out how we are going to prioritize and who would decide where the money goes. Do you have suggestions now, or could you get back to us on how we would establish a process for choosing the innovative and transformative? I think that's what we would really want to focus on, innovative and transformative ideas within childhood, early child care, but I don't know if you had any ideas.
Well, thank you for the question, Senator. There's a lot of proposals in front of the General Assembly this year across many different committees that would help resource early child care, including the governor's budget, which puts an enormous investment into a preschool endowment trust. We're hoping that there's also innovative ways to bring along birth to 3 as well. Connecticut has been a nationwide leader on birth to 3 in the early care space. We want to make sure that is also equitably resourced as well. So, but happy to continue the conversation on other innovative ways to continue to fund early care.
Thank you. So, and right, and I think this is not an either or, it's a both and, right? This is an all hands on deck moment. So interesting. I mean, do you think then that given that there are other areas that may be prioritizing the 3 to 5, that we should be focused on the birth to 3 within this fund, or potentially something to explore?
Potentially something to explore. I mean, I think it's about being critical and making sure that we understand completely resourcing early care in Connecticut is not just about birth to 3 or 3 to 4 or 3 to 5. It's birth to 5 because those 5 years are so crucial to the development of children long term.
Great. Thank you very much. I don't have any further questions, and I don't see any others. So thank you for taking the time to come testify and for your advocacy.
Thank you, Senator. Good to see you.
Nice seeing you as well. Merrill is not. Okay. Next, Merrill Gay.
Good afternoon, Senator Maroney, Representative Lamar, Ranking Members Ciccarella and Rutigliano. Members of the General Law Committee, my name is Merrill Gay, and I'm the Executive Director of the Connecticut Early Childhood Alliance. For more than 20 years, the Alliance has brought together organizations that care for and about young children to work for policy change. I'm here today to support SB 1463. I think we all know Connecticut is a high cost of living state. It's really hard to raise a family on just one paycheck. So childcare is increasingly a necessity. And yet across Connecticut, families struggle to find and afford early care and education for their children. This week, a father from Hartford called me trying to find care for his 2-year-old. The only place he found that had an available spot was going to charge him $525 a week, far more than he can afford. Most early care programs know that parents can't afford that and don't charge that much. But as they bump up against what parents can afford, they have to minimize their costs. So in many cases, they aren't able to pay their staff much more than minimum wage, and many don't offer health insurance. That leads to high staff turnover and reduces the quality of care that young children are receiving. So to summarize, childcare costs too much for families. It doesn't pay early educators a living wage, and there just isn't enough of it. Former Secretary of the Treasury, Janet Yellen, described childcare as a textbook example of a broken market. When the market's broken, the government needs to step in. So last year, the General Assembly passed House Bill 5002, which created the Early Care and Education Fund to make those needed investments. Unfortunately, we didn't put any money into the fund. So this year, there are several proposals to deposit unappropriated surpluses into the fund, and that's great as long as we have a surplus. I'm here today to support Senate Bill 1463 because we need a dedicated, dependable funding stream to support this important work. This bill would intercept lottery money and put it into the fund. And I hope that you can support it. I'd be happy to answer any questions.
Great. Thank you very much, Merrill. And I think you highlighted, right, the broken market, $525 a week, so over $25,000 a year. And I know in my district, one of the childcare centers, the lead teacher has been there over 20 years and makes $19 an hour. So we're charging families too much, or more than they can afford, not too much, because there is a cost to providing the service, and not able to properly pay the early childhood educators. So I agree, we do need to government needs to step in and intervene. I guess, if you heard my questions with Nick before, do you have ideas on what we should prioritize with this, or how, more importantly, how do we include the voices to determine who should be prioritized by this fund?
Yeah, it's really clear that we have an enormous shortage of infant toddler care in the state. There's currently licensed spots for 1 out of 3 children under age 3. And that varies widely by town. In wealthy towns, you've got an adequate supply. In a poor city like New Britain, there's only 1 spot for every 8 children. And that's because parents can't afford the market rate, and the market responds the way markets do. If there aren't paying customers, they don't provide any supply. So that's a place where we all understand there's a huge problem. One of the things that's really interesting about the governor's proposal is that it would have a community planning process where parents and local leaders would identify what are the problems and what are the assets in the community that could be brought to bear in addressing the problem. So a system that involves local communities in figuring out what are the most pressing issues for childcare, as well as a dedicated funding stream to make it possible to meet those challenges going forward. I think both of those are very important.
Great. Thank you very much. Seeing no other questions, thanks for taking the time to come testify today, Mayor.
Thank you.
Next, David Goodfriend.
Hello there. Can you all hear me okay?
Yes, we can hear you. Please proceed.
Thank you. Good afternoon, Chair Maroney, Chair Leamer, distinguished members of the committee. My name is David Goodfriend. I'm here today on behalf of Sports Fans Coalition to express our strong opposition to the price caps proposed in HB 7182. I wanted to be with you in person today, but my flight this morning was canceled, so I'm coming to you via Zoom. I founded Sports Fans Coalition back in 2009 as a nonprofit grassroots advocacy group with the mission to represent fans wherever public policy impacts the games we love. We're the ones who got the Federal Communications Commission to end the sports blackout rule in 2014. We drafted the Sports Bettors Bill of Rights and got it enacted in 4 states. And we testify in state legislatures like yours across the country, supporting fans' ability to buy and sell their tickets freely. We applaud Connecticut for being one of only 6 states that expressly protect ticket transferability. Fans in Connecticut have the freedom to buy and sell tickets from each other. We also support most of the bill before you today, HB 7182, which adds really important consumer protections. But we have problems with the proposal to cap resale prices to 25% above face value, and the proposal to penalize consumers with a fine of $5,000 if they earn even $1 above that cap. While I understand the intent to protect fans from high prices, these measures in reality could end up doing more harm than good. We all agree that high prices hurt fans, and we're living in a time of inflation. Americans are feeling that pain, especially middle and lower income families. Sports leagues and team owners are among the worst when it comes to jacking up prices on everything from tickets to parking to merchandise. And it's getting to be that ordinary working families just can't afford to go to the games at all. But price caps don't address the big elephants in the room: abuse of market power by ticketing and sports league behemoths. Price caps on ticket resale create unintended problems and tend to hurt fans. Let me give you some examples. Consider the fan who buys season tickets and sells a couple tickets to the big game in order to defray the cost. Think of season tickets to the Red Sox and you sell the tickets to the Red Sox Yankees game in order to defray the cost of your season tickets. Well, if that fan can't sell her tickets above face value, she no longer can afford her season tickets at all. Or consider this example. Somebody goes out and buys a ticket months in advance and then finds out they got to sell it later because their kid got sick, or maybe they lost their job and they need the money. Suddenly they're prevented from doing so and selling it at market value. That's not fairness. That's an economic penalty on fans. Now, balanced against that pain that I just described for fans, we found there really isn't that much benefit to consumers when you actually have a price cap in place. There have been plenty of economic studies on this that showed when a price cap was repealed, there was no increase in resale ticket prices compared to states that actually kept the cap in place. What we did see when caps are repealed is that there's an open market, allowed fans to buy and sell tickets more freely, often below the original ticket price. Let me drill down on that point for a second.
Actually, your 3 minutes are up. Would
Oh,
you
sorry.
summarize?
Sure. Happy to answer any questions.
Best summary I've ever heard. Thank you very much. Are there any questions? Okay, hearing none. Thank you for taking the time to testify. I'm glad you were able to get on and testify, even though your flight was canceled.
Thank you.
Okay, next we're going to go back. I believe Kyle Innes is available to testify.
Hello, thank you. First, I just want to thank the chairs, vice chair, and committee members for giving me a few minutes to talk today. I'm here with the Securities Industry and Financial Markets Association. We represent the brokerage industry across the United States, including 110 broker-dealers that have their main offices in Connecticut and 22,000 securities industry employees in the state of Connecticut, as well as the tens of thousands more that are licensed to do business in Connecticut. And I'm here today to talk about Section 1 of SB 3, specifically related to the fee disclosures. While SIFMA doesn't have any concerns with the underlying objective of this section, absolutely understand it. We are concerned with how that could interact with the brokerage industry. And our main issue is that for our industry, the share itself is generally considered the good that is being sold. And so while we are regulatorily required to find the best price for a customer when they say, please buy X shares of this stock, we do not have a way to actually know the price, the full cost of that good until the confirmation of the trade. Of course, SB 3 would require the total cost to be given prior to the purchase being made, which would be the confirmation of that trade. So we're just here today to ask for similar treatment to that Section 704 exemption, and for that to be expanded to include the Connecticut brokerage industry as well.
Okay, great. Are there any questions? Okay, and I believe you had submitted written testimony, correct?
We did, yes.
Okay, great. So I can reference that. All right. Thank you very much for coming to testify.
Thank you so much.
Okay, next, Emmanuel Data. Okay. Together, yeah. Next, Mohammed Hossein. Okay. All right, next, Don Vaccaro, Bruce Morris, and Christine Dennis. Bruce, would it be okay if you came up together? Let's see, we have. I'm assuming you're all testifying the same way, unless there are some internal squabbles you're going to air today. Okay. Is Don online? Yeah. Former Representative Starworth, would you like to come up as well? Come back and join us. Yeah.
All right, I think I'm on. Can you folks see me?
Yeah, we could see and hear you. Please proceed.
Great. So I've prepared written testimony, which I've submitted. There's no reason to read it back in the record. I want to thank you folks for allowing me to testify. Chairman Maroney and Lamar, the ranking members and the members of the committee. My name's Don Vaccaro. I've been in the ticketing issue in Connecticut since the 1980s, and Connecticut always seems to be is a hotbed for the ticketing industry, and where some legislation originates that is copied, throughout the country. Connecticut has a long history with ticketing issues, and nationally recognized Nobel Prize winners who came in to testify right in the General Law Committee about this subject, which really put Connecticut at the forefront. So, in saying that, I think this is a good start to get these issues out into the open of what we need to do. First, I want to say that we believe that Attorney General Tong's position on the all-in pricing is correct, and we believe, if I'm correct, that he's just trying to clean up that legislation so that it really applies to what consumers want. Meaning that as a consumer looks on a website, on a display, that ticket price that they see travels through the whole process, and that's actually what they pay. It's about transparency, and it's about consumers easily able to price compare, right? I can't price compare a cell phone. There's no way I can do it, right? Because of all the hidden charges. I can't price hotel rooms. I can't price this, but tickets is something that consumers should be able to price quickly because of the perceived scarcity of that ticket disappearing. I'd also advocate, which is not on the bill, that this also applies to movie theater tickets as well going on there. As far as price caps, look, price caps don't work. We had in the 90s, Nobel winning economist Robert Shiller was testifying in the General Law Committee on how those price caps do not work and are detrimental to the marketplace. And what we've seen is, since the free market came, we've seen like the major league sports franchises sell billions of dollars of tickets directly to ticket resellers, to ticket brokers for their season tickets, yet no one really knows about that. And that stabilizes the process, and it gets the money to the rightful owners while those marketplaces make less of a fee. And we hope that the state will allow that strategy to apply to concert and comedian performers who are now restricted from doing that practice, while sports teams are allowed to do that because of contractual stipulations in contracts with venues, and venues in the state of Connecticut who have lost entertainment artists from playing the state because of those restrictions. So, I'll end it there. I'll be happy to answer any questions you have or give you any color, light in the situation, anything that I can do that can be helpful. Thank you.
Great. Thank you, Representative Ritigliano.
Hold on. All due respect to the chair, Representative Morris, we want to fix this problem. We've been trying for years on the General Law Committee. We were hoping today that you could come before us and tell us exactly what we need to do to fix whatever edits the bill needs to make it right. And I get the cap and all that. And if you don't like it, just tell us. I don't mean to interrupt the chair, but I know he feels the same way. So what can we do better?
Very good. Great. So I'd start by saying this is consumers deserve a right for a speedy refund and actually a refund for canceled events. For example,
Excuse me, sir, you have Representative Morris sitting right in front of us. I was kind of hoping that if it's all due respect to you, if he could answer the question. Does that?
Okay, great. Thank you.
Okay, to give us a real quick focus here, the bill as it exists, you've heard about the caps that and our challenge with that. Other than that, the elements that are in the bill regarding all-in pricing, you are cleaning up the language and making certain that at this point it meets your intent. So we support it as written. However, when you get to the exclusive contracts, as written, it's about sellers. What we would promote or recommend that the edits are changed, that this would apply to state-funded venues, and it's actually the contract really between the sellers, but you can say between sellers and resellers. And our written testimony gives you the benefits of this, similar to the crypto center in California between the Los Angeles Lakers and the Clippers, different fees. If you ask questions, I'll get it, but that's your quick fix there. Prompt ticket refunds, we're saying should be, no, that's an add-on. Let's see, you had something else that was in here that had to do, primarily the edits had to do with sellers and resellers. The bill as written primarily addresses resellers and not sellers. So those edits make a difference. We would add to this that a requirement that for prompt delivery within 72 hours of tickets. You buy a ticket right now to an event that's 7, 8, 9 months away. You lose your ticket. You have a difficulty trying to get a ticket. Making that change would make a big difference. I'm going to look to my peers. We have our general counsel, Chrissy Dennis, with me because I feel like I'm missing something.
For the specific language fixes, which I believe is your direct question. So I believe we're looking at page 3 in the section that begins on line 66. This particular language deals with the actual refund clause here. And a big component that's missing is that it deals only with resellers' requirement to refund a ticket cost for a canceled event. And that particular language is missing the requirement that a refund is also required from the primary market. So if an event is canceled, right, Beyonce cancels a bunch of events, the primary market also has to refund that ticket in addition to the secondary market, the reseller refunding that ticket. So we are completely fine with the reseller having to refund the cost of that ticket to a purchaser that buys the resold ticket. But under this particular language that's written right here, there's no requirement that the primary ticket master also refunds that money. So that's seems like just an inadvertent miss in this particular language. So we're requesting that the primary seller has to also refund that ticket cost in the event of a canceled event.
Yeah. So ultimately, it's with the exclusivity and the ticket refunds that you're editing and making the same changes. Okay. And all-in pricing again was good, and you heard our 2 recommendations that are in our bill. Okay. Prompt delivery and another on arbitration, forced arbitration. Right now, for a Connecticut resident, if you want to argue a claim or something, you just can't take it to your regular court because it's written in the terms and conditions of the primary sellers, whatever, that you must have arbitration within their state.
Yeah, right. I remember that from last year. All due respect through you, Mr. Chairman, I just have a couple questions about the bill. I was hoping you could help me clarify. But in the meantime, I was doing some research leading up to this. I know the Chairman Lamar always shows his phone where he paid this outrageous price for stuff on StubHub and all this other stuff, all the fees, right? So I went and I was specifically looking at spring training tickets for the Red Sox. Okay. So I went on StubHub They didn't whack me to the fees till I got to the end. They're not obeying the law.
Yep.
I went on SeatGeek and it was an option. I could either have all in or not all in. But in both cases, even with the fees, the ticket was cheaper than it was selling from the Red Sox. So there's some value to the company, but not all of them are following the rules. It's just my personal experience, widespread. I'm just telling you what's going on.
And that's why we're promoting this. We've been asking this of the AG for the last year, and we know he's supporting it because in many states, even in New York, this is not being enforced because they say the language is too ambiguous. The language that you currently have here, it tightens that up and it creates a level playing field for everyone. It meets your intent that you did in the law 2 years ago and again last year.
So if we go through the bill at starting on line 38, number 2, it says no operator or entertainment venue or agent of an operator or entertainment venue shall enter into an agreement with a ticket reseller that provides a ticket reseller with the exclusive right to resell tickets to the entertainment events at the entertainment venue. I wrote a gigantic question mark. Can you explain that in plain English, what that paragraph is trying to do?
So the intent with this particular language, and I believe this is where we were trying to clarify also, that we were aiming with this language to address the monopoly of the Ticketmaster Live Nation. So I believe Mr. Vaccaro spoke about how we were looking to have the state-funded portion put in here, so that way state-funded venues could not have exclusive contracts that were, limiting the ability for other ticketing companies to come in and have an option of opening up the market to have the possibility of different ticketing vendors be able to offer tickets to different events. So right now, you have the Bushnell or you have the Meadows or whatever it's referred to these days. It'll always be the Meadows to me.
Oh.
But you have those types of venues that have long-term contracts that typically have high fees because, they enter into the long-term contracts with Ticketmaster. So we were looking to add language in here that they couldn't have those long-term deals with those particular ticketing companies. So this
But does
language
this
again
language do anything? What does
no,
this language do?
This language again only adds the term reseller and not primary seller. So again, we believe that was
Yeah,
a
because
drafting error, and it again
Okay.
could have that specific primary seller language in there.
Right.
Resellers don't enter into contracts with venues. That's not something that typically happens on the resale market. So this particular language really doesn't have any effect on what that prohibition was trying to accomplish. So you could just add
That's
the
the
word.
paragraph where you want the change,
that's right.
basically.
Li-
Okay.
Limited to, limited
Two
to,
changes.
yeah, 2 changes. Specify this for, it's for state-funded venues and it's the contracts between that venue and the seller.
Understood.
Because
So
that's-
you're saying that
because that's where
there's a
Ticketmaster-
private venue, they kind of get to do whatever they want, is what you're saying. But
Well, we believe,
state funded,
right,
they
that-
shouldn't be able to.
Right. We believe for purposes of this committee that, the state would be able to regulate state-controlled, state-funded venues.
Yeah, and this addresses what the Department of Justice in their suit against Live Nation and their monopoly. This addresses the fact that they historically go to the venues and say, listen, if you want these acts to come through here, you've got to do the contracts exclusively with Ticketmaster and these long-term contracts.
Understood. So if you go to line 51 of the bill, right?
Yes.
It talks about when the ticket is initially offered for sale to purchasers at the display price, you can't increase the price while this is happening.
Yes.
I find, and I don't know if we could solve this legislatively, that I get bounced out or thrown out, or for some strange, crazy reason, I get thrown out of the website, and all of a sudden I go back in and the ticket's more money. When they say the definition of transaction, is this only while you're in there, or is it sort of like, what do they consider one period of a transaction?
So on our website currently, when you go to that website, the price that you see on the initial page is going to be the final price that you will pay.
Right.
And we believe that was the intent of this legislature when that bill was passed. Our competitors are not currently doing that. They have this little modal window, as you described, right, where they make this additional click.
Right.
And because it has been interpreted to be ambiguous, that when you select that ticket for purchase, because you're doing an additional affirmative step, that at that point is where you have to see the final price, that they're allowed to do that under the current way that this bill is, under the current way that the language is currently drafted. We've had this issue with New York as well. So as far as being bounced out, I'm not familiar with that happening. I do know, obviously, that, in the secondary market, the demand, it changes, you know, the price of tickets. And it is very possible that if all of a sudden, you know, there's like a trade that happens and, you know, Leo Messi signs a contract again and, you know, stays with Inter Miami for another year when he said he was leaving. I suppose that could possibly happen. That's never obviously the intent with this particular language. However, you know, we believe that, you know, that's supposed to
Excuse me, I think I can give a little bit more clarity to the legislator's question, and it's a great question. It is phenomenal, right? So primary sellers create a virtual waiting room, right? And if primary sellers have 10,000 people in that virtual waiting room, and they only have 1,000 tickets to sell, they increase the price of the tickets based on the real-time consumer demand. And what that legislator is experiencing is a de facto auction of tickets that's not really disclosed to the consumers as an auction, but it's couched as dynamic pricing. So he's very accurate. Not that many people have noticed that practice takes place. We don't practice that. Most of the secondary market doesn't practice that. But in the primary market, it's dynamic pricing. And it's very similar to what we heard about with Bruce Springsteen playing Tampa. The tickets were $250. But then they moved up to $5,000 in the course of a couple seconds. So that, I believe, addresses the legislator's question.
I appreciate that, and it does address my question. I guess I'm trying to figure out legislatively how we define a transaction. Like, when does the transaction actually begin? So I think it's when you start interacting with the site. And you saw the price, you clicked on it, and then all of a sudden you're just deciding between seats or whatever. I think that's when my transaction begins.
Yeah.
I think the sites think it's a different thing. And I'm sort of looking for language
So
to
if I
get it
can,
closer to what I believe.
And I'd say, Bruce, let me just answer this one. I absolutely agree with you. I don't think that it's possible to codify what you're suggesting. However, if there is a pattern of abuse by a ticket seller that consistently ends transactions during the middle of the transaction to take that ticket and sell it at a higher price to a different consumer, that may in and of itself be a violation of a Fair Trade Practices Act, right? But to quantify it, memorialize it in legislation might be hard, because at sometimes there's going to be connectivity reasons that will mandate that a transaction can't go through. API, system failures, or something like that, where you can't communicate to the end users. And it's very similar with sometimes you go to airlines and sometimes the travel agent can't interface with the airline computer, so the transaction has to be broken and you have to start over again. But I understand exactly what you're saying. I think there's ways to mitigate it, but not perfect it.
So
Sorry.
You said that it's an unfair trade practice, that what the scenario you just described. Are you suggesting that it's current, or do we have to create the fact that it's an unfair trade practice? And then
I would say it would be current. It would be based on the standard that a reasonable person would think that a ticket seller is not breaking a transaction in order to increase that price, is not displaying that practice to the consumer, is not letting the consumer know that that practice is going on, that it very much could be adjudicated under the current statute as an Unfair Trade Practices Act.
So you're saying that we already have a law in the books to protect in that scenario? That's what you're suggesting?
Correct.
But what
Correct.
I would add-
And right. And one of the problems with the whole thing is I think a lot of companies blame business issues on technical issues. And they say, well, technically we couldn't do it, or technically, and it's kind of hard to decipher what the truth is. But yes, I think there's ways to mitigate that. But I would say this, I think that just giving the transparent pricing throughout the whole process, which Senator Tong has said that he'll clean up the language, is probably the most important consumer issue in the ticketing space, not based on me, not based on anyone else, but based on the empirical data that the Federal Trade Commission collected about 6 years ago, where consumers listed their biggest frustration with buying tickets is seeing the tickets at one price and going through the transaction and there being another price at the end. Sometimes those service charges were 50, 60, 70%, right? And it was a real problem because some consumers would say to other consumers, their friends, can I buy them? The tickets are $20. And their friends said yes. But then they went through the checkout and they're 35. And one consumer made a choice to buy it for their friends and then had to explain later to their friends that the tickets were really 35. So that by far has been the biggest issue as far as the number of complaints from the FTC hearing, which was, I believe, was in 2017, where they got input from I think it was about 10,000 consumers who filled out detailed questionnaires, and it was over 50% of the complaints were on that one specific issue.
Honestly, we couldn't agree with you more. It's our main concern. It's been the main concern of this committee for quite some time. The other one I would say that's also a number two complaint is when you have the tickets in your cart and you're going to check out, and then all of a sudden they magically disappear. And they've sold them already. I almost think once you put them in your cart, they should at least hold them for you until the transaction's over. And I don't know if that actually happens. My last question, and then I'll turn it over to the good chairman, and I appreciate him allowing me to go first. The part where it says 125%, I read it a couple of times. Is that everybody, or is it an individual or a third party that can't sell them for more than 125%?
It's not our language. That was the language that we're responding to. You're talking about.
And 125% is really just 25%, right? Because 100% is the cost of the ticket. So you're really just getting a 25% premium on your really valuable, I don't know, say Big East tournament tickets or anything like that. Not that I know anything about that whatsoever.
The question is,
Anyway, we're totally against price caps. They don't work, but I think that gentleman from the fan coalition went through it very well. And years ago, when I used to buy tickets from season ticket holders, they would sell me the Celtics-Lakers games, right? Because they can get an astronomical amount for those tickets, but the rest of the tickets for the season weren't worth that much, right? So it would allow them to defray the cost of their season tickets. That's why we've seen the whole sports market go to free market pricing. The whole sports market sells literally billions of dollars worth of tickets to secondary market brokers. You could call them scalpers, whatever you want. But when they sell them to them, they have revenue shares in place. So the net margins that these resellers are making on their tickets hovers somewhere around 6%. If this same rights that sports teams have to sell tickets outside of the primary is applied to concert artists and comedians, this would be a great way to mitigate the issues, get steadier prices in there, and bring more venues, bring more artists to venues, especially in Connecticut. We had a Connecticut venue, an artist was playing Bridgeport, right? That artist canceled the show because that artist didn't have the same rights as the sports teams in that venue to distribute their tickets outside of the primary. So the venue gave sports teams and family shows the rights to distribute their tickets wherever they wanted, but they didn't give that concert artist. So the concert artist saying, why? Why am I being restricted? What's the difference? Okay, well, the difference is they wanted to charge that concert artist a lot more money for renting the venue, and they canceled the show. And it was, you know, it was an African-American show. It was Rick Ross and Jeezy were playing at Bridgeport, and they canceled it, you know, and the main reason was they weren't allowed to distribute the tickets the way they wanted. They didn't want the tickets distributed in a non-transferable way, which is illegal under Connecticut law, and they didn't want to be a party to an infraction of a Connecticut law.
So in plain language, in plain English, because that when you say primary, you're talking about like a Ticketmaster type situation, and secondary, the artist could pick a different, I don't know, what are the other ones? Live Nation, there's a whole bunch, right?
Secondary is the resale market.
Yeah.
So, but how would the artist, I guess this is my ignorance sometimes, why would the artist care as long as they sell tickets?
You know, that is a great question, and we have some very good support for this. In fact, Ticketmaster's ex-CEO, a gentleman named Irving Azoff, now that he's no longer the Ticketmaster CEO, believes that artists should have the rights to sell tickets on any platform they want. And this restriction should not be in the contracts. He testified of that in video about 2 years ago in Los Angeles. Garth Brooks said the same thing, right? So what that would enable is an artist like Taylor Swift to pick any ticket distributor she wants for her venues. And the artist's argument is, well, if sports teams can do this, and family shows can do this, and practically any other renter of the venue, why are you imposing different rules on us as an artist or a comedian? And the reason why is that their shelf life, in theory, is shorter. They don't have the negotiating power, and they can get taken advantage of. So
just to interrupt, just because I have a question. Does what? Well, it's an interesting topic. Don't you find it? It's general law. It's what we do. How does that help the consumer? Are you saying that if somebody's having a show at the AMP, a theater, and they're a Ticketmaster exclusive, and the artist's like, no, I want Ticketmaster, but I also want to sell it through XYZ. How does that help the consumer? What if that XYZ distributor is charging more fees or charging more whatever, or the splits are different with the artist? How does this whole conversation, outside of helping the artist, which I understand, how does this help the consumer? How does what you're saying help my ticket prices?
Got it. So it gives that artist ubiquitous distribution, right? It gives that venue and artist more advertising dollars for their shows through the marketplaces. It creates more awareness for the venues. For example, if you list tickets on our exchange, it goes right to every military base in the country because we have the contract to provide tickets to all the military bases for all the soldiers in the United States. It immediately goes on, Orbitz. It immediately goes on Expedia, cheap tickets. The tickets are distributed everywhere. So it really creates value for those venues, right? It gets those tickets out everywhere. The lower the artist marketing cost means there's more shows available at the venues, right? The more shows that are available at the venues and the artists pay less marketing cost, you have some competition that more artists are going to go to the venues and do it. Also, some other ticket distributors, right? If you put them on different websites or different marketplaces, have different policies that will allow more consumers to buy. For example, we sell tickets via Venmo, PayPal. We take the Chinese credit card. We sell tickets overseas to folks who commute, who come into the country and stuff like that. But not only us, all the marketplaces do it. Most consumer products want ubiquitous distribution, right? That's what it's about, unless there's some other reason that they don't. The sports teams are doing phenomenal with this ubiquitous distribution. However, some venues think that since the sports teams are doing it, they're making less in rebates. So they want to stick it, for lack of a better term, to the concerts and the comedians, to restrict them to the platform. And these artists, I mean, it goes from Pearl Jam to Garth Brooks. The Irving Azoff's client was the Eagles. They want the rights to sell their tickets through any distribution channel that they want. They just want the same rights that the sports teams and family shows have. And currently, in most cases, they don't have those same rights.
I want to thank you for answering my questions and a very interesting conversation. I'm going to open it up to the other representatives. I feel like I'm monopolizing everybody's time. So thank you very much.
Thank you.
Are there any further questions? Representative Candelaria.
I just want to go, thank you, Mr. Chairman. I just want to go back to the issue of refunds. So this is actually an issue where resellers are not refunding. You also mentioned that in the language, you wanted to add the primary seller. Are we hearing a lot of these issues? Is this going on consistently?
I'll give you the great answer for that. If you remember back in Las Vegas about 5 or 6 years ago, there was a terrorist incident where 50 people were assassinated. I believe it was, the tickets were sold through Ticketmaster. I believe it was a Live Nation event at a country music festival there. They never issued refunds. There was a class action suit. They refused to issue refunds, right? One of the statements they made is, well, people have to contact us if they want a refund instead of being immediate. Well, it's kind of hard to contact somebody if you're dead. If you're one of the 500 people who are in the hospital, you're one of the other people there, you don't even think of contacting for a refund. So yes, it is extremely hard to get refunds from the primary seller, right? It's sometimes hard to get refunds from the secondary seller because the secondary seller might say, hey, I don't get it from the primary seller, right? So the refunds should be instantaneous, 7 days. It should be ubiquitous on sellers and resellers. If your event cancels, you get your money back. Now, it's not only for the consumers, is that money goes right back into the economy, and those consumers usually look for another place to spend that money. And don't forget, when folks hold back that refund, 2 things happen. They earn interest on that money, which aggregately adds up to millions of dollars a year. And consumers usually have to pay interest on that money, which is at many multiples of what the businesses get for interest. So the reason why consumers aren't getting refunds quickly, it's just simply a money grab, right? That money, when a show cancels, should get immediately refund. Our policy is when we get a show canceled, we refund the next day. we're in a negative situation until we get our money back from the issuer, but it's just not fair to the consumer. If a show cancels, it's automated. It is so simple. You refund instantly. If you put the date at 30 days, everybody would start waiting for 30 days. 7 days is much more time than necessary to issue a refund. And there's a lot of venues that would support this legislation as well.
So, in the same line of questioning, so would the venue have any say in the refund at all? Depending on the type of venue or the type of artist that's actually in the venue, what role, if any, does the venue play in those refunds?
Well, once the venue officially cancels the show and it kicks off the refunds. So the venue officially cancels it, then the refunds get kicked out to the consumers. That is the trigger. The venue controls the trigger on the refunds.
Gotcha. Thank you for those things. Thank you, Mr. Chairman.
Great. Thank you very much. Representative Ackert.
Thank you, Mr. Chair, and Don, thank you for your testimony. Just to follow up on that question, I just heard that on a drive-in that Billy Joel has canceled for 4 months, postponed for 4 months, and they're not refunding the money. They are giving you another date in the future. Is that similar to canceling, or is it just because I'm supposed to go, I got tickets to, next month's concert, and then you may have something in September, but you're not getting a refund. You have to go to that show if you want to go to the show.
I'm not familiar with that with that specific show that you're quoting, but the standard principle that most venues adhere to in this situation, they don't always adhere to it, but most of the time they adhere to it, is if a concert postpones, the consumer has the option to either get a full refund instantly or to get that, to be able to use that ticket at the postponed date. Okay.
They did say that they'll be honored at the next date. I didn't hear anything about any refund opportunity. But I thank you for that answer. Thank you, Mr. Chairman.
Thank you. Are there any further questions? Okay, hearing none. Thank you all for your testimony.
Thank you, Mr. Chairman. Thank you.
Great. Thank you, Mr. Chairman.
Beg pardon? We want to get it right. So look forward to the suggestion. Okay, yeah. And I believe in the written testimony, we've given that, but we'll be talking to you. We're glad to work with you to help get it done. Thank you very much for your attention and this time. We appreciate it.
Thank you. Okay, next, Senator Looney and Duff.
That was awesome, right?
Yeah. Good afternoon, Senator Maroney, Senator Chigliano, distinguished members of the General Law Committee, and so my two New Haven colleagues are here also, Representative Paolillo and Representative Candelaria earlier. We are here. I'm Martin Looney, the senator from the 11th District, representing parts of New Haven and Hamden, and our distinguished majority leader, Senator Bob Duff, is here. We're here to talk about Senate Bill 3, which is one of our significant caucus priorities this year in the area of consumer protection. I'll just highlight a few instances of it. The first part of the bill addresses the issue of junk fees, and the concern about that, of course, is that junk fees often obscure the true price and dilute the forces of market competition and makes it difficult for people to compare when they find out about junk fees added on late in the process that they did not factor at the beginning when they were doing their comparison pricing. Secondly, regarding the eavesdropping by electronic devices, this is something that people are shocked to find out can go on. Third, this is something that Senator Duff has worked on for a long time, the the right to repair and the opportunity to be able to have consumer choice in the choice of repair rather than having artificial barriers put up. And number 4, the .gov internet domain requiring that municipalities use that. And 5th, the issue of price gouging. Currently, price gouging is not prohibited unless there is an emergency declaration by the governor. And our price gouging statutes have evolved over time. The original statute dealt just with the issue of price gouging on products or items. We expanded that some years ago to also include services. So, for instance, originally we would be looking at price gouging on dry ice when there was a summer storm that knocked out power, and all of a sudden the price of dry ice would skyrocket when people trying to protect food from becoming spoiled. Or we were concerned in some cases the price of snow shovels or other items might go up in the winter. Then we expanded it to cover services. Somebody who might come and offer to take the snow off your roof when it's creaking. It might charge what might seem an inordinate price because of the emergency situation that someone is facing at that point. This provision now would expand price gouging to include a situation when we don't necessarily have a gubernatorial declaration, but a notice of abnormal economic disruption by the Attorney General, and would also allow for an investigation of price gouging, not just at the retail stage, but at the distributor stage and at the wholesale, because in many cases the retailer is not the one at fault. The retailer is just passing along a price that's been mandated to them by their supplier. I remember some years ago when we had the debate on the last time we expanded the price gouging statute, there was one senator in the floor debate who said that there is no such thing as price gouging because everything is just whatever the market drives at a given time. That certain items are going to be more valuable at certain times than at others, and we should just let the market prevail. Well, that in my view is sort of the unbridled red and tooth and claw capitalism that I don't think we should embrace. That I think Connecticut should embrace a more responsible, compassionate social policy, social conscience form of capitalism that does put some restraints on in those circumstances, rather than just allowing people to be taken advantage of in emergencies. So the issue is more complex because of the fact that the pressure is often coming from someplace other than the retailer, and this would allow the Attorney General to become involved at other levels than the retail. And then we have the issue of shrinkflation and the so-called altering of packaging to disguise the fact that there's less in the package than used to be the case. And I'll hand it off now to our Majority Leader.
Thanks, Senator Looney. Good afternoon to members of the committee. Good to see you all here today. And again, we're not talking about ticket prices right now or drones, so you're probably happy about that as well. Yes, but we've no gouging of drones here, but glad we got that settled a couple weeks ago, and that is now the law of the land. But wanted to talk about, and I appreciate the committee hearing Senate Bill 3 again. We did pass it in the Senate last year. It got stalled on the last day of session in the House, and so here we are with a number of different provisions that I think put forward a very good consumer protection law. And I don't need to go over the same issues that Senator Looney did talking about Senate Bill 3, but I would just say that if you asked constituents around the state, you asked your constituents whether they supported these one by one, they would probably say yes, that they do. That they view price gouging as an issue that the government should have a hand in when there are certain economic disruptions or emergencies, and that is a proper place for government, that we're talking about ensuring that TVs and other things don't eavesdrop on us. We're just not keeping up with technology. And in fact, I would probably argue that Congress should be dealing with these issues, but they're not. And let's just, they're not going to. So we can pretend that they're going to one day and that maybe there's a markup of a bill and maybe there's somebody's got an idea and maybe there's 5 people who support it and in 3 years they'll have a committee hearing and in 4 years they'll maybe get something out. They're not going to do it. So it's really up to us in state legislatures to be able to take control of these things and to make a statement about what we think is really important. And that's why you're seeing many states tackle these kinds of things like junk fees and eavesdropping and right to repair, and in other ways in which we can protect consumers, because we know that with technological innovation comes consumer concerns involving privacy, transparency, and affordability. And we have a duty as a state to foster innovation and regulate the market to ensure the safety of its consumers. And I think that this bill strikes that kind of a balance. The last thing I'll just mention is in the .gov, because that is really important. Senator Maroney and I think this is the 3rd time I've testified now in front of this committee, so you're very fastly becoming my favorite committee to testify in front of. But we're both on the cybersecurity task force with the National Conference of State Legislatures, and municipalities cannot, or they can, but they have a very difficult time now applying for federal grants without a .gov. And frankly, for people not knowing if their communities, if those websites or domains are correct, if they don't have the .gov, it gives people assurance that that is a correct domain, and that actually is something that they can trust, rather than going to a .org. Norwalk went from a .org to a .gov because of the federal provisions about grants, but it does give, like we have .govs, it gives people assurance that we're actually being able to, they're contacting somebody for real, not somebody who might put a link in and hack their computers. So for all those reasons and more, I do think that this is a solid bill and that it's a well thought out one. And again, thank the committee for raising it today for a public hearing.
Great. Thank you. Representative Vitigliano.
Thank you. Yeah. Good afternoon, gentlemen. I just have a couple of quick ones. The provisions of the price gouging were very similar to a bill that we passed out of committee today, the Attorney General's bill. The only concern that we had, and I would love your perspective on it, is that it sort of gave too much power or unchecked power to the Attorney General. Not that we are for price gouging and we don't think he should be able to do it, but the Attorney General sort of just deems it so, and there was no way to undeem it and they could extend it. I just was hoping that you could put our mind at ease or give us some thoughts on that one.
Sure. I wasn't privy to the Attorney General's testimony earlier, but I think it should certainly be appropriate in the statute to define the term in a way that would be clear and that there would be standards for the Attorney General to follow in making that declaration, so that it would be objective and not excessively subjective.
Yeah, they can. And I think there's conversations already about amending that to figure out ways in which there's checks on that.
Right. Well. And we as a legislature, as you both gentlemen are leaders and part of, we're comfortable with having 2 offices now that could declare emergency. That was the only part that I thought was a little odd. Shouldn't it be up to us? Shouldn't that be sort of our job, or like we do now with the governor, where the governor declares it, but yet we have a say if we don't agree? I just didn't know if that was the same, if you wanted that same thing with the Attorney General or not, or how that shape seems a little out of character is all I'm saying.
Just my concern is that the legislature obviously is something we dealt with during the pandemic. We are not made for immediate and quick action. There are times when something comes up that only the executive branch can deal with. In this case, extending that to the Attorney General if a price gouging situation arises. So I often create the analogy that the executive branch officials and departments can be like sailboats, and we're like a battleship. It takes us a while to get in position to do something. But it's certainly a valid point that there have to be standards that would be objective for the Attorney General to be able to make that declaration, which in some ways would be roughly equivalent to a governor's declaration of an emergency.
Well, I appreciate that. I appreciate the answer. And you brought up a senator that brought up that there's no such thing as price hikes. That's just for reference, it's a Freakonomics theory. That was a book that was published almost about 20 years ago, where they think that when there's an emergency, it's the high prices that get people to go to the area to supply them with what they need. Like if you need a generator in Louisiana after a hurricane, the fact that somebody can make extra money means that more people will run into the market with generators, and then they'll come down because there'll be so many of them. It's an interesting book. It talks about lots of issues. I enjoyed it a lot, but just a suggestion. Half the room is nodding. Not that these drones are before us, but I think we're going to hear testimony. Not if I'm putting you on the spot, Senator, tell me to be quiet, and you can move on to Representative Acker. I didn't mean to demote you. I'm sorry. We're going to hear testimony, which I wasn't aware of. That there's a company out there that when the drone is, nobody wants Chinese drones. We'll all agree, right? We were just worried about how long it took the municipalities to adapt and all this other stuff. So we're with you on the foreign drones and all this other stuff. But they say that they have software or whatever, where the drone comes in and it has to be, whatever was on there gets wiped out, and they put on there where the protection is that the information can't go back to where we're concerned that it's going back to. I don't know if it's true or not. I'm saying that's what they're probably going to testify to. I didn't know if you've heard of that, talked to them, had an opinion on it, or is there any modification we can make to the drone bill to make it easier for the municipalities in the short term?
Thank you for that. My feeling is we passed the law is settled, done.
Thank you, Mr. Chairman. Thank you, sir.
All right, thank you. Representative Acker.
Thank you, Mr. Chair, and I like that answer, Senator. And thank you for both being here and bringing this to our attention, this bill up. So on the price gouging, that's primarily or specifically during an emergency. Is that correct? And reason
Our current law, yes, there has to be a gubernatorial declaration of an emergency that presumably comes into existence at a certain point and goes out of existence at a certain point. The concern here was that there may be an ongoing condition of price gouging somewhere in the chain of sales on certain items that are not necessarily an emergency in the sense that a sudden storm is an emergency, but has become a chronic condition of price gouging.
Thank you, because they brought up the regular commerce type of thing where you see on, people ask on different social media sites, hey, I'm looking for blah, 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 blah. And then they get quotes back. And then they get there and say, I had one contractor that was 4 times higher than the low contractor. And I know in my business, it's all over the planet on the same exact job. And so I'm interested to see what some of the reports. I'll check with DCP and what some of the what some of the feedback is on some of this. But I thank you for that. And then the other,
I might add to that,
please,
I think
please,
the genesis of this actually came up last year when we became concerned, and the Attorney General also, that in the wake of the pandemic, when there were supply chain problems, that there were a number of price spikes upward, of course, that were never adjusted downward after that situation ended. Once there was no longer a glut in a supply chain problem, the elevated prices stayed. And that's what we wanted to get at here, to allow the Attorney General to address that situation, which would be outside the context of where the governor declares an emergency.
thank you. Thank you for that input. And then the other part is that listening piece. So we're talking about this listening in piece, right? When we talk about listening in on our electronic devices?
Well, that also in TVs, televisions. There's a reason why the TVs are very cheap.
Oh, interesting. That's so now you're making me even more nervous. You're more nervous because I was having a conversation with my daughter about a gunned stuffed animal. Now I don't typically look up gun stuffed animals on my phone or any other of my devices. And the next time I picked up my phone, what was for sale on my phone? A gun stuffed animal. I'm like, how on earth would I ever know that all of a sudden I have this?
I can't wait to get the ad next.
Yeah.
We're all well.
That's a good point.
That's probably gonna pop up again. But it is interesting, and I didn't think of the TV component of it, or any other electronic.
I can just share with you, Representative, that this is the fun part about legislating, is that you read things, you research it, and then you have the ability to act, right? And anybody, again, who goes into an electronics store or warehouse store, TVs are pretty cheap now compared to how they used to be. And there's a reason why. Part of it is because of the fact that there's a lot of listening. And I'll just give you also another example. Oh, and before I get to that, I'll just say that I went on our TVs and to try and get yourself so that it's not listening and that there's privacy, it takes a lot of work. So again, the reason why we have this, so there's disclosure and that you can prevent a lot easier without having to spend 20, 30 minutes doing it if you can. But you think about people have Alexa, right? Or you might have the Mac version of that. One's very cheap, one's not as cheap. One does more listening, one doesn't do as much listening. There's a reason why the prices are the prices. And again, I'd love to say that Congress is going to take care of these things, but they're not going to. And if just like you, kind of that aha moment of, you mean that's actually listening to me? It's not just my phone, because we all kind of understand now that phones are listening to us. But other appliances or other devices in our homes are listening to us. Yes, they are. And that's, we have to be able to tell our constituents we're taking more control over that.
Thank you, Senator. And so I wasn't typically a paranoid person. I'm shutting the main breaker off on my house when I get home from now on. So I'm shutting everything down. So, and I know where it's at actually. So thank you, Mr. Singleton. Thank you, Mr. Chair.
Great. Thank you. Okay, Representative Jensen.
Thank you, and thank you for your testimony. I just have a question about the shrinkflation in food. All right, so it says it has to be clearly and conspicuously disclosed. Are we thinking about like an on-pack label that needs to be on there for a full year?
Yeah, thank you. Thank you, Representative. This part of the bill has actually been the toughest. And it's been the toughest to try and define and try and label and everything else. So I'd say that's a work in progress at this point.
Yeah, if I can follow up, yeah, because I know like if you put a new violator on, right, you're only allowed to be on for 3 months. But if you have a smaller size, now it has to be on for a full year.
Yeah.
All right, that would seem.
Yeah, I mean, the thing is, we all have seen shrinkflation. Right. Nobody buys a pound of coffee anymore, right? But it is a little more difficult to try and actually, it's like, we know the problem, right. Trying to actually fix the problem is a little bit more of a
Still work in progress.
Yeah.
Thank you.
My wife noticed it when I bought her candy for Valentine's Day. Same box as previously, less candy, more plastic.
All right. I do have a few questions. So one, we're going to hear testimony later in regards to the right to repair. And the intent for right to repair is consumer facing, correct?
Yes.
And so would there be any objection? We're going to hear testimony from 2 different people about connected medical devices if we were to exclude devices that were authorized, approved, or cleared by the FDA.
Thank you, Senator. I believe that they're already exempted by federal law, by our CUTPA laws, and that they don't, if they got a separate exemption, it would pose more of a legal issue for us here in the state of Connecticut. That's my understanding.
Okay, great. Thank you. Next, the .gov. Would you talk about the fiscal note from last year? I think it was.
I don't think there was a fiscal note.
I think it was a rare fiscal note that actually saves towns money because there is, I believe, CISA has grants for paying for that.
Yes, exactly, and that's when we spoke to the gentleman at the meeting we were at recently. There are grants now, and it's very easy to do. It doesn't take town resources, especially small towns. Resources, so you don't have to go hiring like an army of people to go to .gov. They will do it for you, but they really want you to do it. So that's why they have these grants available. So it's really, really important, especially again as we see more foreign actors go further down into the government level. Whether it's not just they're going after national governments, they're now going after state governments and local governments. So it's really important for communities to do it, and they'll save money because they'll be less, I guess there's less of an opportunity, less chance for them to get hacked and then have ransom. And then 2, with the grants, it will save them money, and they'll have those opportunities to apply for other federal grants because they have that .gov too.
Thank you. Right. The added benefit, in addition to the trust of the domain, there are actual additional cybersecurity protections. So the last one, and the question about giving the Attorney General the right to do this without any checks. Senator Luna, you had mentioned back to as we learned during the pandemic, we can't get the whole legislature together, but we did create the committee, I believe, we were looking to perhaps model something off of the committee of the leaders who would have the right to meet to veto that if the AG were to determine an economic disruption. And I'd just like to get your thoughts on that.
Yeah, I think, Mr. Chairman, if the committee believes that to be appropriate, would be another way to do it, to kind of deal the legislature in to creating a consensus on the fact that an economic disruption does exist, and to allow the Attorney General to make the case and convince the legislature why it does.
Great. Thank you very much. Are there, okay. Hearing no further questions, thank you both very much for coming to testify.
Thank you.
Next, Chelsea Farrell.
Hi, good afternoon. Can you hear me all right?
Yes, we can hear you. Please proceed.
Thank you. So good afternoon, Chairman Maroney, Chairman Lamar, ranking members, and distinguished members of the General Law Committee. My name is Chelsea Farrell, and I am the Policy and Legislative Associate at Trinity Solar. As you may know, Trinity is the leading residential solar installer in Connecticut. We have worked in the state for over 17 years, and during that time, we have installed over 29,000 systems, and in 2024, we installed over 3,400. I'm here today to testify on House Bill 6052, and while we truly do appreciate the committee's work on this important topic, and we fully agree that consumer protection is critical to the industry, there are amendments that are needed for Trinity to fully support this bill. So last year, the legislature took an important step by creating a consumer protection task force, and Trinity was honored to be included in that effort and was appointed by Senator Harding as a representative. And it was unfortunate that the task force was unable to move forward. It's our overall preference that a task force be reinstated or restarted to draft collaborated solutions that would work for all. But in the meantime, we fully recognize the importance of addressing these issues and wanted to make sure that we submitted testimony on the legislation that was presented. I'd like to briefly highlight just a few suggested amendments, and then I encourage you please to review our written testimony for more detailed recommendations. At a high level, I'll start with Section 3, the no-knock list. So the issue here is the practical implementation of this provision. Under the current language, the sellers are obligated to review the no solicitation list on a monthly basis, but yet the list itself may only be updated quarterly. So there's this misalignment that raises the risk of a company inadvertently soliciting to a home that was recently added to the list but then not yet reflected. And then compounding this with the concern of the significant fine of up to $20,000, I can see companies here that make a good faith effort to comply, but they may be limited based on the timing of the list updates, administrative changes, all which may be out of their control. And then I'll shift my focus there to the fine of up to $20,000 in Section 5. We would ask that this penalty be limited and more in line with the Home Solicitation Sales Act penalties. Additionally, it notes in the legislation that this fine is for one violation and can be applied multiple times over. So the bill itself does not appear to provide an appeal process or a mechanism for companies to challenge this or explain alleged violations. And we believe this is a critical omission as it leaves businesses vulnerable to disproportionate penalties, really without an opportunity to demonstrate compliance. It would be a financial hardship with those penalties reoccurring. And I know I'm running out on time, so I'm going to jump to another key concept, and that's just generally that the provisions in this bill should not just be limited to solar. And I really appreciated Representative Linehan's testimony earlier as she touched upon this. Overall, the industry should not just be isolated in door-to-door etiquette. It should be streamlined and uniform across all door-to-door sales. Thank you so much. I appreciate it. Happy to field any questions.
Thank you very much. So, thank you for raising, the idea of the appeal process. I don't know if you have any suggestions of where to look in legislation for other areas where we've created an appeal process?
Not offhand, but I'd be happy to put something together, discuss this with other solar companies and other stakeholders and potentially come up with something that may be workable.
Yeah, if you could send something, that would be great.
Sure.
Okay, are there any further questions? Okay, Representative Acker.
Thank you, Mr. Chair, and thank you for your testimony, Chelsea. Can you go back to the working group or task force component that you mentioned that you're appointed to it, and unfortunately, like so many of our wonderful task force that we put together, they just don't ever come to fruition. Is that what happened?
I believe so. I don't know the full details, but I believe just
So you've
the
never met,
communication.
right?
No, nope.
Okay, and that might have been a good start to what we're trying to do here with getting, getting good consumer protection. So I appreciate that. And then the
Absolutely.
fine component is I haven't seen a fine to this level. I think that I can remember. Is it up to 20,000 per violation?
It does note in section 5 that I believe it was section 5A through F would be an up to 25,000 or up to $20,000 fine per violation.
Right. So if you happen to go and you got a salesperson out and they hit 3 or 4 doors in a neighborhood, and they were all on that list, that they would each be a violation, each be a potential violation, right?
That's
Fine.
my understanding.
Great place to do business, isn't it? Thank you. Thank you, Mr. Chair.
Thank you.
Great. Are there any further questions? Okay, hearing none. Thank you very much for
Thank you so much.
coming to testify to us today. Next, Kimberly Naitre.
Good afternoon. Chairs Maroney and Lamar, Vice Chairs Fonfara and Turco, Ranking Members Ciccarella and Ritigliano, and distinguished members of the General Committee. Thank you for the opportunity to testify today. My name is Kimberly Naitre, and I strongly support a new section to SB 3, which establishes a waiver allowing state agencies, municipalities, and contractors to procure and operate small unmanned aircraft systems only from entities both foreign and domestic that meet the strongest security requirements. Simply requiring that certain components within a drone are not made by opposing foreign governments is window dressing for a larger problem, ensuring our drones cannot be hacked and our data cannot be stolen by hostile foreign or domestic actors. This waiver makes one thing clear: any drone, whether foreign or American made, must meet uncompromising security standards. All collected data, including video footage, photographs, telemetry, and personally identifiable information, must be stored exclusively in the United States in full compliance with federal and state privacy laws. Systems must enforce end-to-end encryption, operate on segmented and secure networks, and require multi-factor authentication for access. Tamper-proof hardware must prevent unauthorized modifications, and all collected data must reside on a secure FBI-compliant cloud infrastructure with automated deletion within 45 days unless retention is required for law enforcement purposes. By taking this strong, proactive, and logical stance, Connecticut can lead the nation in establishing an airtight framework for drone security, protecting our state's data and infrastructure from both foreign and domestic vulnerabilities. This waiver is about future-proofing Connecticut's drone usage to ensure that every drone deployed, now and in the future, meets the highest security standards, no matter where its parts come from. By requiring verifiable cybersecurity audits and compliance with the most stringent encryption and data protection protocols, this framework guarantees that Connecticut does not unknowingly expose its critical infrastructure and public safety operations to foreign interference. Crucially, enforcement mechanisms will prevent any drone, domestic or foreign, that fails to meet these stringent requirements from being used by state agencies, municipalities, or contractors. I urge the committee to support this addition to SB 3. This is a practical, security-first approach that protects our agencies while ensuring they have access to the best tools available. If a manufacturer, foreign or domestic, cannot meet these standards, its drones should not be used by government agencies. Thank you for your time and consideration.
Great. Thank you very much. I believe Representative Retigliano has some questions for you.
I was asking you to ask. Can you tell me currently who uses this software that you're saying? Because we're talking about foreign drones, right? You're saying that it's okay if you buy a drone from wherever, maybe even a banned country, China or Iran or whatever was on the list. But if you install this software, you should be able to use the drone, correct? Yes?
If you follow these requirements, yes.
Follow the requirements. Is there any governmental agency currently using this software that you could refer to?
I believe all 50 states are using these kinds of drones right now. In terms of the software, are you referring to the safeguards that we mentioned in the additional language, or which software are you referring to?
I guess because I'm not a tech expert, so I'm hoping the senator asks you better questions than mine. But I guess I could say, if you could say, well, I don't know, I'm making this up. The FBI uses this software and they're so confident about it. They buy drones from everywhere and they install these protocols and they haven't had a problem, or whatever agency you could refer to.
I would probably prefer to have a technology expert speak to that. But like I said, I believe all 50 states are utilizing this technology.
You mean the drone technology or the safeguard technology?
The drone technology, I believe.
No, yes, that's the problem. They want most of our first responders in Connecticut are using foreign-made drones. We are passed a law banning the use of foreign-made drones, which some of the first responders have a problem with because they're cheaper, they do more, they want to use them. But we're saying a flat-out no. We were wondering if we could point to another agency that uses a foreign-made drone but has your sort of protections on it that would make it okay for us to say, okay, it's fine if you have a Chinese drone, but you must have this. And if this protects our information, then maybe we could give our first responders a little bit more time to adapt to the changing landscape of not wanting a foreign drone. Did I make sense?
I think so. I'm more than happy to provide this list. I don't have it offhand at the moment.
Okay, thank you.
Thank you. Are there any further questions? Okay, seeing none, thank you for testifying.
Thank you very much.
Next, Neil Eskin from the University of Connecticut.
Good afternoon. My name is Neil Eskin. I am the Executive Associate Athletic Director at UConn. Thank you for the opportunity to provide testimony regarding HB 7182, an act concerning entertainment event tickets. As others have testified today, we strongly agree that providing the total ticket price, including all fees, is essential for building trust and helping customers make informed decisions. It also reduces frustration from hidden costs and minimizes shopping cart abandonment. At UConn, we believe that displaying the total ticket price aligns with our values by promoting transparency, improving customer satisfaction, increasing loyalty, and supporting fair competition through accurate price comparisons. Although this bill does not apply directly to state agencies like UConn, I'd like to share some feedback from our perspective. First, as related to the language in Section 1B regarding the advertising of ticket prices. When any retailer widely advertises its goods or services, the attempt is to provide consumers with information that is easy to understand, something simple to digest, yet compelling. UConn believes that requiring a detailed breakdown of fees within an advertisement could lead to confusion rather than clarity for customers. Our preferred approach is to display the total ticket price, inclusive of all fees, upfront, while providing a detailed fee breakdown during the online purchase process before any tickets are placed into a shopping cart. We feel this approach is more effective and customer-friendly and ensures clarity from the outset. Second, Section 1C does not reflect the realities of today's ticket marketplace. The industry best practice nationally for events, including those at UConn, is mobile ticketing, where tickets are delivered directly to customers' phones. Tickets no longer serve as customer receipt. Instead, they function as a scannable admission pass, displaying only the event name and seat location, not the price. But in addition to receiving a ticket, customers also receive from us at the time of purchase an electronic order confirmation, a receipt, which provides a clear itemized cost breakdown of the entire purchase. We ask that you consider adjusting the language in sections 1B and 1C to reflect the suggested changes we have shared in our written testimony. Thank you for your ongoing support of the University of Connecticut. I greatly appreciate the chance to share UConn's perspective on this issue and welcome any questions you may have.
Great. Thank you very much. I think, if I understand, on the delivery of the tickets, and so I'll just go from my experience.
Sure.
I bought tickets, when I buy tickets for the event, they don't show up in your account until the week before. Sometimes, like when I bought my tickets to go see UConn at Georgetown, or my NCAA tournament tickets, I bought them for Indianapolis. I'm going to go with my son out there, and the tickets aren't in my account yet. I believe what the resellers think is that it should be sent to your account right away so that you would have the opportunity to resell that. So understand it. That's my understanding of what they're looking for. So how can we achieve that in lines with what you've said?
It's interesting to hear. We deliver tickets immediately when people buy. When people buy from our site, as soon as you buy and purchase, those tickets are delivered immediately. And we feel that's the most consumer-friendly way to approach it. And so delaying delivery of tickets, is sometimes done because there's an assignment of tickets, perhaps, but we don't feel that that is the proper way or the appropriate customer-friendly way to do business as it relates to delivery of tickets.
Okay, great. Thank you. Are there any other questions? So, all right, hearing none. Thank you very much.
Thank you. Thank you very much.
Next, Joseph Watkins.
Thank you, co-chairs Maroney and Lamar, ranking members Ciccarella and Ritigliano, and distinguished members of the General Law Committee. My name is Joe Watkins. I'm president of WorldPay Gaming Solutions. We're the global leader in payment processing, providing secure, reliable, and innovative payment solutions for gaming operators worldwide. With decades of experience in the fintech space, WorldPay Gaming Solutions processes billions of transactions annually in regulated gaming markets. We're a licensed payments provider in the state of Connecticut, and I'm personally licensed as a key person in Connecticut as well. We work closely with regulators, operators, and financial institutions to ensure safe, compliant, and seamless payment experiences for consumers. We're also a member of the iDevelopment and Economic Association, also known as Idea Growth, a leading trade group representing companies across the online gaming ecosystem. My testimony today reflects the interests of Idea Growth's diverse membership, which includes gaming operators, technology providers, and payment processors such as myself, all of whom are responsible gaming advocates. I offer testimony today in opposition to HB 5269, particularly regarding the provision requiring that all account holders approve a deposit before making wagers. While this requirement may seem well-intentioned, there's no technological mechanism to comply. The result would limit consumer choice and push players toward less transparent, less secure account funding mechanisms. Here's why compliance is impossible. There is no method within the established card networks or banking systems to confirm the approval of all account holders prior to making a purchase or deposit. When a verified account holder makes a deposit, the gaming operator passes key information through the payment chain to confirm that the transaction is legitimate and authorized. However, there was no way to identify throughout that payment chain whether joint account holders exist or if they would offer their approval. The issuing bank at the end of the chain may know if there's an account holder that is a joint member of that account, but today they do not share that information to any other members within that payment chain. No payment processor can independently verify the number of account holders or require additional approvals beyond the primary account holder's authorization. I urge the committee to consider these realities and reject HB 5269, as its implementation would be impractical and counterproductive. I also saw throughout the rest of the hearing today that there were a number of payments questions, and so I appreciate the opportunity to testify and welcome any questions you may have for me.
Thank you very much. Are there any questions from the committee? Okay, Representative Lamar.
Thank you for your testimony today and providing some insight into how the back-end mechanics of this present a problematic reality for us as we think of appropriate legislation to limit what we also recognize as a problem, and I hope you recognize as well, which is a readily increasing, some would say staggering increase in the number of defaults and or debts accumulated by what appears to be young men, that the rates of which that we're seeing at our problem gaming interface here in Connecticut is quadrupled in the last 3 years since online sports gaming has taken hold. Do you have any advice for how we'd otherwise prevent what we see as a potential long-term economic challenge for many of these individuals who have joint accounts, who encumber large debts and then have a co-signatory on a credit card or a debit card, who are enjoined in some manner because of the debts accumulated by one individual without their known? I mean, it is going to become a much bigger problem than it already is, which is a big problem. And I'm open to advice on how to handle this issue. If you're telling me there's no way for you to accommodate it, then we're going to end up with, I think, like legislation that prohibits the use of credit cards at all. If there's no way to safely do it, we're going to end up with legislation saying you can't do it. And I don't know that that's the right answer. So I'm looking for advice more than I am for criticism of the current approach that we've outlined in this bill.
Yeah, of course, Representative Lamar, happy to give it. So a few thoughts there. First, just to be clear, this limitation is not only for credit cards. This is for all payments. So whether that's a debit card, a credit card, or even if you were doing an account-to-account purchase, right? So if you're using ACH, real-time payments, or FedNow, none of the rails within the payment ecosystem allow for this acknowledgement or capture of whether or not an account is joint, or the express consent of all joint account holders to authorize that purchase. I would definitely point you to the AGA. There's a Have a Game Plan program is very effective. What's great is, obviously Connecticut is newer in the online gaming space compared to other jurisdictions, but these problems are not new. These questions are not new. And so there's well-established best practices that exist. The AGA, I think, is a phenomenal resource that I would point you to, as well as leaning into conversations with industry experts. Myself, I've helped a number of different states look at issues as it relates to payments within gaming, and we're certainly happy here at WorldPay Gaming Solutions to offer our expertise as you evaluate any of these particular questions. One other comment that I had heard earlier in the hearing there's a couple of comments that probably are worth mentioning or addressing. One is that the thought that on a debit card, the fact that there might be a credit label there, like Visa or MasterCard or Discover as examples, would indicate that somehow when an account holder has lost, or no longer has access to their own funds, that turns into a credit instrument. That's not the case at all. There are credit rails, think of them like train track rails that exist connecting banks to operators. And those rails are, Visa, MasterCard, Discover, Amex, but they might also be debit rails like Pulse, Nice, Star, etc. So there's different train tracks, and all that Visa logo on that debit card is saying is that you're eligible to not only go down the debit train tracks, but you can also go down those credit card train tracks too. It would still be a debit transaction. It's just using the Visa network in order to move that transaction forward. One other quick thing in terms of advice, I've heard other members suggesting that folks under 25 are at especially high risk, and that they could use credit instruments to cause themselves tremendous harm. Most financial institutions consider a gaming transaction to be a cash advance transaction. And anyone who looks at their credit limits, when you look at a credit card, there's a separate, much lower limit for those cash advance, transactions, both on an individual transaction level, but overall, your limit is not the full limit. And so by its very nature, the way financial institutions work as issuers of these credit instruments, there are much lower available balances to folks, and anyone who couldn't otherwise afford a large balance wouldn't be offered one. So you might see $5,000 overall credit limits, but that might only carry with it a $500 cash advance limit. So I think my best advice is lean in really carefully and closely with the experts and with those jurisdictions that have dealt with this issue for much longer.
Thank you. I think that's a fair suggestion. I do think we're going to struggle with this moving forward. And I think even the states that have leaned in on an earlier timeline than we have are struggling with it as well. It dominates conversations amongst legislators from gaming states. It dominates conversations at NCSL, the state legislators who are looking at the same data that this committee is looking at. Look, there are some realities, right? The overwhelming majority of people can game and game responsibly. They can game at physical locations or online in their pockets. They can engage in generally entertainment-based activities. Paul, are you okay? We had slight accident internal to the committee, or just making sure the individual's okay. That's okay. Sorry, I didn't mean to. So just I do think that what we're trying to do is get to a point where we're allowing the overwhelming majority of our state to game responsibly and utilize whatever tools and financial instruments they have in their possession to do so, but also recognize that there need to be some constraints in the deeply problematic behavior that we're also seeing a sharp uptick in. And so I want to have this relationship between you and I personally, but generally this committee and the industry, to determine how we accomplish both. We have incredible partners here in Connecticut. I have a question on an issue, I can easily turn to either of our tribal nation partners who are always forthcoming and honest and are continually working toward advancing safe gaming solutions for all of our residents. But there's going to be this constant tension while we're seeing the data that we're seeing. And I think that's where I'm not sufficiently satisfied that the testimony that we received in opposition to this bill recognizes the problem that we're confronting. And I'm hoping to work with my ranking member on getting something over the finish line this year that more clearly restricts access in ways that directly abut the problematic behaviors and evidence that we've seen so far to date. And I know that was more of a statement than a question, but I think it's a beg and a plead more than anything else to help us figure out an appropriate tool to constrain what we're confronting right now, which is this sharp and dramatic increase in problematic behaviors, generally amongst the younger population than we have confronted before, and we don't necessarily have the tools to reach and effectively market and keep out of dangerous situation. So I guess
I appreciate your comments, Representative Lamar, and I will just add, I share your concerns. Before I came into the payments world, I was a casino operator for many years, working across a number of large casino operators, including most recently MGM and Springfield, Mass. So I've seen great best practices, and my testimony today is really limited to what is possible within the financial ecosystem and technology sector. But I think, for a different issue earlier in the hearing, someone mentioned the idea of putting together a task force. And I think that would be a great next step to get the right advice and the right best practices together, as well as make sure they're all possible to actually implement, which this isn't. And we can certainly accomplish this goal together. Everyone I know in the gaming sector across, whether they're a payment provider or an operator or a technology provider and the like, we're all committed to reducing any problem gambling risk and only accepting good business.
I appreciate that. Thank you again.
Thank you. Representative Yacarino.
Real quick, thank you, Mr. Chair. Thank you for being here testifying. So WorldPay, you're a payment processing company and also facilitate payments. Is that accurate?
Yeah, we're the largest acquirer in the world. Yes.
And that would be through online gaming or just gaming in general?
So, yeah, Representative Yacarino, my company, WorldPay Gaming Solutions, which is a subsidiary of WorldPay, we focus on gaming and gambling specifically. We handle all the lottery payments or almost all the lottery payments throughout the US, online gaming payments, you know, a lot of the various Stage Digital wallet operators that you see also use us for their acquirer. So we're very well known and we have broad reach within the gaming sector. Our parent company, WorldPay, does payments of all variety across the world and moves trillions of dollars a year in total acquiring volume.
Yeah, I think I appreciate that. I think they're a credit card processing company also, if I'm not mistaken. So your recommendation, obviously you're fairly young, for young men and some women that are having problems with gambling, there's it's easy access to cash with WorldPay or anything else, and you can't legislate self-discipline. But do you have any safeguards in place that you could recommend?
So I've seen some great best practices from operators that I do recommend personally. For instance, folks having an opportunity to set budgets before they're in gaming sessions, right? And you're not sort of in the passion of gaming. But also, you know, we've seen some of the suggestions that have happened, including from yourself, potentially looking at only allowing credit card transactions, well, or not disallowing specifically credit card transactions, excuse me. We've seen that in other jurisdictions, right? So in Tennessee, in Iowa, you cannot use credit card transactions for any gaming activity. What we've also found is that there tend to be higher ancillary businesses that allow for cash advances to still take place, and then folks turn around and still game with those funds. And unfortunately, you lose the protections that come with using a credit card. So anyone in the payment space, and remember, we do debit, credit, ACH, all account to account. We're not just doing credit card processing, we're moving money in all manners and all digitally. But anyone who's actually in the space, none of us would use a debit card because we want to keep the protections of our chargeback rights and not have our own money at risk. And when there is something like account takeover or fraud or those sorts of things, I don't want my own dollars at risk. I want the financial institution who issued me my card to have their dollars at risk. And so there's tremendous trade-off that you lose when you're not able to use a credit instrument and you're forced into a debit card. It's the same reason why when you check into a hotel, you would never use a debit card because those funds are actually held from you and you lose access to them.
No, I appreciate that. I use my business credit card for the points and also security. But when it comes to gambling, you're really not going to go after DraftKings because you lost, because you just lost. So I wouldn't agree there with you, but I appreciate your time and we'll continue to listen. Thank you.
Great. Thank you very much. Are there any further questions? Okay, hearing none. Thank you for coming to testify before us today.
Thank you.
Next, Jennifer Hossain.
Good afternoon, it's Hossain. So, good afternoon, Senator Mahoney, he's not here, and members of the General Law Committee. My name is Jennifer Hossain, and I am a Connecticut content creator, influencer, co-owner of Two Hungry Gens, and I'm here to testify regarding Bill 5560. While I recognize the importance of maintaining integrity in online reviews, I do not support HB 5560 in its current form. Instead of unfairly restricting legitimate businesses and ethical content creators, the bill should focus on fraudulent actors who manipulate consumer trust through deceptive review practices. My concerns with HB 5560 are it fails to target actual fraudsters. The real problem is fake and deceptive reviews, those generated by fraudulent companies, review farms, or individuals who deliberately mislead consumers. This bill does not do enough to differentiate between ethical partnerships and bad faith actors. It can harm small businesses and ethical content creators. Many small businesses rely on honest partnerships with influencers and content creators to share real experiences about their products and services. Ethical creators always disclose partnerships, ensuring transparency. This bill, as written, lumps them in with fraudsters, which is unfair and could stifle legitimate marketing. It also risks overregulation without effective enforcement. If enforcement is not targeted as actual fraud, this bill could create unnecessary legal risks for businesses that operate in good faith. Meanwhile, bad actors will still find ways to manipulate the system, often from outside Connecticut's jurisdiction. A better approach would be, rather than a broad ban on compensated reviews, I urge the committee to target fraudulent review farms and deceptive practices directly, clarify the difference between ethical sponsored content and deceptive reviews, strengthen enforcement mechanisms against actual fraudsters, not honest businesses. This issue is important, but the bill must be rejected if not narrowed and focused to truly protect consumers without punishing ethical marketing practices. Thank you for your time and consideration.
Great. Thank you very much. Are there any questions? So I guess I have a few. One, we talked about before, and you kind of mentioned this, right, that ethical creators will disclose relationships. So would you be opposed if we just instead had a requirement to disclose if there was a paid relationship?
No, I mean, the FTC already has regulations. So if we said, use language as in, we were hosted by or in partnership with, I wouldn't be opposed to that.
Okay. And do you have any examples, I guess, or know of any states that have gone after you mentioned the fraudulent review farms?
I do not. I was very surprised by this bill. I'm disappointed Representative Elliott isn't here to kind of elaborate on where this arose from.
Okay.
All right.
Great. Yeah, if you find any, if you could share that with us, that would be great.
Absolutely.
Okay, thank you so much. Okay, next, Roxy from AdvoMed.
Hi, thank you. Good afternoon, Chair Maroney, Chair Lamar, and members of the committee. My name is Roxy Kazitsky. I'm Senior Director of State Affairs at AdvoMed, the MedTech Association. And I'm here representing AdvoMed as well as the Medical Device Manufacturers Association. Our membership comprises the full spectrum of health technology innovators and manufacturers who work every day to deliver high-quality healthcare for patients worldwide. And I'm here testifying on behalf of both MDMA and AdvoMed to express our concerns with the right to repair section in Senate Bill 3. While it appears that the intent of this proposal targets certain types of electronics, unfortunately, the definition of connected device manufacturer, and electronic set inadvertently loop in medical technology, especially what's used in home healthcare. So unless it's explicitly exempt, unfortunately, it is still included and looped into the bill. Last year, this committee heard this bill and the sponsors did agree to include a MedTech exemption. But as stated earlier, obviously the bill didn't, it did pass the Senate and then it didn't move forward. So I want to, before I go on, address Senator Duff's comments about some technical issue with Connecticut statute and including an exemption. I'm not aware of what that would be. We've not obviously run into that in other states. Minnesota, Oregon, Colorado, and New York all have broad right to repair laws with a MedTech exemption. Now, if the concern is you'd prefer to pass maybe what you'd call a clean bill or one that doesn't really have exemptions, we'd point you to California, where we don't have a medical device exemption because the law is written in such a way where it's scoped narrowly enough where we're not impacted. And actually the right to repair bill as written in Connecticut does kind of approach California's language, but unfortunately those three definitions I mentioned do loop in MedTech. And these products are ones, as I mentioned, are used by home care nurses, physical therapists, other healthcare providers, or the patients themselves. Obviously, you, me, everyone, patients and consumers rely on a technology's accuracy to provide proper diagnosis and maintain safety standards. If medical devices are not explicitly exempt or otherwise scoped out, patient safety is at risk. Unregulated providers lack the necessary training to repair complex FDA-regulated devices. While these tablets or other ancillary electronic devices are not made by a medical device manufacturer, they do become part of the product itself when it's approved as a medical device, and therefore it falls under legal ownership of that medical device manufacturer. So some examples of this kind of medical technology that would fall into the scope includes a portable ultrasound where the transducer is paired with a tablet used exclusively as part of the product, a patient-borne monitor with cell capability, implantable pacemakers or defibrillators that transmit device status information to clinicians via ancillary devices in the patient's home, portable X-ray devices that include a SIM card, and patient monitors that are connected to a central station in a hospital. Again, safety and security are really the paramount reasons that we oppose this provision. And it's what our members prioritize most to make sure they serve their patients. So we appreciate the committee's consideration of our concerns and happy to discuss the technicalities mentioned earlier by Senator Duff and how we can incorporate an exemption into the bill. Thank you.
Okay, great. Thank you very much. Are there any questions? So I'll look at the Minnesota language as well as I'm looking into the underlying the CUTPA statutes to see if the exemption is there. But I know industry typically prefers the belt and suspenders, even if it's listed in the CUTPA. I assume you would prefer to have it also explicitly listed in SP3.
And again, also the California's, again, if you are interested in a bill that does not have exemptions or does not have a medical device one, then the law in California is scoped or written in such a way that scopes us out. So we don't have one there.
Okay, great. Thank you.
Thank you.
All right, next, Michael Moran.
Good afternoon, co-chairs Maroney and Lamar, members of the committee. Thank you very much for affording me a few minutes this afternoon. I'm going to speak in opposition of the proposed bill 7182 with regard to ticketing. I would say that generally speaking, most members of this live performance space, the industry, are all in agreement that ticketing is broken and something needs to be done to fix it. I, for example, have a show coming up later this month, and I have two websites up in front of me. The show ticket is $20, and on my site, if you click buy ticket, it adds the $6.75 worth of fees, $26.75. I have another website up in front of me right now. That same ticket is $677.95. They do state that it includes the fees of $195.95. The second website has the single ticket price at $1,798, which does state includes all fees. This is a travesty that somebody can, and it's probably a speculative ticket sale. I'm going to guess that this reseller doesn't have the ticket in their hand. They're going to sell it on spec to a victim, if you will, who's going to purchase this ticket, not knowing that they can come to my website and buy that ticket for $26.75. Something needs to be done about that. I did not submit written testimony, but if there is a window of opportunity for me to do that, I would be happy to. I think one of the things that we need to include in any ticketing bill moving forward would ban speculative tickets. I think it's just an unfair practice and it should be banned. I think that there are providers, resellers out there that actually spoof my website so that you think you're on palacestanford.org, but you're not. And I think that needs to be addressed as well. I think we're doing pretty well with the transparency and pricing. I think most resellers are actually adding the language that fees are included, and that's a step in the right direction. I think that there should be some accountability for resellers. I am the president of a 501c6 professional trade organization, and we are a registered business in the state of Connecticut. I think that if you're going to resell tickets to a venue here in Connecticut, you should probably be registered as a business to do so in the state. I think that you should always refund for an invalid or canceled event. We do it without question. The event gets canceled. Our money is basically segregated. Ticket sale money doesn't get blended with operating funds. I don't own that money until I've delivered a show. So if the show doesn't happen, you get a refund. I think there should be a consumer protection portal for reporting potential violations. And then I think any bill has to list the enforcement agency and the penalties associated with the potential violations. Those are my comments on the ticketing side of things. It's not one size fits all. I don't have Celtic Laker tickets. I don't have Big East tickets. I'm not dealing in that space. I'm a 1,600 seat performing arts center in Stamford, Connecticut. The building's been here for 97 years. And I think we want to do right by our patrons. And I think that we're seeing those poor consumers come through the doors having been basically victimized by resellers at some level. Happy to answer any questions.
Great, thank you very much. If you could send in the written testimony, we can get that up online really at any time prior to the bill getting called. So please, on the floor of the House. So please submit your written, and then you did mention the deceptive domain or the spoofed domain, and we do have that in another bill as well. So thank you for taking the time to come testify to us today.
Terrific. Thank you all for what you do.
And next, Paul Pescatello.
So good afternoon. Thank you so much for allowing me this time to speak before you. Again, my name is Paul Pescatello. I'm senior counsel at the CBIA and executive director of its Bioscience Growth Council. I'm also chair of We Work for Health Connecticut. All those organizations are involved in growing the biotech community, which includes medical device, several medical device companies. I'm here today to respectfully speak in opposition to SB 3, an act concerning consumer protection and safety, specifically SB 3's right to repair provisions and the bill's lack of a clear, explicit exemption for medical devices. SB 3 appears to be focused on what most of us would consider items that fall into the category of consumer electronics. However, the definitions of connected device manufacturer, and electronic set in sections 2 and 3 of SB 3 could be construed to include medical device technology. These definitions would be applicable to an array of medical devices, including implantable pacemakers, implantable defibrillators, portable ultrasound components, patient-worn or implanted monitors, and portable radiology devices. All of these devices can have the capability to transmit critical information about a patient's health status to healthcare providers. SB 3 would place patients and users of medical devices at risk. Access to materials, parts, and tools is no substitute for the extensive training, education, and expertise possessed by original equipment manufacturers. Medical devices are complex. They're used to diagnose disease, save lives, sustain lives. OEMs allocate extensive resources to create comprehensive servicing protocols to ensure that their devices are properly maintained and consistently meet safety and effectiveness standards promulgated by the FDA. Service by original equipment manufacturers must adhere to strict FDA regulations for medical device maintenance and repair, known as quality system regulation. These FDA regulations include specific instruction for training, part and component replacement, and documentation of servicing, inspection, and repair work. In addition, OEMs and their authorized servicers are subject to additional FDA regulations that include reporting adverse events, recalls, and registration with the FDA. This regulatory framework covering post-sale events helps ensure that all servicing to medical devices is done by properly trained and equipped technicians. that all repair work is thoroughly documented and that adverse events are reported to the FDA. SB3 could facilitate the work of unregulated third-party servicers on complex medical devices, including, but very much not limited to, chemotherapy and insulin infusion pumps, ventilators, cardiac pacemakers, without proper training and potentially without appropriate repair equipment and replacement parts. I'll just sum up by saying I urge you to revise SB3 to include a clear exemption for medical devices similar to the exemptions provided in the Federal Fair Repair Act in several states, especially Minnesota, New York, and Oregon. I think that's been mentioned a couple of times here today. We'd be happy to work with you with providing that language.
Great, thank you. Are there any questions? Okay, hearing none. Thank you for coming to testify today.
Yeah, thanks so much.
Next, Rachel Baird. Yeah, online. Okay, next, Katie Riley. Okay, next, Robert Ward.
Thank you, co-chairs Maroney and Lamar, ranking members Ciccarella and Rutigliano, and members of the General Law Committee. I'm here on behalf of iDevelopment and Economic Association, which advocates for responsible internet gaming policies that spur economic growth and protect consumers. Our members represent the entire online gaming ecosystem, from operators to technology providers, giving us a 360-degree perspective on industry policies. We oppose HB 5269 for two key reasons. First, as you've heard a few times today, the bill's deposit approval requirement is impossible to implement. The bill would require all account holders to approve a deposit before wagering, but this is just not technologically possible within existing banking and payment systems. As you heard from WorldPay, operators and payment processors have no way to confirm multiple account holders or their approval at the time of the transaction in the payment system as it exists today. I wanted to point out a couple of unintended consequences that we think this bill would have if passed. First, it would force out trusted licensed payment processors that can't comply with this unworkable mandate. And in doing so, it would push consumers toward riskier and less transparent payment methods that lack security and oversight. The second reason that we oppose the bill is that its prohibitions on promotions would drive consumers towards illegal operators. The bill would prohibit promotional offers, which would significantly harm the regulated gaming industry in the state. Promotions are critical to the industry because consumers expect them. They're a standard part of legal regulated gaming. And without promotions, customers will turn to illegal offshore sites that still offer bonuses, but do not provide the same consumer protection, responsible gaming safeguards, or tax contributions as the regulated industry. The real competition is not between the legal operators, but between legal and illegal markets. So this too would have unintended consequences by handicapping licensed tax-paying operators, which would make them less competitive, all while strengthening the unregulated illegal sports books that exploit consumers without oversight. To summarize, this bill would not achieve its intended goals. Instead, it would impose impossible compliance burdens for payment processors and operators, push consumers towards riskier, unregulated gambling platforms, and undermine the legal tax-paying gaming industry. So for these reasons, we respectfully urge a no vote on HB 5269.
Great. Thank you very much. Are there any questions? Okay, hearing none. Thank you for coming to testify. Okay, next, Alice Horgan.
Good afternoon, co-chairs Maroney and Lamar, ranking members Ciccarella and Rutigliano, and distinguished members of the committee.
Fastest 3 minutes of the day.
Yeah. Thanks for the opportunity to comment on House Bill 6052. My name is Alice Horgan. I am the Northeast Government Affairs Manager at Sonova. We're one of the country's largest residential solar and storage providers, and we've been working in Connecticut since 2014. We've long been an advocate for strong consumer protections for solar customers. Last year, I worked with the committee in support of Senate Bill 297, and I was appointed by the Speaker's office to the Consumer Protection Task Force that was not convened. I want to thank the sponsors and committee's nuanced approach to increasing consumer protections in the state. Echoing what Sia and Trinity Solar and what Positron will say, we can't support the bill as written, but with the following changes, I think that we can align it with the implementation of this bill and support it. So for consumer education, it's critical for consumer protection. We support requiring contractors to provide a brochure to consumers about solar services and protections of the state. However, we believe that the Department of Consumer Protection should be the one that's developing that brochure in consultation with stakeholders, not individual solar sellers. That having too many different brochures floating around is not good for consumers. So we had some concerns regarding Section 3's requirement of a 10-day notification to municipalities for door-to-door sales. But after hearing what Representative Leineman, what her concept was for the provision, I think we'd like to work with her a little bit on refining that language so that we're not conflicting with municipalities' like existing abilities to issue canvassing permits, so we're not just flooding these towns with letters about when folks are coming to sale. Sonova believes that we need more clarification on what the solar seller relationship list is. As it's written, it kind of appears to require contractors to provide a list of virtually every employee of a lender, a manufacturer, an educational institution, an investor, or other firms that work with the contractor, which is sort of unwieldy, and I don't think that's quite the intent of the bill. So we'd like to work on that. And as mentioned in previous testimony, Section 5 needs to be refined in regard to the timelines laid out in the bill. We're in total agreement that a salesperson should be clear about who they represent, what the purpose of their visit, and respectful of what the consumer's requests are. However, we suggest that the 10-second references be removed and be replaced with promptly to more closely reflect the real life interaction as opposed to the telemarketing requirements for 30 seconds, which is the basis of that language. Sonova, we support the concept of creating a no-knock list, similar to the do not call list. We don't want to be knocking on doors to folks that don't want our product. But I do want to flag that the implementation of such a list could be challenging, would require a lot of work with the DCP to require the periodic updating of the list, making it free to access, and also an element of consumer education regarding the lag times. So when folks sign up for the no-knock list, understanding that might be however many weeks until the updated list is published that then, these door-to-door sellers would have access to. And then finally, echoing what Trinity said about some of the fining language, we support reducing the fine to $500 to align with the other provisions in the Home Solicitation Sales Act. Thank you for the time.
Thank you. And would you send, I guess, suggested language? You said, on the solar seller relationship list, that
Yes,
language to refine that.
Absolutely.
Okay, great. Thank you.
Thank you much.
All right. Are there any further questions? Seeing none. Next, Syed Rahman. Okay. Next, Kyle Wallace.
Right. Thank you, Chairs Lamar and Maroney, ranking members for Tigliano and Ciccarella, members of the committee. I'll be batting cleanup on this solar issue, so I'll try not to be as too redundant.
We've saved all the hard questions for you. So.
I know. All right, I'm ready. So I just wanted to first say that we appreciate the opportunity to talk about this really important subject. We're really invested in ensuring that this is done right. It's important for the long-term success of the industry, the confidence of consumers. And so we really want to engage and help craft something that is really meaningful and provides additional protections for solar consumers. As mentioned in our written testimony, we support the bill with some of the amendments that others have mentioned. I will note that we really like a lot of the things in this bill, the concepts of the no-knock list, the reporting of business relationships, the standardization and the brochure and handbook. I think those go hand in hand and are really important. And so I think there's a lot in here that is really good. And so I just want to express appreciation for the thoughtful perspective of the committee in this bill. I do want to just talk a little bit about the brochure and handbook, which I think is a really meaningful protection that would be new for Connecticut in the way that it's drafted in this bill, and I think would help address some of the concerns that were heard earlier with testimony of misleading marketing claims and things of that like. For example, if you have this brochure that has to be provided as part at the start of every sale that someone is trying to make, and on that presumably there would be things like saying, you know, beware of things like free solar, or, you know, you won't have a utility bill again. And if the consumer, you know, has this brochure and then they hear someone saying that, like that automatically raises a red flag. Alternatively, if a consumer gets multiple quotes like they should be getting for every home improvement contract or project, and 3 of the providers provide the required brochure and 1 doesn't, that sends another signal that, you know, that one may not be a reputable provider. So I think there's a lot of different benefits in addition to just having the good, consistent, and accurate information that can help reduce some of the information asymmetry, because solar is a unique product a lot of consumers haven't thought a lot about until they start looking into it. So I think that those are some really meaningful protections. Like others, we just think that those should be developed by DCP so that they're consistent every time with, we believe, collaboration from PURA, who sets the rules of the solar programs, and also from other interested stakeholders like the industry. As others have mentioned, the $20,000 penalty we believe should be lowered to $500 to align with Section 12 of the bill as drafted. And then we would also ask on specifically the knocking hours. We appreciate the 9 to 7. I think at least in the summer, we would ask for that to be 9 to 8 when it's lighter outside. We understand that there's seasonal differences in that, but that's, we believe is a fair window. So with that, we also have some other like little technical changes on like cleanup references on, for example, the definition of residential solar photovoltaic system references a different part of the statute that is limited to systems of up to 12 kilowatts, whereas the residential program in Connecticut is up to 25. So you would be missing out on technically those larger systems. So I'll happy to answer any questions.
Great, thank you. And you submitted your written testimony?
Yes, I did.
Okay. But I guess something to consider, right? You do, I mean, you bring up a good point, right? If you have multiple quotes, you could be getting the handbook from several sources. I'm wondering if we need to think of a way to work like with posting the information on the Energized CT website. So it could be, you know, providing a QR code or link would be suffice, but I need to think that through. But that is something that I guess could be a possibility.
Absolutely. I think that's a really good idea. I think these resources should be available on a variety of websites, probably DCP, probably on the utility websites for the solar programs, PURA's website, so that there is, no matter where the consumers go, they have access to that information. And I think that's a really good point to have it available.
Okay, great. All right. Thank you very much.
Thank you.
Okay. Next, Lawrence Queso.
Is still on.
I apologize. Please proceed.
Okay, thank you. And good afternoon, and thank you very much for allowing me this opportunity to talk about an issue that has become increasingly a concern to myself at the Klein and also to our entire industry. First, about the Klein, we are a 1,437-seat performing arts center serving the greater Bridgeport region. We are proudly celebrating our 85th anniversary year, and we are one of 7 theaters in Connecticut still having a Broadway-sized stage. I am here to support FHB 7182 because I think it is a major step in the right direction. There are some modifications I'd like to propose based on personal experience. But overall, the whole concept of reselling tickets is, to me, offensive. Running a theater, I don't need a reseller. I pay a contract and ticket fees to be able to sell through my website. And I don't need somebody else coming in and particularly charging 25% more. If I have a concert that earns 25% profit, you could consider me a lucky dog and you'd hear me start barking. I don't think we should reward bad actors. Secondly, the way they work is they pay sponsored ads on the search engines. And that gives them advanced placement at the top of the search engine, well above that of the client. So the consumer would have to scroll through 4 or 5 entries before they'd even find our website. And the ticket prices posted on this, which although they do say we are resellers and prices may be higher or lower than the face value, in 8 months of research on this, I haven't found one that was selling our tickets at less than the face value. And we have a chorus line this week for 5 performances. It's a flat price of $40 and it's currently selling for $195. I don't think it's right that anybody could display our seating chart on an unauthorized website. I would like to see that added to the thing. I think that would cut this down greatly. Now, maybe there are in the sporting world and in big stadiums, maybe people are buying blocks of tickets and reselling them. It certainly is not happening at the Klein. I'm aware of every sale. That's how I tripped into this practice. But if they are, consider the ramifications. Somebody buys 100 tickets, maybe they don't sell all of them. We're then out the ability to sell those tickets, and that means we're out concession sales, parking fees, and by the way, both of those we pay a sales tax to the state on. So if we have fewer people because of these malpractices, the state's going to lose out. Okay.
Thank you so much for your testimony today. Are there questions? Representative Ritigliano.
Thank you. I just came in, so I missed the beginning part, but I am totally sympathetic to what you're talking about. It is fascinating that when I search for a show that I want to see or a venue, the top 3 are some variation of the venue, and they're all fake sites. But you said the one thing I found interesting was 2 things, really. One, you said that there shouldn't be an aftermarket. I think we're maybe, I'm for full disclosure on tickets, and I'm against the practices that people do to you by having your seating chart and everything. That's going to be another one of my questions but I do think if I buy a ticket that I should be allowed to do whatever I want with it. Would you agree with that? Like if I feel like selling it for $5 or twice what I paid for it and somebody's willing to pay for it, do I have the right to do that?
Yes, you do. That's why eBay exists. But this isn't that kind of thing where Aunt Sophie slipped and broke her hip and we can't come. What I'm protesting is the people who are doing this as a business. And it's no longer the guy standing outside the stadium in a raincoat with a fistful of tickets to sell. This is a very sophisticated bot thing. And I think everything's in the extremes. However you could word it that could allow the first thing of the Aunt Sophie is fine with me. But when it's big blocks of tickets or people who are preempting our sales by selling on their sites, that has to be curbed.
So I appreciate that. And I would agree with you, actually. I think I have a personal right to sell whatever I buy. And I also would agree that it's unfair what all these other people are doing. But when you say the word preemptive, but don't they actually have to pay for? Oh, wait a minute. Are they just listing the tickets for sale at a higher price, and then after somebody buys them on their site, they run and grab them from your site?
Exactly right. And let me explain how I found this out. Last August, we did a concert with a jazz musician named Gerald Albright. One of my board members was a big fan, and she was in a board meeting with me, and she took out her cell phone and she bought a ticket to the concert. And she turned to me and said, "That was awfully expensive." And I said, "What did you pay?" And she said, "It was $109. She bought a $24 ticket. Seconds later on my cell phone, I got the confirmation order. And it was not her name. It was a made-up name at a fictional address in California. And I recognized that address as having been on a number of other orders. At the time, I thought Gerald is from the West Coast, might have had relatives or an entourage who were buying tickets. But all of a sudden I realized these are all fake names. So I started Xeroxing. This file is every bogus order we've had at the Klein since August. It's 231 tickets.
So when you say bogus, the ticket eventually got purchased from you, but
They do.
it was just
We get
for
the ticket revenue, but we get no benefit of knowing who bought the ticket. I have no way of informing them if there's a cancellation because I don't have their accurate email address. And,
Do you want to go? Oh.
and it's causing great distrust. Now, at the Gerald Albright concert, to start to curb this, I made an announcement from the stage. I said, our ushers are going to come to a number of you tonight and ask you if you will please come and meet with me in the box office after the concert.
Right.
And I wrote out the seat numbers of every ticket that had this. It was 18 tickets. They all came to the box office. Every one of them were shocked. They were shocked to find out what the face price was versus what they had paid. And more importantly, every one of them admitted to me they were sure they were on the Klein website when they bought the ticket.
Yeah, I would agree with that. And it's happened to me in the past, most notably at the Bushnell here in Hartford. There's somebody that has a name that's so close to theirs, it looks just like it's very confusing. So I think I got what I needed from my question. My question was, do I have the right, which you support, my right to do whatever I want with my ticket? But maybe there is some sort of process or something we should do about this deceptive, if you want to call it that, interruption of your business. So I appreciate it. Good luck to you. Good luck at the Klein. Do you have anything good coming up that in the spring?
Well, we have Chorus Line, but we're putting together our whole fall schedule right now. But we have a craft beer festival celebrating Connecticut breweries
There you go.
on July 26th, and a big 85th anniversary concert with a major name who I'm not ready to announce right now, but it'll be huge on November 1st.
Well, good luck to you, and thank you for your time, sir.
Thank you.
If the festival needs any guest judges, I think Representative Tigliano and I could like sacrifice that day for you. That's right. Representative Yacarino.
I'll be very brief, Mr. Chair. Thank you for your testimony. It happened to me about 2.5 years ago at the Radio City Music Hall. I buy tickets for my wife. You know, she was never at the show. I was there with my mom years ago. Excited we get in line. They don't have my name. I paid a lot of money, more than I should have paid. But I went to somehow somebody was really helpful. I went to a different ticket box and I had to give my ID and I had to give all the transactions and they had it under another name, but they saw my credit card. You know, I had to show up my ID, my credit card. If I didn't navigate through that, we couldn't have seen the show.
Mhm.
And that was really disturbing.
Yeah,
And, you know, that happens probably more than you want that to happen to.
it does. I haven't seen it where people have shown up and we don't have their ticket, but it could happen.
They
through
did it
this
a different, the company's name, not my name.
Yeah.
And that was the problem.
Yeah.
But I appreciate testifying. I don't want to take any more time, but thank you.
Are there any other questions? Seeing none, thank you so much for
All right.
testimony today
Thank
and joining on this. All right, so that's the end of the day for us. Chris Herb, you were signed up late coming in, so we've scheduled the entire afternoon just waiting for you to join us. I'm glad you sat through so many.
Lateness should not be rewarded, Mr. Chair.
Lateness should not be rewarded, but you get prime attention now.
Hopefully I don't disappoint. My name is Chris Herb. I'm the president of the Connecticut Energy Marketers Association, and we appreciate this opportunity to testify today. I don't normally say that. We represent 600 family-owned heating oil and propane retailers throughout the state, and our motor fuel members own, operate, and distribute gasoline to over 1,000 locations. We're here today in opposition to Section 6 of Senate Bill 3, which contains language that vastly expands the AG's powers under the profiteering statutes and also has undefined terms that would make him judge, jury, and executioner. I testified on a very similar bill earlier this year. And so I'll just cut to the chase on what's really wrong here. First of all, we have a current statute that works very effectively, that provides clear limits within the law on how to price our products. That law has been effective since 2010. It was in this committee. We worked with that leadership at the time, and it passed the General Assembly, and it's proven to protect consumers immensely. This bill brings us back to what I call the dark days of the profiteering statutes, where we have undefined terms like unconscionably excessive. And the reason why that doesn't work, and the example that I've given to the legislature in the past, is that when I drive to work every day, or if I drive to church or the grocery store, the speed limit is clearly posted. I know exactly how fast I can go. And if I go over it, I know that I could be pulled over and cited for it. if these undefined terms that are contained within this bill and within 6856 are passed into law, we end up going back to a time where retailers do not know what they do. And that's what I mean by judge, jury, and executioner. Although this bill does provide some language that says when an abnormal market disruption will occur, it then removes any protections on what you can do during that declared disruption. The President of the United States and the governor can currently declare emergencies where these profiteering statutes are triggered. And within those, I believe if the Attorney General felt that we needed to be in one of those situations where he needed to be able to utilize his powers under those statutes, that he should work with the governor to do it. There is an avenue in which the profiteering statutes can be used to protect people against, I see the words diapers and hand sanitizer and roof rakes and all the things that the legislature has been concerned of. There are ways to be able to get there, but the Attorney General would have to work with the governor. We're comfortable with that. We think that this bill is sends us back quite a ways, and I don't even know how it works with the bill that you passed earlier today. So I would just say that, you know, we didn't bring out all the gasoline dealers today and heating oil dealers to ask you for this because you heard from them earlier in the year. But I would say that that this language should be removed from the bill. It does not serve consumers and it does not help small family-owned businesses that I represent.
Thank you, and I appreciate that. And I do think we recognize that as a committee. We took some approaches earlier today in the bill that we passed out, reflective of your concerns and comments. I don't know that we got all the way there, but we did incorporate a lot of that thinking into the original JFS language that we passed in 6856. We'll look at this as part of SB3 as well. I do think you've made your point clear to us, and we need to continue to evolve that section specifically.
Thank you.
And you can tell the fine Forbes family, they don't need to come up and testify. We got them. Representative Pillil and I got them. Representative Vitigliano.
Just super quick, do you consider yourself or your members retailers? Because at one of the bills it exempted retailers. So, but I think they were referring to like supermarkets and whatnot in the AG's bill. I just didn't know if you thought you would be exempted under that sort of language.
No, our interpretation is we were pulled into it. So we are definitely retailers. We represent the entire supply chain. But technically the vast majority of our members are retailers on the street that sell to the end user, the consumer, the person.
So you wouldn't be exempted is what you're saying,
we
even though they exempted sort of like a supermarket, but they didn't exempt the manufacturer or the distributor.
Yes, exactly. We do not believe that we are
Okay,
exempted.
fair enough. Thank you.
Our members play multiple roles. So you could be a distributor and a retailer at the same time. So we believe we're still exposed to this.
Thank you, sir.
So do the supermarkets. Are there any other questions for Mr. Herb? Seeing none, thank you so much for your testimony today. That concludes our public hearing sign-up sheet. Is there anyone here today who wished to testify who was not afforded the opportunity or who was missed earlier in the afternoon? Seeing none, that concludes our public hearing testimony. We will, in just a minute, we will reconvene our committee meeting for the purpose of collecting votes.
Mr. Chairman, and that votes will be open till 4?
Votes will remain open in room 3500 and in the committee and on Zoom until 4 p.m. Thank you. We now reconvene the General Law Committee meeting from earlier this morning. We'll stand in recess for the purpose of collecting votes in room 3500 or via Zoom until 4 p.m., at which time the meeting will be adjourned. Thank you all.